Chief Justice, Honorable Mr. Justice. ನಮಸ್ಕಾರ.
ಅದೇ ಎಕ್ಸಿಬಿಷನ್ ಹಾಕೋರು, ಅದಕ್ಕೆ ಇದೊಂದು ಮೆಮೊ ಇರಲಿ, ಅದ್ರ ಪುಟ ಮಾಡೋದೇ ಇಲ್ಲ, ಪೂರ್ತಿನೂ ಮಾಡಲ್ಲ. ಅದೇ ಎಫ್ಆರ್ ನಂಬರ್ ಇದೆ,
21 ಕೊಟ್ಟು ಅಂತೀರಿ. ಮನ್ಮಥರ ಕೊಟ್ಟು ಇಷ್ಟೇ ಕೊಟ್ಟು ನೋಡಿ.
ಅದೇ ಆಗ್ಬೇಕು. ಅದು ಈಗ ಹೋಗ್ತೀವಿ, ಮಗು ಕಳಿಸ್ತೀನಿ ಅಲ್ಲಿಗೆ. ಹಾ, ಇವಾಗಲೇ ಮಾಡಿಸ್ತೀನಿ.
ಏನ್ ಪ್ರಸನ್ನ ಸರ್? ಮೇಡಮ್, ಬಂದ್ಮೇಲೆ ಕೊಡೋದ ಮೆಮೊ? ನಾನೆಲ್ಲ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿತ್ತು. ರಿಓಪನಿಂಗ್ ದಿನ ಬಂದಿತ್ತು, ಮೇಡಮ್ ರಜೆ ಇದ್ರು, ಬರ್ಲೇ ಇಲ್ಲ. ಆಮೇಲೆ
ಹೊರತು ಬಿಡಿ, ಅವ್ರಿಗೆ ಬರಲ್ಲ.
ಲಂಡನ್ದ ಅದು?
ಲಂಡನ್ ಮಗ,
ಮೊಮ್ಮಗ ಲಂಡನ್.
ಫೋನು ಇಲ್ಲಿಂದ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಂಗಿಲ್ವಾ ಮೇಡಮ್? ಮೇಡಮ್ ಫ್ರೆಶ್ ಕೊಡ್ಬೋದಾ? ಪೆಂಡಿಂಗ್ ಅಂತ ಬರೀರಿ ಮೇಡಮ್, ಮೇಲ್ಗಡೆ ಅಷ್ಟೇ. ಪೆಂಡಿಂಗ್ ಅಂತ ಬರೆದ್ರೆ ಆಯ್ತು ಮೇಡಮ್. ಡೆಫಿನೆಟ್ ಆಗಿ ಅಲ್ಲ ಮೇಡಮ್, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬರೀಬೇಕಾ? ಫ್ರೆಶ್ ಅಂತ ಬರೀಬೇಕಾ? ಹೌದು, ಪೆಂಡಿಂಗ್ ಅದು ಬರ್ದಿರೋದವರು. ಏನು ಮಿಸ್ಟೇಕ್ ಬಿಫೋರ್ ಕೋರ್ಟ್ ಅಂತ ಬರೀರಿ. ಅಷ್ಟು ಹೇಳ್ಬೇಡಿ, ಬೆಳಿಗ್ಗೆ 11 ಗಂಟೆ ಆಗಿ ನೀವು ಹೇಳ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕಾ? ಹಾಂ, ಕೇಸ್ ವಿಲ್ ಬಿ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ ಬರೀರಿ. ಯಾರು? ಇಲ್ಲ ನರ್ಸಪ್ಪ ಇಲ್ಲ
ಅದು ಕೊಟ್ಬಿಡಮ್ಮ, ಅದು ವಿತ್ಡ್ರಾ ಇಲ್ಲ. ಆಯ್ತು. Lord's kind permission.
All memos to the court officer.
One pending matter.
All memos to the court officer, whatever it is.
Directed to be listed today.
Huh?
It was directed to be listed today. I filed an application for vacating of the interim order. It's emergency.
No, that's what I'm saying. If you give the memo, I'll see why it is not listed when it is supposed to be listed.
Please. Great.
Yes. Call the list.
Page wise adjournment, list 1, page number 2, cell number 3 to 9, page number 3, cell number 10 to 12, list number 2, page number 4, cell number 13 to 13, 14, page number 5, cell number 15.
To serial number 1, we have mentioned, inform to the other side as well.
What you have called now?
Cell number 13 to 12 and 12 to 14, list number 2, cell number, page number 4.
Lord, arguing counsel is not in town.
Which case?
Serial number 1 of list 2. Lord, if tomorrow or any other date of this week it can be given.
Because there was no representation on the last occasion, it is posted for dismissal. Why the dismissal matters to be adjourned?
Lord, I'm the proxy counsel. The arguing counsel is not in town. Tomorrow it may be listed. Tomorrow or day after tomorrow.
Have you informed the other side?
We have informed.
Does this matter tomorrow under the same caption? Yes.
Page number 5, cell number 15 to 19, page number 6, 20 to 27, list number 3, page wise adjournment, page 2.
My lords, list 2.
My lord,
My lords,
list
list
number
2, serial number 17, my lords. I appear for the petitioner in this matter.
Yes.
I seek an adjournment, my lords. The arguing counsel is, there's some inconvenience today, my lords.
Have you informed the counsel for the respondent?
Yes, my lords, my office has informed.
When counsel for the petitioner seeks time, it is submitted that the same is informed to the counsel for the respondent. Does this matter?
My lords, interim order to be extended.
Does this matter on 26th of November? Interim order earlier granted is extended till then.
my lord, list 3,
Yes.
serial number 6. Mediation is going on. 2 weeks time may be given in this.
What is happening?
Mediation is going on to settle the matter. So
Go
2
for the
weeks.
petitioner.
Yes, my lord.
Where is the respondent?
Notice is not yet issued.
Without issuing a notice, mediation is going on.
Trial court
No,
pending
no,
is
no.
there, my lord.
I'll not. We will issue notice. I'll hear if there is any point or else I'll dismiss it. Yes.
Page
Lordship,
number
serial number 7, list 3. Request for a short accommodation since arguing counsel has some personal inconvenience. We are for the respondents.
At the request of land counsel to the respondent. Does this matter? Have you informed the petitioner?
I'll inform them, your lordship.
No, I will. You have to inform and then make a mention. Then we wait for the turn. Yes.
Page number 3, serial number 10, list number 4, page wise adjournment, page number 3, serial number 11, page number 4, serial number 12 to 16, page number 5, 17 to 21,
Madam,
page number
list number 4, serial number 2.
Serial number?
12.
Yes.
Kindly pass over it, sir.
Kindly?
Pass over.
Can you ask for a passover while the matter of
adjournment,
the,
sir.
yes, call the list.
Page
lord,
number,
serial number.
page number 5, serial number 17 to 21, page number 6, serial number 22 to 27.
My lordship, serial number 23, my lordship. I placed for a 1 week time, my lordship. Today I was filed in Wakalat, my lordship. My Wakalat is not yet put up, my lordship.
We'll see. Yes,
Page number
Inform to
7,
other side, my lordship.
we'll see.
page number 7, serial number 28 to 32, page number 8, serial number 33 to 38, page number 9, serial number 39 to 43, page number 10, 44 to 48,
46, your lordship. There is no appeal filed by the company. Yesterday, our lordship already dictated. We satisfied the award also. Can lordship can.
I'll dictate the order when it
You already
comes.
dictated, your lordship. Yesterday. Actually,
It
you
is not
already
concluded
did. For the
completely.
clarification, your lordship.
I understood. Let it come. I'll complete it. Yes.
Because I informed.
Number
Yes.
1 for orders matter.
One
My lord.
mention, my lord. One mention, my lord. List 2, serial number 17.
Please wait. Let us complete all
The arguing council's son's hospitalized, my lord. That's the only.
at 2:30. List 2.
Serial number 17, my lord.
Hmm.
The arguing council's son's taken a fall, so is taken into the hospital. The arguing council's son has taken a fall, my lord, is taken into the hospital. Some inconvenience today, my lord, any date may be fixed.
2611, it is already obtained.
17. List number 2.
List number 2, serial number 17, 2611.
My lords, I am for the respondent in this case, my lord. Short date to be given, my lords, regarding surfacing matter it is.
Which case?
Respondent, my lords. Respondent 1, for the same matter. List 2, serial number 17.
So already it is adjourned. What is that you want?
In adjournment, they have said that they have informed the respondent, but they have not informed the respondent. A short accommodation to be. We have not received any mail or message, my lord.
Anyhow, she says some personal difficulty
Yes,
to the
yes.
council.
Short date to be given.
Yes, this is matter on 19th of November.
My lords, one thing, my lord. We have filed a memo earlier, my lords. The date has been given to 10/11, but the DRT has kept for orders on 31st, my lord. Kindly, my lords, petition will be informed.
It's already given 30th. You didn't even verify from the court officer what has happened to the memo, and you make a
The
mention.
date has been given on.
Earlier it was 10/11. Again, you gave a memo yesterday. I read the memo and gave the date as 29th or 30th.
My lord.
Yesterday they have given another memo. Please look into it. I've given the date as 30th. One day before that.
A humble mention, my lord.
I inquired it morning.
Huh?
I inquired the state officer morning. They said that 10 only, so I made a submission again.
Yesterday you have given memo, isn't it?
Yes,
I've
ma'am.
seen that. Then one day before 30, I think on 30th they've given the date.
Oblige, my lords.
Humble mention, my lord.
All the memos, keep it in a file and give it to them. Let them verify. Then don't review it. Let them look at the book. Huh? So why it should be taken now? Today why it should be taken? Today is 28. You please give the slip. No, none of the matters are urgent to be taken up at end of the list or at 2. You give the memo. I will see. I will assign the date. Yes.
Lord.
Oh, the list is already.
Humble mention, my lord. Writ petition pertaining to surfacing matter. I appear for bank, my lord. The writ petition, they have challenged only the sale notice. The writ petition has turned infructuous. However, there is a benefit of interim order. The entire surfacing proceedings have come at halt, my lord. Anytime.
Why it is exceptional your case that we should make a mention when I'm specifically saying give the memo? Please give the memo.
Please.
And you all of you know that every memo a date is assigned basing on the urgency. In spite of me telling every day this is what is going on. Again, everybody wants to mention. That doesn't make any difference. Whatever is the urgency, if you write, I can read. Yes, call the list.
Lordship.
List number 1 for orders matter, sale number 1.
Appeal number 7 I've informed.
No, I can't go back again. Please wait. Yes.
Sale number 1, Chandrasekhar for petitioner.
Appealing for respondent in this case.
Why you don't rectify the office objections?
The respondent may not find a statement of objection to the petition. That may not, without there being any signature, probably they may have filed.
Like senior said last occasion before court only assigned that. That's what instruction is there.
Give it to her. We will not consider this objection. You argue the matter.
Yes.
Yes, argue.
Not the lordship may take not the order passed by the family court in granting the interim intelligence.
Where is that?
Section G, page 41. In this may not during the pendency of the divorce proceeding, not the application case to be filed by the wife, seeking may not for maintenance of rupees 20,000 per month and the litigation. We find an objection, may not contesting this. The learned family court, my lord, was pleased to allow the interim maintenance. Lord, by
So what
finding-
is wrong with this order?
Lord, it is an exorbitant. He is a
What is your
tailor.
income?
Lord, he is a tailor, my lord, it is a seasonal one. Nowadays, my lord, because of the garment business.
You must have filed your
Lord,
statement of assets and liabilities. You must have stated what is your income.
That, my lord, in fact, my lord, by cloak, my lord, they mentioned, my lord, 40,000 rupees expenses. He had, my lord, the parents. He has to take care of.
First of all, please answer to the court's query first. I said you have filed, when you have filed your statement of assets and liabilities, what is your income as per that?
Lord, in fact, my lord, it is a transferred brief to my colleague. Lord, he could not able to secure that assets and liabilities, the statement. I will get that, my lord, and I will produce it. But even assuming for a moment, a tailor.
Nothing to assume. We have to look at the facts. We don't assume things. Is earning, it must have been recorded in the order. Please come to the order.
Page 41, annexure G.
Petitioner in his affidavit of assets and liabilities has stated that his education qualification SSC, his general monthly expenses are 40,000. His income, he is incurring around 20,000 per month towards his parents. And the respondent has no occupation and has no income. So you require 40,000 per month for your expenses, 20,000 for your parents, that is 60,000. So how much you are earning?
But how much, my lord, the tailoring, my lord, he can.
That the court can't say, it's for you to say, that's what you said. Are you 40,000? No, you said 40,000 you are spending per month, 20,000 to the parents, 40,000 for yourself, that's 60,000. Court has rightly granted 15,000 to the.
The lordship kindly appreciate the thing. My lord, without any reasonable cause, she herself deserted. Even right now, my lord, I am ready to take her. A tailoring who is, my lord, his occupation is a tailoring. Not, he cannot be expected every month is the same income. It varies, my lord, from festival to festival, season to season. Lord, it is an exorbitant 10,000, my lord, it could be reasonable, my submission.
When you spend 20,000 for your parents, why not 15,000 to the
Varies,
wife?
It varies.
Huh?
It varies. Income varies. It is not a fixed income tailoring.
Who asked you to tell all this to the court?
Probably not.
No, probably. What you have stated before the court, you have to consider it.
Whether it is true or not, my lord, I have to verify, my lord, I will get the.
It is from the order. You cannot say what is stated in the order is wrong.
No, I cannot say. I cannot say what is the explanation offered in the affidavit for showing the assets and liabilities, my lord. That, my lord, she suppressed the fact that, my lord, she is not a gainfully employed. She is an employed. Lord, she was working as a P1 in the bank. Lord, that, my lord, she suppressed.
What is the material before the court?
Lord, annexure D, my lord, page 34. It is in Kannada, but my lord, the bank has issued an endorsement stating that, my lord, she was gainfully employed and she was earning a salary.
Milord,
Bank statement, my lord, the lordship can-
Milord, I'm a proxy counsel. My senior has instructed only that.
Tell your senior that I'm going to allow this petition.
No, Milord, kindly pass over. I'll ask the senior to come and argue the matter.
In her application, she is nothing as.
By the next date of hearing, land counsel for the petitioner shall place before this court the statement of assets and liabilities that are filed before the court. It is the contention of the counsel of the petitioner that the wife is gainfully employed. He has filed a communication is given by the bank. The respondent shall file an affidavit whether she is employed or not, whether she is, if she is employed, what is the salary. This is matter on 20th of November. Yes.
Serial number 2.
And by the time, the office objection shall be complied with by the respondent.
Serial number 2. Nirmala K.
What is this non-filing of Form A and B?
Because I'm not a party, I have filed the Makarata today. And therefore filing of Form A and B, that is for party in person, has to file. I have filed Makarata today. And they have not furnished copies to me till now. though they appeared before court at the last occasion and made some.
When you're not appearing, where is the question of giving papers to you?
No, last occasion they appeared before court. They made a submission before the court saying that we have filed this petition. Is it not the duty of them to furnish copies to me, my lord?
How will they know that you are appearing?
No, they were present. I was also present. This matter is coming up past nearly one and a half years,
What is your name?
N.N. Rogers, my lord.
Where is the counsel?
Opposite counsel is not present today, my lord.
It is submitted with the respondent that he wants to appear as a party in person. He shall appear before the committee. List this matter along with so and so. There was no direction to issue serve papers on you by this court.
No, this enhancement.
It is submitted that in WP 23345, Mr. N.N. Raju, yours has filed his wakalat today. Learned counsel for the petition shall serve the copy of the writ petition on the counsel. List this matter on 20th November.
Hearing on interlocutor applications.
No representation on behalf of the petitioner in WP 23345. Yes.
Cell number 3.
My lord, I appear for the petitioner in this matter. My lord, this.
Yes.
Yes, my lord. I am for the petitioner in this matter. The petition has been filed, my lord, against an order passed by the Honorable Trial Court against dismissing an application I had filed seeking visitation rights of my daughter, my lord, under the Guardianship in Wards Act. My lord, if your lordship may take page number 96 of my petition. This is the interim application that I had filed, my lord, IA number 6, wherein I had sought for visitation rights of my daughter, my lord. Earlier, my lord, in an application that I had filed seeking interim custody of my daughter. Yes,
What is the stage of this? What is the stage of this DNWC?
My lord, the DNWC is pending for leading petitioner's evidence, my lord.
Which court is this?
This is before the 9th Additional District and Sessions Judge, Bangalore Rural District, my lord.
9th Additional.
My lord.
Rural. We'll ask the court to dispose of your the GNWC itself. Now the question of considering the interlocutory application does not arise.
My lord, as of now, my lord, what had happened was when this application was being heard by the Honorable Trial Court, there was an interim arrangement that had been agreed for, wherein certain visitation rights had been granted to the petitioner, my lord, and that was being continued as such. And presently, my lord, the petitioner as well as the respondent, who is the wife of the petitioner, they're negotiating for settling the matter altogether, my lord. And therefore, we are hopeful that probably in the next month, we should be able to reach some kind of settlement. As of now, my lord, the petitioner is being allowed to visit the child, and the child is also quite happy with the petitioner visiting her. So that arrangement is being continued as such, my lord, presently. So our endeavor right
What
now
is that arrangement? What is that arrangement now?
My lord, the arrangement now is that
Ask him to come. Ask him to come and rectify. Password.
Cell number 4. Cell number 4.
Give that.
Please, my lord. In a husband's petition for divorce, the wife's application seeking recall to file.
I'm not able to understand why a memo is moved for a fresh matter.
My lord, that was moved on the day of reopening, my lord.
No, why?
There was urgency because the trial court matter was posted, my lord.
No, fresh matters will come. It's a general direction. Unnecessarily advocates are burdening the court with the memos. Because every memo you give, I have to see. So please don't give any memos of fresh matters because general direction that all fresh matters, if the office objections are complied, have to be listed.
My apologies, my lord. We'll make a
Yes,
note
where
of
is
this.
impugned order?
My lord, impugned order at page 26.
20?
26, my lord.
Yes.
May I read out, my lord? The petitioner is absent, the respondent is present.
Who are you? Wife or the husband?
Husband, that is the petitioner in the trial court. My lord, paragraph 3, my lord, the respondent side have filed IA number 4 and 5, both under section 151 of CPC, seeking permitting them to file their side objection statement to the main petition. Now the case is posted for argument. However, it is necessary to afford maximum opportunities to the parties. Hence, IAs filed herein are allowed and the objection statement to the main petition from the respondent side is taken on record. The respondent side have filed their side objection with counterclaim seeking restitution of conjugal rights. The respondent side have filed IA number 6 under section 151 of CPC seeking deletion of allegations. For rejoinder, if any, from the petitioner's side to the counterclaim and the objection to IA number 6 by 28/2025.
Where is this IA number, this affidavit in IA number 4
My
and
lord,
5?
the relevant portion is at page 35, my lord. May I read out?
When she entered appearance?
My lord, she has entered appearance on 9th February 2024. 9th February, 9/2/2024.
Where are the proceedings? Where is the proceeding sheet?
My lord, at page 29. Page 29 on the left-hand side, my lord. Advocate for, on the date 9/2/2024, advocate for the petitioner is present. Srimati B.S. advocate undertakes to appear for respondent. Both the parties are directed to appear before BMC, Bangalore Mediation Center on 14/2/24. Await mediation report by 15/4. Now coming to next page, my lord, on the right-hand side, page 30, that is on 15 till 27/6, the mediation goes on and then it fails, my lord. On 27th June, the mediation report is received as not settled. That has been recorded on the right-hand side. Now, my lord, on 2nd July 2024, the order is recorded on the right-hand side, my lord. The petitioner is absent, the respondent is present. Srimati SM advocate has filed wakalat for the respondent along with IA number 2 under section 13 of the Family Courts Act. The IA is filed, is allowed and the respondent is permitted to engage the services of a legal practitioner. The failed mediation report has been received. For objection statement to the main petition from the respondent side, call on 3/9/2024. Now, my lord, going to the next date, that is 3/9/2024. Both the petitioner and the respondent are absent. Both side counsel are present. For objection statement to the main petition from the respondent side, finally, call on 5/11.
So.
Again, my lord, on
No,
5/11 and
after,
11/12.
After that order is passed as objections taken as nil, this was
Yes, my
on 29/1/25.
Please, my lord.
After that, the matter has come up only once. That is on 19/3.
No, my lord. 4 times after that, my lord.
No. 29/10. Look at it at page 31 bottom.
Yes, please, my lord. 29.
Both the parties and the respondent both say present. The objection statement to the main petition from the respondent is taken as not filed. This is on 29/1.
Please, my lord.
So after 29/1, the matter has come up on 19/3. That's
19/3.
And next is immediately this IA is filed.
No, my lord. 11/6, there was another date.
But still, no, if the matter is adjudicated on the merits of it, you will also, there will be a finality to the litigation. Why do you unnecessarily, why do you want to, no, something will be, some order is passed. Again, if the appeal comes, again, the order will be set aside. Unnecessary waste of time.
My lord, I acknowledge that, my lord, but the issue is that, my lord, the reason she has stated, and this basically, my lord, this IA is filed only to ensure that the proceedings are dragged because she has been present from the stage of mediation. She has participated in mediation. She has been served with a copy of the evidence and exhibits. That is also recorded. Only after she receives the copy of the exhibits, she come up with the
unnecessary adjournment shall not be granted.
My lord, a direction may be issued, my lord. 3 months for conclusion.
No. MC is of the year. Which court is this? 6th additional principal.
6th additional, my lord. But 6th additional and the matter is 2025. My lord, if I'm not going in depth into the merits of the matter, there was a PDF which was released by the ex-boyfriend of the respondent, and that was made public
Actually,
everywhere.
not necessary that you should go into the merits of the matter, because I'm not
Please, my
deciding
lord, I'm
anything.
not going into the merits at all.
So
But
if you want adjudication on merits of it, without the objection, it is not possible.
my lord, she has even filed a counterclaim seeking for restitution of conjugal rights. Now, my lord, this is only a desperate attempt to drag the matter because she has not been cooperative in mediation, and even from day one, my lord, she has been present throughout the proceedings. It is not that she was not unaware of the proceedings. She's even been served a
If you want
copy.
costs to be imposed only on that ground, I'll issue notice.
My lord, cost is
Otherwise,
not a concern, my lord. My
then
only
otherwise-
concern is time.
Time in 23 matter, there can't be a direction. Only direction that this court can issue is don't accommodate her with unnecessary adjournment.
My lord, at least best possible direction for time may be granted, my lord. At least within 9 months, or my lord, at least for reaching the stage of evidence or argument, because I have concluded the proceedings still arguments. Now, after reaching the stage of argument, she comes and files an IA for recall. That too with the reason, my lord, that she feels
Please
low.
show what arguments stage it reached.
My lord,
nothing.
My lord, kindly come to page 33, my lord.
Yes, I'm looking at 33.
My lord, the respondent is absent, no representation from the respondent side, hence the cross of PW1 is taken as nil.
So one day the matter comes and the court says the PW1 is taken as nil, then at
My
that
lord, that
amounts
was
to-
because she was not appearing.
No, please come.
My lord, kindly grant a direction, my lord. Kindly.
Please
My lord, I am not.
understand.
My lord, I acknowledge the fact what your lordship is directing me. I acknowledge that, my lord. I understand that it might be appealed and I might lose more time. Kindly grant a direction to the trial.
And so
court.
first part you understood.
Please, my lord.
Second part, what you have to understand is this court is directing the Bangalore Family Court to dispose of the matters till 2019. Yours
my
is
lord.
not an exceptional case that it has to be directed to dispose of out of turn. So this is the second point. This also you understood now.
Please, my lord.
Please come. The present writ petition is filed. Agreed whether?
My lord,
What
one
is-
last point, my lord. I have not been granted an opportunity of being heard on the IA. It was allowed on the same date when she files the IA, on the same date it is allowed.
Anyhow, it is why you want unnecessary. I'll record your contentions.
Please,
The present writ petition is filed. Agreed with orders passed in I number 3, dated 11/6/2025 in MC number 7743 of 2022. The petition before this court is the husband. He has filed MC number 7743 of 2023 seeking divorce on the ground of cruelty.
Please, my lord.
On the ground of cruelty.
13(1)(a).
The wife had entered appearance on
9/2/2024, ma'am.
on 9/2/2024. Thereafter, the matter has come up for objections on two occasions. The objections were not filed. Then on 29/1/2025, the court had taken an order is passed that as the respondent has failed to file the objection, it is taken as not filed and directed to call for the petitioner side evidence on 19/3/2025. On 19/3/2025, the petition is present, the respondent is present. The petitioner side have filed one document. The petition is examined as PW1 and exhibit P1 to P5 are got marked for further chief of PW1 directed to call on 11/6/2025. At this juncture, I number 3 is filed under order 7/14 seeking permission to file their additional documents. And the documents are taken on record. PW1 is further examined and exhibit P6 to P15 are got marked. And the court has closed the petitioner side evidence. It's I number 4 and 5, not 3 and 4. Thereafter, they filed I number 4 and 5 under 151 CPC, seeking the permission to file their side objection statement to the main petition. The court has allowed the application and observing that now the case is posted for argument, however it necessary to afford maximum opportunity to the parties. Hence, the IA is allowed and the objection statement to the main petition from the respondent side is taken on record. And along with that, they have filed a counterclaim seeking restitution of conjugal rights. And also filed IA number 6 under 151 CPC seeking deletion of allegations. The court has adjourned the matter to 28/2025 for rejoinder if any to the counterclaim and objections to IA number 6. Next parallel counsel appearing for the petitioner, husband submits that the wife was not diligent in prosecuting the matter. And when the matter is posted for arguments, the present application came to be filed. It is submitted that the court has not given any opportunity to the petitioner to contest the said IA. Now the wife has also sought for counterclaim. It is submitted that only with an intention to harass the petitioner and to protract the proceedings. This counterclaim is filed when without the court ought not to have allowed the IA number 4 and 5. It is submitted that the order impugned needs to be set aside. This court has perused the order. No doubt there are lapses on the part of the respondent in filing the objections. The dispute between the parties can be adjudicated if all the pleadings are there on record. Considering this aspect, the court had allowed the IA in these circumstances. This court do not find any reasons to interfere with this order. However, it is made clear that the court shall not permit the respondent wife to drag on the matter, and unnecessary adjournments shall not be granted.
Lord,
Accordingly disposed of.
I apologize to bother your lordship. Lord. One finding may be recorded that the matter shall be disposed as expeditiously as possible. Lord, I have contested the matter till the stage of argument. Grateful, Lord obliged.
Yes.
Yesterday's matter, the respondent wanted to make submission.
Are you appearing as a party in person?
Yes, sir. I'm filing a memo.
You appeared before the committee?
Not yet. The copy was also served through a WhatsApp, Your Honor. I don't have the physical copy. I requested so many times.
Requested who?
All the junior counterparts in the family court. I've sent a message.
What is any urgency in this matter?
But the urgency is this. Your lordship has directed the family to 2015 matter, my petition for divorce. There was a stay order passed by the Honorable Court for of further proceedings. And then your lordship passed an order at page number 46, operative portion, directing the family court to dispose the main matter before the 15th of December. Page 51, my lord, is the, sorry, page 50.
Yes.
Time limit has been fixed. It is for my cross-examination. The respondent refuses to cross-examine me until I file my affidavit of assets and liabilities. There is no monetary claim pending before the family court at all. There was a claim for alimony which I have withdrawn. Cross-examination is not, he's not proceeding with until I comply with your lordship's order, my lord, at page number 51, directing both parties to file the statement of assets and liabilities at page 51. That was at a time when my claim for permanent alimony was pending before the family court.
No. This order, what was the impugned order in this petition?
The father had challenged the order of maintenance, interim maintenance granted to the child. 10,000 rupees was awarded to the child as interim maintenance.
He is paying still.
He's been paying 7,500.
Then why not this is necessary? If it is, he's claimed that you're earning. So if you don't file your statement of assets and liabilities, when there is a direction by this court, you ought to have filed. And if you don't file, if you want any modification, you should have approached the court. And you just can't keep quiet saying that no, I have, I don't have any other claim on monetary aspects, so I will not file. That can't be the
But your lordships have specified in the
Both the
order.
parties shall file their respective statement of assets within 15 days from the date of receipt of the
Kindly,
copy
kindly
of the
see
order.
direction number 4, my lord.
Yes.
As per the interim order, the petitioner husband shall continue to pay the maintenance per month to the respondent
Yes.
wife till disposal of the MC. MC is to be disposed of by 15th of December.
Because now,
yes,
the court will consider
yes,
why this arrangement is made, again, making adjudicating on the interlocutory stage or on the maintenance. This will be adjudicated finally.
I'm not making any claim at all.
No, for 7th, what about the maintenance to the child?
I'm not claiming, my lord. After your lordship's order, my lord, spends itself by 15th of December, there is no claim I'm making for any further monetary support from the father at all. Not for myself, not for the child. Not the entire exercise.
In the pendency of the matter, why should he pay?
For 2 months, your lordships have directed him to pay.
Your
The
Honor,
matter was disposed of, my lord, on.
It appears to be that something is not.
No, the reason is
Probably
this.
no, the reason is she has already, whatever she has stated.
Yes.
Maybe not right that she doesn't want to place things on record.
Lord, the reason is this. On the last occasion, there was a visitation order passed by the family court in an execution proceeding, where the father came near her house and created ruckus. She has purchased, my lord, some properties which we'll have to disclose in the AOD. The only reason she does not want to disclose is because there is going to be, my lord, some embarrassment cost or humiliation cost. Therefore, she's even giving up claim for. I've been appearing in this matter, my lord, from 2018 before the family court. So I'm aware of, my lord, what transpired in the execution proceedings. A child has in fact been referred to NIMHANS for counseling by the division bench in an appeal filed by the mother against the in the custody proceedings. These are the issues, my lord, that are pending. She
Where
stays,
is the order impugned now?
no, the order impugned is page number 21. May I read? 18.9.
Yes.
The counsel for respondent filed, he filed an application to recall the stage of closing my cross-examination and permitting him to cross-examine me. That application was allowed. Thereafter, para number 4, counsel for petitioner submits that they have filed memo that they will not claim permanent alimony and there is no need to file affidavit of assets and liabilities. Counsel for respondent submits that they're paying maintenance already and there's a direction to file affidavit of assets and liabilities to both parties and also file objection to the memo. Peruse the order passed by the Honorable High Court of Karnataka and WP number 50738 of 2019 that there is a direction to file affidavit of assets and liabilities by both parties within 15 days, which is not
No,
complied.
she
Yes.
doesn't want permanent alimony. She doesn't want maintenance. Even the maintenance that you are paying, you don't pay to her. So why the statement of assets and liabilities are necessary at this juncture?
Your Honor, the maintenance was awarded by the principal judge without the assets and liabilities. So there's a lot of
No, no, they
confusion.
don't want.
No, but I've already paid about 6,50,000 over the years, Your Honor. My defense was struck off on this matter. And in fact, they're trying to, in the guise of setting the family
What will
court
happen to his amount that is
The
paid?
order that was passed was prior to Rajneesh and Neha. 2018 was the first order of maintenance, at which time there was no requirement for either parties to file their affidavits. And the second order was passed on 9/9/2019, prior to Rajneesh and Neha. So it is not a question of me not complying with the requirement of the law and therefore having to file this affidavit of assets and liabilities.
For how much is she sought?
Initially, I sought 75,000 rupees both for myself and my child. 25,000 rupees was awarded by the family court. That was challenged by the father. It was reduced, to 10,000 rupees and the matter was remanded back to the family court for fresh consideration. Family court has passed an order in 2019 awarding 10,000 rupees per month, which was further reduced to 7,500, only for the child, not for me.
Your Honor, so throughout the petition, they have always suppressed the facts. And when the time has come where it has to be disclosed, they're trying to, in the guise of setting the FC order, interim stay, they're attempting to set aside the order which was passed by this very court, Your Honor.
No, they do not want. She doesn't want alimony. No further maintenance they want for the child. In that case, what is if the statement of assets and liabilities are not filed? What is the impact of it on your case?
Your Honor, this will lead to clear suppression of the facts. And I think the counsel is already aware there's a perjury and contempt application which is pending before the MMTC court. So they don't want to commit.
What is that application?
It was about cruelty, Your Honor. That's already been dismissed. And they've gone on a criminal
No,
appeal.
perjury application. What is it? Perjury application on what ground?
On not disclosing the facts, Your Honor.
Of what?
In the assets and liabilities, they have lied quite a lot, Your Honor. So
where did they file?
In MMTC 5, Your Honor.
They've already filed.
Yes, Your Honor. And again, they have gone for a criminal appeal, Your Honor. And there also the matter is pending. So they want to avoid a double perjury and they're avoiding to file the assets, Your Honor. So clear suppression of facts, Your Honor. And they even sought the strike off of the defense on this matter. I had to approach the Honorable High Court several times. And when the time has come to correct it, they're avoiding the filing.
Where is that strike of the defense?
In this very court.
Your Lordship's order, my lord, there were two orders. One was challenging the direction to pay maintenance of 10,000 rupees, and another was where the family could have struck off his defense for not paying the maintenance. Both writ petitions were clubbed together. There's a common order passed by Your Lordship in both the writ petitions. This is all in 2019, much prior to Rajneesh and Neha. May I make this submission, my lord? Kindly see the attitude of the respondent. The only reason he wants me to file my affidavit of assets and liabilities is because now the matter is posted for cross-examination. Cross-examination on my assets and liability statement can go on, which he wants to use for the other case, where he says there is some perjury application that is filed. There is no prejudice caused to him because I'm not making any claim before the family
Your
court.
client is not being fair to the fair, and why she is doing all this.
No, there has been
No,
a
whether,
history.
because he has every right, because
There's a
he's
history to the
he
relationship.
is litigating, either he can have this or that, like, nothing wrong with that.
True, my lord.
But your client has to be fair to the
But
court.
I'm not making any claim. My lord, the requirement to file the statement of assets and liabilities is only if there's a
You
monetary.
filed a statement of assets and liabilities before the other court.
In 7 years ago, in 2018, or not 2018, sorry, I'm 2020. I'm not appearing in that matter. The domestic violence, somebody else is appearing. But that was from the instructions that was more than 4 or 5 years ago.
No, Your Honor.
Not-
The
But
file is
did
very
you
recent. Your
seek for, no, one more thing is,
Yes.
an order is passed.
Yes.
Directing the court to dispose of the matter, and in that one of the clauses that you have to file your statement of assets and liabilities. Did you seek modification of
But
the file?
apparently, the instructions are that the counsel who appeared in the writ petition earlier made a request, my lord, for being spoken to or to file an application for modification. Your lordship suggested that it's a separate cause of action. I will not, if there are any subsequent events that have taken place, you file a separate. These are the instructions I have received. But ultimately, my lord, the object of serving filing the statement of assets and
It's
liabilities
true,
is
that I
only
can
if there's a monetary
understand,
claim.
that I can understand.
Yes.
But at the same time, your party is afraid of filing the statement of assets and liabilities because somewhere like she must be thinking that, it will be adverse to her statements or that are made earlier.
I cannot be invited, my lord, with great respect, to give evidence against myself. I've already filed an affidavit. He has filed a perjury petition. That can go on. Now, my lord, I have purchased some property. I can show a video to your lordship of what happened when the last time the family court granted visitation. Coming outside my house, screaming, going to all my neighbors, telling them that this lady is, I have filed cases against her. She lies on oath.
Your Honor,
This is them. I'm sorry, please wait. I'm a single lady, my lord, staying with my son for the past 10 years. I have the video, my lord. I don't want to embarrass anybody before the court. I'm on the street in front of my house. I'm covering behind my window and taking the video of how the person behaves. If he gets to know that I have purchased another property, the same will repeat. The same incident will repeat again. I've been staying, my lord, because my father has gifted a property to me. My brother is now supporting the respondent. My father, prior to his passing, gifted the only property that he had in his name to me, because I have taken care of my parents all through. And my brother is leading evidence against me in a case filed by him. These are the family dynamics. I'm a single lady. I have no other support.
Your Honor, if I may. Both the interim and final visitation orders have been violated by the petitioner, Your Honor. Both the execution petition is still pending before the Honorable Principal Judge Court.
MFA.
Why you don't want any settlement to all this?
She's not allowing me to meet the child, Your Honor. It's been 10 years. And I've lost the visitation since he was 1 year old. And he's 13 years old now.
No, fighting it in this manner, do you think that you will be able to get the visitation?
Your Honor, I am...
Ultimately, the boy is staying or the girl is staying with the mother. If you fight with the mother like this, will you get the visitation?
Your Honor, even this petition is filed by them so that actually I'm being harassed, Your Honor. Because this order is being passed by this court, Your Honor. And they're trying to get a stay in the guise of setting aside the family court order. Your Honor.
Yes, Mr. Arungondrij, whether this matter is anytime referred to the mediation?
Referred to mediation multiple times. In fact, right now, the child is undergoing counseling before NIMHANS by virtue of a division bench order.
You know, counseling is completed, Your Honor. Even now, they are violating the visitation.
What is the age of the child?
13-year-old boy.
And for 10 years, I have not seen the child.
Is it so?
But I have videos of him meeting
Two
the child.
execution petitions are pending, Your Honor. On the interim also and even on the main final order. Your Honor.
Lord, I have videos of him interacting with the child.
Let the entire trial happen, Your Honor. They are continuously making misleading.
We're ready to go on with the trial.
Here the
These-
matter is before the court about the assets and liabilities, Your Honor. They are going on making misleading submissions.
No, whatever happened before the judgment of Rashish versus Neha. Now, now whatever is that is pending is the MC. In the MC, neither she is asking for permanent alimony, nor she is asking for any maintenance to the child.
This is a new submission, Your Honor. Maintenance
That I
was
will
not
record.
withdrawn in the family
No,
court.
I'll record this, that she doesn't.
And what
want-
about
she-
the 6,50,000 she has actually collected, Your Honor?
That was.
That has been injustice the way she's collected, Your Honor. Because without
No,
filing the assets.
you don't have to contribute to the child.
But
Whatever
without
is
seeing the child, Your Honor,
Huh?
without seeing the child for 10 years.
But that won't be a ground, whether you're seeing or not.
All I'm allowing is a fair trial, Your Honor. Let the assets be filed and let there be a fair trial in there.
What is the necessity for that you can tell the court?
In fact, the
Why
petitioner-
the court has earlier
let me
ordered
say.
is, because if they want alimony, if they want maintenance, the statement of assets and liabilities have to be there on record. No, they have withdrawn that. And what is your problem?
There are other things, Your Honor. She has complained to the police station as ex-husband when the divorce has not been even granted. Your Honor. She's already addressing me as an ex-husband.
All these things, for that, this is not relevant.
That's what, Your Honor. There are many things.
You please understand, with all these issues and all, it's not going to take you anywhere. You try, go before some mediator instead of
I've
going.
gone, Your Honor.
Where you have
She is,
gone?
in the family court, there was mediation, and there was even in the High Court, there was mediation. Your Honor.
Hmm.
Both MFAs are pending before the Honorable High Court.
What MFS?
Two MFAs.
Custody against the custody order.
The
Custody with
GNWC is ordered.
Yes, Your
GNWC
Honor.
custody is with the mother.
Custody is given to the mother.
Mother.
He appealed against that.
He has appealed against the order of custody to the mother. Mother has appealed against the order of vacation custody to the father.
Even
Both
this,
those appeals are being heard together.
even
And then there are some interim orders.
Going on from the last 10 years.
Sorry, no?
It's going on from the last 10 years.
Appeal, no, the GNWC was disposed of in 2021 or 22.
No. When was this instituted?
Same 2015. Both cases were in 2015.
So almost 10 years.
so they've been exploiting the fact that they can lead to suppression of facts, and now when the time has come to correct it, they are again not submitting assets, Your Honor. When I have already submitted, Your Honor, and I will continue to pay the maintenance for 10 years, Your Honor.
He was earning 2.5 lakhs a month working in Hyderabad in a software company. The minute I filed the case, he becomes a music teacher in the school, earning 10,000 rupees a month.
Again, it's a misleading submission.
10,000
I
rupees a
am
month.
qualified as a music teacher. I have a degree, Your Honor.
We'll let the court go on with the proceedings so that the litigation will, there will be a finality to the litigation. Without this, I'll record that they do not want any maintenance for the child. They do not want any alimony from you. So this filing of statement of assets and liabilities in these circumstances, not necessary. Purpose of filing that is something else.
Your Honor, I'll be unable to cross-examine on so many aspects, Your Honor.
What aspects you want to?
Because she has even missed.
Understand, for granting the divorce, you don't require all those grounds. Divorce, the grounds are altogether different.
But not on the cruelty grounds, Your Honor. And the cruelty has already been dismissed by MMTC, Your Honor. So I'll not have a fair trial. I'll not be able to cross-examine on many aspects, Your Honor, if this is the case. And I've already filed the assets and
It is
liabilities.
assessed and liabilities are not for cross-examination on the merits of the matter.
At least it will show the court all the wrong submission over the years, Your Honor, 10 years. It will be great injustice when I've submitted and she's not submitting.
That is not the purpose of filing a statement of assets.
That is not the only purpose, Your Honor. I'm only requesting.
Please. The present deputy, where is the order impugned?
Page number 21, 18/9/2025.
Page number 21.
21.
Agreed with the order passed by the family court in MC number 4610 of 2015 dated 18/9/2025, where the court,
22 is the operative portion.
where the court had directed the wife to file the statement of assets and liabilities. The wife is before this court. The respondent has appeared as party in person. Earlier, when two writ petitions are filed before this court, one by the husband.
Both by the husband.
Both by the, when two writ petitions are filed by the husband earlier, WP number 50738 of 2019 and WP number 21516 of 2021, dated 17 July 2025. This court has disposed of those two writ petitions, directing the family court to dispose of the pending MC by 15/12/2025. Further, directed the family court to fix a time frame, and parties are directed not to ask for unnecessary adjournments. Further, the court has directed the parties to file their respective statement of assets and liabilities within 15 days from the date of receipt of the copy of the order. And as for the interim order granted by this court on 30/11/2021, in those writ petitions, the petitioner shall continue to pay the maintenance of an amount of rupees 7,500 per month till the disposal of the main MC. The husband has come before this court in the earlier round of litigation, one questioning the maintenance of an amount of rupees 10,000 that is granted by the granted to the when his defense was struck off by the court as he has failed to pay the maintenance. Next paragraph. Learned counsel appearing for the petitioner wife submits that the MC is filed seeking divorce. The wife is not the wife is not insisting. It do not require any alimony from the husband, and also she do not want to want any maintenance for the child. It is submitted that as the purpose of filing the statement of assets and liabilities is to determine the maintenance and to determine the alimony payable to the wife. When the wife is not interested, is not asking for any of these two, there is no necessity to file the statement of assets and liabilities. It is submitted by the land council that in view of the differences between the parties from the last 10 years, if she discloses her statement, if she files a statement of assets and liabilities, the wife is apprehending that the husband may cause inconvenience to her by coming to the new property which she has purchased. It is submitted that the dispute between the parties is going on from the last 10 years. Next paragraph. The party in person submits that in his submissions. It is submitted that the maintenance that is granted is much before the judgment of the apex court in Rashish versus Neha. Next paragraph. The party in person submits that she has suppressed several facts. He has filed his statement of assets and liabilities. Unless and until she files a statement of assets and liabilities, he would not be able to cross-examine the wife. He has been paying the maintenance from the last 10 years. He is not even able to see the child till now. If the statement of assets and liabilities are filed, the suppression as a misrepresentation of the wife would come on record. It is submitted that though the visitation is granted to the father, in spite of his best effort, he could not see the child from the last 10 years. Hence, as years full stop. It is submitted that when as per the order of the court, when they're insisting the court to dispose of the matter by December 15, the other limb of the order that the statement of assets and liabilities have to be filed ought to have been complied with by the petitioner, by the husband, by the wife. Anything else?
I want to submit a memo, Your Honor,
What is that?
requesting to take the cognizance of the contempt of courts, Your Honor.
Not before this court, because not before this court.
Yes, Your Honor.
Before the appropriate court, you can.
Yes, Your Honor. Pleased.
Having heard the learned counsel for the petitioner and the party in person, peruse the material on record. The Honorable Apex Court in Rajesh versus Neha has laid down the guidelines, filing the statement of assets and liabilities. The whole purpose of the same is to place all the record before the court and to determine the maintenance oblique alimony that is payable. In this case, no doubt, the maintenance of 10,000 that is fixed earlier was before the judgment of the apex court. On the last occasion, when the husband is before this court questioning the maintenance, this court has directed the wife to to file, both the parties to file a statement of assets and liabilities. Now it is a case of the wife that she do not want maintenance, or she do not want maintenance for the child, maintenance for herself, and also alimony, permanent alimony. The permanent alimony. In those circumstances, we'll say from today onwards, he doesn't have to pay that maintenance also, the alimony. And hence, this court has directed the husband to pay the alimony, pay the amount of maintenance of 7,500 till the disposal of the MC. Considering the circumstances where the wife is not seeking for alimony or maintenance, this court deems it appropriate. This court is of the view that the filing of a statement of assets and liabilities by the wife are not required. Further, the husband need not pay any maintenance from today as per the order dated 17th July 2025. Accordingly, the writ petition is disposed of, directing the family court to dispose of the matter as per the timeline fixed by this court in WP number 50738 of 2019 and WP number 21516 of 2021.
Cell number 6, preliminary in B group. Rahida, Onam.
Appearing for the petitioner in this case, my lord.
Yeah,
Impugned order is next year F, my lord.
My lord, I seek weeks time to file objections in this case, my lord.
No objections on the 2023 matter. Yes.
Your lordship, we are seeking for enhancement of the
Where is the order?
page number 74, my lord. Annexure F.
74.
It starts from 74. Operating part is at page number 84 onwards, my lord. Wherein petitioner wife has been granted 10,000 per month, and the son has been granted 20,000 per month, my lord.
10,000 to petition number 1.
Yes. And 20,000 to petition number 2, son.
Altogether 30,000.
Altogether 30,000, my lord.
What is the income of the father?
Yes, your lordship, he is running a company. He is the managing director of the company, my lord. Your lordship would find the relevant aspect at page number 131, my lord.
No. What was evidence before the trial court?
Your lordship, I have produced this document also.
What is 131?
131 is his company's ACR, my lord, which is filed before the Ministry of Corporate Affairs, my lord. 131 at column number C, my lord. Details of transaction entered into with related to parties and key personnel, my lord. There your lordship would find Tanmay Roy, who is the respondent husband, my lord, wherein his amount paid for the year is shown as 35,49,500 salary and remuneration, my lord. Expenditure is shown as 87,26,500. So these all are the income he is getting. But whereas the trial court has considered only rupees 95,000 what he has shown as his salary, my lord.
What is the finding of the court on this?
Your lordship may take.
Petitioner is working, my lord. She is
She has lost the job, my lord. I have disclosed in my assets and liability. I have produced it also before this court also.
Now, what has happened to this criminal miscellaneous,
It's pending, my lord. It's pending for a cross examination.
right from 2021?
Yes, your lordship. It's still on this day also it is pending. The stage is for further cross examination of PW1.
Hmm. What is your salary?
Who's my lord?
It's
Yes, Mr.
95,000, my lord.
Then what is this document at page number 132?
My lord, that is the company's expenditure wherever he goes, madam. That expenditure, whatever he incurs, he will claim from the
No, it
company.
says salary is, your salary is 35 lakhs 49,500. Look at it.
That is increase of remuneration, my lord.
What is
That-
remuneration? What is salary?
Salary is 95,000 per month, my lord. I have produced my income certificate also, my lord.
Salary will be 1 lakh and remuneration 2 lakhs per month.
Yes, my lord. That is apart from what I am, that is clearly mentioned, my lord. In the same page, 95,000 it is mentioned, my lord.
The respondent shall file an affidavit before this court with regard to the statement that is placed before this court at page 132.
131 minute.
Hmm?
Page number 131 minute.
131 and 132.
Yes, my lord. I will tell it.
That's at 132.
Yes, sir.
At page number 132. List this matter on 20th November. If no affidavit is filed by the respondent by that time, considering page number 132, the maintenance will be enhanced.
Deeply.
Cell number
Yes.
7, Ajay J. Nandalike, petitioner has moving right for
Yes.
So this matter has been settled. Only thing is the private mediator has to send the report because we opted for private mediation. My request on 12th or 14th of November, my lord, we'll request the private mediator to send the report to the High Court registry directly.
It is submitted that the matter is settled for the mediator's report. List this matter on 13th November.
Obliged.
Yes. We hope, I hope that by the time it comes,
settled, my lord.
no further adjournments on
I
this.
understand.
Yes.
Apologies.
8.
Cell number 8, A.
Appearing-
Mahesh Chaudhary.
Appearing for the petitioner in this matter, challenge, I'm for it's the husband's petition where the wife has obtained an ex parte interim maintenance order. On the last occasion, your lordship had ordered the respondent to file an affidavit that she's not working because in in the petition, she's written that she's not.
Where is it?
Due to festival and holidays, I could not file it. I placed 2 weeks time, I will file it.
Why?
Your lordship, it was last listed on 17/9.
17/9.
I agreed, your lordship, due to.
No, 2 weeks time. List this
Time may be
matter.
granted, I will file
List
it.
this
No,
matter on
she's
4th
Bangalore.
of November. By that time, if the affidavit is not filed, the court has to draw an adverse inference. Yes.
Your lordship, up until then, the order may be stayed, your lordship. This is the conduct of the respondent in all the proceedings she appears.
Anyhow, finally, it's coming up on 3rd. No, will not. Yes, next
Cell
9.
number 9, Gautam Raghunath for petitioner, Syed Khalil Pasha.
Yes.
The matter has been settled, my lords. This was a matter wherein, my lords, wherein my lordships probably wanted to lay down guidelines, but now the matter before the trial court, in fact, has been disposed of. Section 17 of the Special Marriage Act, I had filed a suit seeking declaration, your lordship said.
What has happened to that?
Now we filed a mutual consent, my lords, and we sought for cancellation of the marriage certificate.
Mm.
Yesterday it came to be disposed of, my lords. I think.
So nothing remains in this.
Nothing remains. I'll
It is
file a
submitted
memo
that
of
the main
withdrawal.
writ petition itself is disposed of. A memo is filed stating
The
that the
suit
main.
itself has been disposed.
Huh?
The suit
The
has
main
been
suit
withdrawn
itself is
before the
disposed
trial
of and nothing remains to be adjudicated in this writ petition again, accordingly dismissed as infructuous.
Great.
Yes.
Obliged, ma'am.
Cell number 10, Lovini
Let's,
Rajesh Rohara.
I'm also
Sonia Rajesh.
respondent in another. So there are two matters, my lords. I am the petitioner in one and. Lords, if my lords may recollect, this matter was heard in the chamber where my lords had interacted with the parties, the husband and the wife. Lords, we've gone to their house and they've come to our house and they've done the inventory. The jewelry is intact. So we have the list, my lords, and she's also taken certain belongings. Now there is a possibility of settlement. We've also given our quotation. In
To
case.
see how nice the husband is. He has not even touched anything.
The cupboard key was with
It was with her only, my lords. She opened it and
She
she
was
said.
apprehending so many things that day. So what is going to be?
Now the husband in case it is again taken up in the chamber, my lords, there is a possibility of settlement. Now, the husband has the daughter also. I mean, he's traveling. Now, we've given a proposal to her. If she comes up with the settlement offer, I think it will settle, my lords. We can have it in the chamber, your lordship.
This is matter on 11th November.
Please, my lords.
This is matter on 11th November. On the day, all the parties shall be, both the parties shall be present.
Yes,
The
Your
chambers.
Lordship, only one more thing was there, Lordship. The jewelry given by her parents to his parents, that is still there with them. We can talk it out in the chamber.
Yes.
Let's,
Five.
My lords, the memo with the list of articles is with me.
Keep it, or else file in the registry. Yes.
Cell number 11, parted matter. Abhilesh J for petitioner.
Appear for the
Respondent here in.
petition of lords. The last occasion, my lords had directed to file the entire order sheet. This is the matter pertaining where the parties had actually consented that they don't have an issue in terms of divorce. However, they had issues in terms of like.
Yes, let's see that.
This part.
That order is dated?
16/3, my lords.
16/3, my lords.
16/3?
2023.
2023.
My lords would find it at page 8 of the memo.
Yes.
Please, if I may read it, my lords. Conciliated, sorry, both the parties and their counsels are present, conciliated, and it seems that there is no any objection in granting the relief with regard to relationship. But the dispute lies in respect of quantum of maintenance to the respondent and her child. Therefore, the parties are hereby directed to lead their evidence in respect of maintenance, and petitioner is directed to lead the evidence forthwith. This was the direction, my lords, in terms of both the parties. Now, if my lords were to kindly see, thereafter, my lords may also see the order dated 12/4/2023. At page number 9, if my lords were to turn, that's where like the IAs are actually kept in abeyance, my lords. I'll just read the operative portion of the order. All the IAs are kept in abeyance. Petitioner is directed to lead evidence forthwith.
So evidence in respect of maintenance.
Yes, my lords. As per the direction, it was only in terms of the maintenance. However, my lords,
Then
like,
it speaks about the bank statement.
certainly.
Case called before the.
Again, because parties were directed to comply with
Counselor
Agnesh's
present.
enhanced judgment.
Case called, petition counselor present. No representation, is not interested to prosecute the matter. File memo along with the copy of the order on dispose this matter within 3rd on INF. Since the High Court is directed to dispose this matter, directed to lead evidence forthwith. I think something is wrong with this order.
My lords, it would
Witness
be.
box and tendered affidavit as is affidavit in chief as PW1 and God marked exhibit P126. You're for the wife.
Please, my lords.
If for the husband is the
Petitioner.
husband filed the MC, you filed the
Certainly.
counterclaim.
Please.
Let if both of you want to contest the matter, let that be, let the court go in a phased manner
My
and
lords,
let it take its own time.
My lords, if with all due respect, if I may seek for a passover because senior is on his legs in another court.
What were you doing till now?
My lords, kindly pass over, my lords.
Cell number 12, situation.
I appear for the respondent in this case, my lord.
Ajit.
I appear for the petitioner, my lords.
Yes.
Just to refresh your lordship's memory, my lord, this was filed before the vacation. This was filed before the vacation challenging the interim order by which interim custody was directed to be given to the wife. Then your lordships felt that the parties may have to be present before the court. Then your lordships took the matter in chambers. And your lordships felt that the interim order need not be interfered with, but this matter may be kept pending for the parties to explore if the entire dispute can be resolved. So I've tried reaching out to the client. He would need some time to see if the entire dispute can be settled, because proceedings are still pending before the trial court. In a
the
technical sense, this petition has become infructuous for the reason that the order has spent itself.
So you want this matter to be pending before this court to explore the possibility of settlement, or in the light of the fact that it has become
The
infructuous?
first option, Lords. If the entire dispute can be settled, I'll seek instructions from the client if he is willing for mediation, because that's what your lordships had indicated.
Yes, Mr.
My lord, there are other 3 petitions pending before this honorable court. So therefore, this can be closed, my lord. This has become infructuous. So my only respectful submission, my lord, the mother is separated from the child. I am the mother. It is the child custody is with the father. The child has only 2 vacations in the year, my lord. One is summer vacation and the other one is Dasara vacation. And there is no winter vacation for the child. As of now, the permission granted, my lord, is only on Saturdays. So therefore, my respectful submission is, let there be a direction by this honorable court that the child be with the mother's custody from Saturday 12:30 to Sunday 7 o'clock, my lord. I'll return back the child on Sunday evening. At least the mother and child bonding will be there.
Whose petition is this?
It is petition father's, my lord. Father is having the custody.
Then why should we grant an order in your favor? The presented petition is filed. Agreed by the orders passed in JNWC IN number 7 in JNWC number 18 of 2024 dated 17 September.
Subject to correction, it's I-12, my lords, page number 27.
Yes, that's what I'm looking at. I number 12.
12, yes.
And GNWC number 18 of 2024 dated 17 September 2025. As an interim custody, child is given to the interim custody of the mother from 29/2025 to 29/9/2025.
29.
When this matter came up before the court, this court has not interfered with the order impugned and also interacted with the parties and suggested that the matter can be amicably settled and they can settle all the disputes. They can settle the disputes that are pending. Then counsel for the petitioner submits that the order that is impugned is already worked out and nothing remains to be considered in this petition. And they petition and they will work out the remedy, they will work out the possibility of settlement before the family court. In that view of the matter, nothing remains to be adjudicated in this petition. Accordingly, dismissed as instructions.
Great.
Yes, next.
Serial number 1.
Lord, yes, please.
One urgent. Serial number 2.
Warning, once a submission is made that some difficulty, something, so I have taken it up tomorrow or day after
No,
tomorrow.
no difficult, no difficult. Grateful.
Serial number 2. Jagdish MS. Vijay Lakshmi for petitioner. Mahendra ABS.
In this case, appearing for petitioner, respondent, my lordship.
No representation on behalf of the petitioner. This is also in dispute. Yes, give this.
Challenge the section 14 order, my lordship.
The petition is filed questioning the
Section 14 order, my lordship.
action by the respondent bank in affixing the position notice dated 21/1/2021 under section 13(4) of the Act, and also sought an interim order seeking stay and operation of the execution of the possession notice dated 1/1/2024 issued under section 13(4) of the Surface Act. This matter came up before the coordinate bench of this court on 25/11/2024. Emergent notice was issued. Interim order as prayed for is granted, subject to the petitioner depositing 25% of the outstanding amount within 4 weeks from the date of order, failing which interim order granted earlier stands vacated and the respondents are at liberty to proceed in accordance with law. Then on 19/6/2021, this interim order is extended. Again on 2/7/2025, the interim order is extended and there was no representation on behalf of the petitioner on that day. Then again on 8/7/2025, interim order is extended. 14/7/2025, 28/2025, 19/2025. The interim order is being extended. This matter came up before this court on 16/10/2025. As there was no representation on behalf of the petitioner, this court has directed the matter to be listed today under the caption for dismissal. In spite of the fact that the matter is listed for dismissal, the petitioner has not, there is no representation on behalf of the petitioner. The petitioner is enjoying the interim order from the year 2024 and has failed to appear before this court. Hence, the writ petition is dismissed, non-prosecution.
Cell number 3.
That's so, my lord.
Cell number 3.
If respondent bank,
Advis.
they undertook to pay the principal amount within a week.
If they're not interested, what we can do? The present writ petition is filed. Questioning the order dated 28/4/2025, passed by the Debt Recovery Tribunal in MA number 4 of 2024. Initially, a coordinate bench of this court no interim order in this.
No interim order.
The notice was ordered and the matter is pending. Matter is pending. When this matter came up on 16/10/2025, it is submitted with the learned counsel to the petitioner that he'll get instructions from his client with regard to the payment of the principal amount pending disposal of the petition. Learned counsel for the respondent argued that the appeal, there is an alternative remedy
Under section 20,
under section 20
RDB Act.
and he cannot come before this court filing the writ petition. Hence directed the matter to be listed on 23/10/2025. Again on 23/10/2025, the time was sought and the matter was directed to be listed on 25/10. When the matter came up on 25/10, there was no representation on behalf of the petitioner. Hence, the matter is directed to be listed today under the caption for dismissal. Today also, there is no representation. It appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Cell number 4 for adults, Ananda N for petitioner.
On 10/3/2025, 10 days time is granted to comply with the office objections, failing which the petition would be dismissed for non-prosecution.
I take notice for respondent bank in this case.
Which matter?
Serial number 4, LKVK Finance,
What's your name?
HN Vasudeva.
So and so submits that. He has instructions to file wakalat on behalf of the respondent bank. What did you write? On 10/3/2025, an order is passed. Even in spite of an order passed for the court, till today, the office objections were not complied with. Hence, in the light of the order dated so and so 10/3/2025, the writ petition stands dismissed.
Cell number 5.
This is the writ petition by the bank.
Respondent.
My lord,
The writ
I'm
petition
fil-
by the bank.
Filing statement of objections to writ petition.
My lord, may I make one submission?
Lord, before he proceeds, my lord, on the ground of it is my writ petition.
Sir, one second.
They cannot intrude. I'll make my submissions on behalf of the bank.
May I make one submission by view of the court? My lord, in this matter, what has happened is the order passed under section 14 of the Surface Act. My lord, in the meantime, before the magistrate court in Hyderabad, my lord, they have settled the matter with the principal borrower. I want to place it on record with regard to the documents. That matter, that aspect has been suppressed even before the learned magistrate while taking the order under section 14. And now also before this honorable court, they have suppressed the material. My lord, we have applied for the certified copy.
Who are you?
My lord, I am the owner, I am the guarantor, and my property is given as secured asset in respect of
For the
loan.
borrower.
Yes.
I'm the bank, my lord. I have
No,
filed an
borrower is not made as a party. Borrower and bank are in hand in glove, my lord, in this matter. They have suppressed, the entire fraud has been played, even on the courts also.
Let me understand. Let me
Demand,
understand.
demand notice on possession notice.
Please wait, please. Let me understand the facts. Yes.
Lord, an application comes to be filed by the bank,
Mm.
that is us,
Mm.
seeking an order under section 14.
Mm.
My lords will find the impugned order at page number 194. An application comes to be filed. And my lord, before, since my learned friend was going on, I did not want to intrude. Kindly take to the order sheet. You have been, my lords have been going through. Every time, my lord, deliberately now the objections are filed. I will not contest that objection.
Let's read that.
Kindly come to the order, my lord. An application was filed by the bank seeking physical possession of the secured asset.
Where are you reading? 190?
Page 194, order dated 23/11/23.
Starts with petitioner secured.
The petitioner, yes, ma'am.
Hmm.
Yes, ma'am. In this, the learned magistrate, my lord, dismisses the application filed by the bank under section 14. Kindly see the reasoning. Straight away, my lord, I will request the honorable court to come to page number 201 in the very same impugned order, 201.
Mm.
My lord, paragraph number 11. By reading the above statement, in conjunction with the provisions contained in section 13(4)(c), as appointing a person as a manager is contingent upon physical possession having been taken over, and as such, the applicability of 13(4) is also irrelevant, and 13(4) is also relevant, and 13(4)(c) alone cannot be taken into isolation. Therefore, the mandatory requirement of paper publication as enumerated in section 15(1)(a)(b) has not been satisfied. Now, my lord, I'll take your lordships to the paper publication. Paper publication is also taken. Straight away, I will request the honorable court to come to the paper publication at page, my lord, 132, your lordships. Series of paper publications are taken. Before that, my lord,
Mm.
and there are as many as, my lord, 130, 130, my lord. Annexure 130, annexure N1, 130. My lord, on the right side bottom portion, Kotak Mahindra, your lordships will find.
Mm.
Bottom portion, Kotak Mahindra.
Mm.
This is the first paper publication.
Mm.
Finding is that we have not taken paper publication. Thereafter, my lord, on the next page, your lordships will find 131. It is in Kannada. Again, Kotak Mahindra Bank Limited. Paper publication is taken. Page number 132. On the left side corner portion.
Property situated.
My lord,
Where is the property situated?
it's in Bangalore only.
Then why he says that it is settled before?
No, that is why, my lord, we are only concerned with the present proceeding whether section 14 order is correct
OA
or
is
not.
filed in Hyderabad.
No, again they are interrupting, my lord. I did not interrupt when they were going on. There must be some fairness.
For that reason, my lord, we want to file our objection.
My lord, I am pressing my application under section 14.
1 second.
No, he can't come like this, my lord. It is my petition, they are intruding. And for the last 1 year, my lord, same tactic is adopted, more than 20 crores. And kindly see, my lord, what they have done. Kindly come to 104. They file a statement before the magistrate that we will clear entire thing. Kindly come to page number 104. Joint memo is filed.
He is suppressing the facts.
Annexure M, page 104.
I will hear all of you.
Yes,
So
please,
I
please,
expect that when one is arguing,
Yes.
the other will have the patience to listen.
Annexure M, page 104, madam.
104.
Yes. This is when section 14 application was pending consideration. 104, annexure M.
Hmm.
Kindly see the joint memo, my lord.
Who filed this?
This is by the borrower. Kindly see, madam. The petitioner and the respondent jointly submit. There are two respondents. Borrower is also there and guarantor is also there. Both borrower and guarantor, both of them. The petitioner and the respondents jointly submit that the respondent has handed over the physical possession of the handed over the possession of the scheduled property, and the respondent number 1 shall pay a sum of rupees 18 crores. Kindly mark this, madam, including 50 lakhs as already paid on 12/1/2018 to the petitioner over a period of 12 months from the date of handing over of possession of the scheduled property. This joint memo may kindly be taken on record in the interest of justice and equity. This is filed on 19/9/2018. Kindly see this. They file this, they come before the magistrate, they say, please, we want to close it at 18 crores then. Now we are in 25, now they are coming up with some more applications, let them come. The impugned order which I had read out to your lordships, just now at page 201, learned magistrate holds that there is no paper publication. My respect.
That's the only ground.
That's the only ground. And my lord, he touches the merit of the matter. Second ground is question of hearing the borrower and the guarantor while passing an order under section 14. This court would say, the coordinate bench of this court would say, last time quoted, question of hearing the borrower or the guarantor while passing an order under section 14 does not arise.
Yes.
In this reported judgment, straight away, my lord, I would request the honorable.
You don't have to read it.
Yes, ma'am. Page 17 of the said order.
No, you don't have to read the judgments.
Yes. In the impugned order, your lordships will see how detailedly both of them are heard. Borrower is also heard, guarantor is also heard. In paragraph number, my lords will see page 196, my lord.
90?
Yes, ma'am. Page 195 for a minute. Page 195, last paragraph, paragraph number 3. This is the first illegality committed by the magistrate. Respondent number 1 and 2 have filed detailed objections opposing the application contending that the petitioner took the possession of the secured property through the advocate commissioner and the petitioner cannot invoke section 14. So magistrate hearing these borrowers and guarantors is against the very purport of section 14 and the binding judgment of this honorable court. This is point number 1. Yes. Secondly, a finding is recorded at para 11, page number 201, that there is no paper publication. Para 11, my lord. Just now I pointed out there is a paper publication. Umpty number of paper publications. And in the very same order, my lords will come to the next page overleaf. In para 12, my lord, interestingly, learned magistrate records. During the course of arguments, learned counsel for the petitioner has relied on the judgment of so and so, and he would extract that. And at para 13, admittedly in the aforesaid decision, respondent number 1, 2 had trespassed in the property and had forcibly dispossessed the petitioner without taking the recourse to law. Para 14 is relevant. In the present case, as per the own admissions of the petitioner bank, that taking into consideration the students in the school run by the respondent number 2 in the premises of the secured property appointed respondent number 1 manager, kindly mark this, my lord, under the SERFACI Act as per the appointment letter. Further, the Panchnama clearly discloses the taking of the possession of the secured property from the so and so. Therefore, the present case on hand, respondents neither trespassed into the property nor dispossessed the petitioner forcibly without taking recourse to law. Therefore, with due respect, the decision relied upon by the counsel for the petitioner is not acceptable. Therefore, once the petitioner bank took possession of the secured property from the respondent under Panchanama by authorized officer of the bank, question of seeking repossession of the secured property by invoking the provisions of SERFACI Act does not arise. In the entire act, there is no concept of repossession. Once the petitioner took possession under the Panchanama, thereafter the petitioner bank voluntarily appointed respondent number 1 as manager to the school run by the respondent number 2 by delivering the possession. The application filed by the petitioner seeking repossession is devoid of merits. Here the learned magistrate does not record this respondent number 1 is none other than the guarantor. Respondent number 1 is none other than the guarantor.
File the application for repossession.
No, it was our application under section 14. What had happened, my lord?
No, what is this repossession?
He is using a wrong phrase. Magistrate has erroneously used the wrong phrase repossession. It is not repossession. It is a physical possession. Phraseology used is wrong. We are not asking repossession. What had happened? There was a school premises that was run which was subjected to.
He says in the entire act there is no concept of repossession.
This entire order itself is wrong. Kindly take to my application. What my application is. Kindly come to my application. They were running a school. They made a statement that we'll appoint a manager. We want to settle it for 18 crores. Believing all this, my lord, joint memo was filed. Kindly take the application filed before the learned magistrate.
Where is it?
I'll just. Page 172 onwards.
172.
Subject to missing. 1 minute. My lord, 182. I'm sorry.
182.
I stand correct. This is the application which is adjudicated.
Hmm.
182.
Hmm.
Application under section 14 of the SURFACE Act for the repossession. The secured creditor respectfully submits as under.
You only said that repossession.
My lord, the very phraseology itself is wrong. That is what I'm saying. Repossession means the
Used by
possession
whom?
for the bank.
No, you were saying as if it is by the magistrate.
No, my lord. The phraseology in both in the application and also
What
in
to
the,
do? Your bank used it.
yes. So
Then he rightly said there is no repossession.
repossession. What I'm pointing out is that the possession was with them throughout because they were running a school. They got appointed a manager.
Let's see the prayer in that.
Yes. But prayer, my lords, will find it at page 184. 184.
Hmm.
Wherefore, the secured creditor respectfully seeks the leave of this honorable court to be pleased to pass an order for petitioner to take the possession. Kindly see, my lord.
Page number
184. Last portion. For about fourth line from the top. 184, my lord. Wherefore, the secured creditor respectfully seeks the leave of this honorable court be pleased to pass an order for petitioner to take the possession. Kindly mark this, of the secured property from the respondent with the help of the advocate commissioner with the assistance of the concerned police with the additional force protection in the interest of justice. It may not be happily worded in the opening portion, but in the prayer I have sought for possession only.
The respondents have illegally retained the possession. According to your case, you have taken possession again. They have taken possession from you.
No, my lord. The fact was that they came.
Fully taken.
The fact is, I'll just submit. It is a school premises. The secured property that was given to us was a school premises. So a manager came to be appointed, who is none other than the guarantor, saying that, see, we want to regularize your debt, and to with that understanding, kindly take to the appointment of the manager. At an extra.
I understood. Yes, what you said.
My lord, 1 second. My objections is not received. Copy of- If that is objections was received, 1 second, I will finish the matter.
Why not? Why?
He is not able to receive that objections. Yes, this is. Fine. He-
I will receive it. I have never said no.
When did you enter appearance in this writ petition?
My lord,
It's 28.
it is still in our office objections. 1 year back I appeared. But because what happened?
And you don't, you
No, no.
will file your objections after a year.
The proceedings before DRT at Hyderabad and Checkbones case at Hyderabad, I could not able to get the documents. He has suppressed all the material facts before this court. Therefore, there is a delay of my. Okay. My lord, kindly see. Page number of my objections.
No,
Page number
before
7.
Before going into those page numbers.
7.
Property is here in Bangalore.
Yes,
Where is the DRT Hyderabad?
The borrower is in Hyderabad. The properties are the borrowers.
This is where?
Hyderabad. And guarantor's property, one of the guarantor, there are 4 guarantors.
One is obtained?
By borrower, not
Where?
Hyderabad.
Uh,
Kindly see.
So entire now the property is in Hyderabad, borrower is from Hyderabad, all proceedings are in Hyderabad.
Guarantor's property, some of the properties of the guarantor is in Bangalore.
Hmm.
Therefore, on that he has filed
What is the amount borrowed?
40 lakhs, 40 crores.
40 crores.
What happened?
Hmm.
Kindly see.
You are the borrower or the guarantor?
No, no, guarantor. My guarantor was discharged long back. I will establish before this court. Kindly see my objections, page number 7.
Your property is in Bangalore.
Yes, ma'am. Kindly see page number 7.
Page number?
Yes, entire this thing I will establish before this court. Para 18, my lord. Event wise, loan sanctioned by the petitioner on 23/4/2012. Personal guarantee and deposit of title deed of this respondent is 11/5/2012. Restructuring of the loan on 1/7/2013. Declaration of NPA 1/3/2014. This is very important, my lord. Thereafter, demand notice was issued on 2/6/2014. Then, master restructuring agreement by the CDMR lenders was executed on 29/2014. Recovery of suit filed in Hyderabad on 6/6/2014. Checkbones case is filed on 28/2014. Possession notice was issued on 8/9/2014. Section 14 petition filed on 22/1/2015. Order obtained on 5/5/2015. This is very important. And again, second time, order obtained on 12/4/2017. Again, restructuring the loan with fresh terms and conditions was 19/5/2017. Again, fresh loan was sanctioned by them. It was admitted in their writ petition. Thereafter, now they are seeking enforce the order to earlier orders. Without NPA is 2014. After sanctioning the fresh, they are coming before this court for this purpose. Now what happened? They have to declare NPA, issue demand notice. From fresh, they have to enforce the order. Earlier orders will vanish. Kindly see the sanction letter, my lord, at page
No,
71.
read further events.
Yes, my lord. And application filed seeking for extension of section 14 order. NCLT was allowed on 18. Physical possession was taken and Panchanama was done on 5/9/2018. Joint memo 19/9/2019. Repossession application was filed on 27/12/2022. That application was dismissed. Repossession, they are seeking repossession before the magistrate court, not physical possession. Once they have taken possession, once the joint memo is filed, fresh sanction was obtained, possession given back to me, then they are seeking repossession from again filing fresh application.
What is this? What is this?
It is, my lord, he was going on. I did not want to interrupt. Again, my lord, your lordships have seen my application.
No. You have initiated the proceedings on the
First
Surface
round of
Act.
litigation.
You have initiated the proceedings on the Surface Act, declared NPA 13/2, 13/4, 14.
Yes.
After 14, again you restructured the loan.
No, my lord, restructure, kindly see
On
this.
19/5,
Not only
2017.
restructuring, my lord, resanctioning. Further sanction was made. Further
No.
sanction was given.
After 19/5/2017,
Yes, madam.
when did the account was declared as NPA?
My lord, I'll just, because he has served it to me just now, but only to maintain the continuity, what he's repeatedly.
Look into this, password.
Yes, ma'am. I'll have a look at it.
Password.
2:30. I'm so glad.
Cell number 6. Cell number 6. KV Banu Prakash.
No representation on behalf of the petitioner. List this matter for disposal tomorrow. Yes.
Cell number 7.
Appear for petition, Lord. Kindly pass for your lordship. Senior will argue, lordship. Is held up in other court.
Give that.
Sure. I'm filing memo for service. Lordship.
They're already appearing.
Yes.
My lords had redirected this matter be listed today. I filed my wakalatnama for R2 and R3 in the morning at the counter. The auction for which they've asked for an interim stay is presently taking place between 12:30 to 1:30. My submission is on a very straightforward point of law, my lords. There's no impugned order. This is a mandamus for me to accept a right of redemption which is already seized in its entirety. The writ petition itself is not something that has to be entertained. I'll bow down if they want to pass over, my lords. I'll make the submission. It can be disposed today itself.
Yes.
Pass.
Cell number 8. KS Ponnappa.
Why the office objections are not complied?
My lords, this
Ashok Kumar.
writ petition was filed because respondents were trying to sell the property in spite of there being moratorium, my lords. We have received an instruction saying that they are not going forward with the sale. We are waiting for the return confirmation, my lords. My lords may have this matter third, my lords. A connected matter is coming up on the same date. We are waiting for the return confirmation from the respondents saying that they are not going forward.
Which is that connected matter?
Lords, I'll check the matter and tell my lords.
Yes, give the number to the court officer.
Yes, my lords.
List along with so and so on 3rd November. Yes.
Serial number 9. VS Jayant Krishna.
Appearing for the petitioner, my lord. This matter, I seek permission to appear on behalf of the respondent. Yesterday, they have served the summons.
About the car.
About the commercial vehicle, please, once. My lord,
What are, according to him, what did he say? That he is not aware of any of the proceedings. Following, without any procedure, you have, you are going to sell the vehicle.
my lord, first of all, my lord, no action has been taken under surface. For filing
That's
the
what I
present-
asked him the other day.
The entire proceedings has been initiated under arbitration. He has alternative remedy to challenge the award under section 34. He has a remedy of section 9 also. As of now, no auction sale notice is also published. I don't know, whatever the entirety, what they have submitted, and with regard to the facts, my lord, what they are stating is around 48 lakhs. In fact, the outstanding amount is 1 crore 10 lakhs for both the accounts. That matter has been suppressed. There are 2 loan accounts. In fact, the petitioner has purchased 3 vehicles. 2 vehicles has been seized. 1 vehicle he has hidden that could not be seized till date. And apart from that, this thing, 2 vehicles outstanding amount is around 1 crore 10 lakhs. He has the alternative remedy to approach, and moreover, he has not paid the EMI from past 15 months. Kindly see when the loan was sanctioned in the year 2024. Right from beginning, he has.
May I submit, my lord? For a moment, if my lords look at annexure A, page 18, my lord. Their letter clearly goes on to say it's reference to the loan and the hypothecation agreement dated 4/3/2024. They themselves says we have due of installments, and they say on 12/8/2025 we have repossessed the vehicle. Lord, to repossess the vehicle, there are certain rules and regulation which has to be followed. My commercial vehicle was on road with all the materials.
No. What is the rule? Show the code.
My lords, may kindly pass over as per RBI guidelines. They cannot seize the vehicle also after 6 p.m. They have done such an act.
And what is no surface proceedings are initiated?
My lord, their letter is very.
No, he's submitting that.
Now,
It's not that it's surface proceedings.
But he goes on to say in the second line, my lord.
Last occasion also when the matter came, this is a specific question I asked.
Please, my lords.
If it is basing on a contractual claim between the parties, if some action is initiated,
Lord,
have a remedy.
I have sought 2 prayers in the writ petition, my lord. To read, I am ready to pay the installments, my lord, because my livelihood is very much involved in that. And there was a mediation also to that extent, my lord.
What is the amount? Outstanding
Lord,
is,
outstanding-
according to him, 1 crore 15 lakhs.
They doesn't even state in the letter, my lord.
No,
For a
he's
moment.
saying- now he's
Now
saying-
they are saying, they are very silent about the amount. They say on 15th of October, if you have any offer to get it, get the intimation.
No, if you're ready to pay the amount,
We are ready, my lord. We need,
whatever is the amount, not what you say, what the bank say is the amount.
let them regularize my loan. Entire EMI will be paid from my side, my lord.
Lordships, may kindly see Annexure B, what he has produced.
Annexure?
Annexure B, page 22, statement of account. It pertains to one account. Outstanding is 55,47,000 as on February 2025. The next annexure sees another statement of account. The outstanding is around 54,35,000. So in all, it will come to around 1 crore 10 lakhs.
But I have not suppressed the fact, my lord. Even I have said my loan amount is that much.
Procedural aspect also with.
But even I have paid certain EMIs. They have not deducted.
All this writ petition cannot be entertained, number one. In spite of that, you are submitting about payment, like you're ready to pay. If you're ready to pay, what is that? You have to tender court.
Please. Once I'm ready to deposit the EMIs within 4 weeks, my lord. Let them redelivery of the vehicle, my lord.
Repossession, it can't be.
So that you will know the other 2 vehicles also you will hide somewhere.
No, my lords, we will undertake.
Already
Because
you
I have entered into a contract. The contract of the road is going on, my lord. I am earning. With material they have seized, my lord.
No, 1 crore rupees, we will not wait till 4 weeks for you to do.
The EMI comes around 1,07,000, my lord. Because my bills are pending. I will be getting my payments.
Last 15 months you are not paying. For 15 months outstanding would be how much per month? How much it is the EMI?
EMI is around 1.5.
1 lakh.
So 1.5 into 15.
That is for one contract. That is for one contract.
Yes.
So it will be around
1.5 into 15. That is 3 into 15.
3 into
please,
45 lakhs.
45 lakhs.
First of all, you deposit 45 lakhs. Then whatever shall follow, shall follow. Otherwise, I'll not interfere with it.
But I'll take instructions, my lord. We are ready to deposit. It may be taken up on Friday. I'll ensure
Friday.
that for the.
And that day I will.
Please, my lord.
If instructions or
My lords,
otherwise. I
My
will
only
discuss the
request, my lord, the EMI comes up to 45 lakhs, my lord. I am ready to deposit 20 lakhs. Let them give 1 month time because I am getting the bill due. I will run the.
Come up with the affidavit, we will see.
Please, my lords, please.
Let them come up with an
Let
affidavit.
them approach the bank, my lord. My instructions
We
is
will.
if they are ready with the settlement, let them approach the bank
Then
directly.
counsel appearing for the respondent submits that the bank is ready for a settlement. Then counsel for the petitioner submits that he is ready to pay the outstanding EMI of 45 lakhs if in 2 equal installments, the petitioner shall approach the bank. This is matter on, we'll have it on 10 November.
Then much of it.
Yes, next.
Please, Manoj, obliged.
No representation on behalf of the petitioner. List this matter for dismissal day after tomorrow. Yes.
The petitioner.
Huh?
Serial number 10.
10. Yes. What about the hand summons?
My lord, file had come yesterday at 3 o'clock. Hence, my lord, 1 day's extension may be given. And my
The
lord, one
petition-
small submission in that case, my lord. My lord had, on the last occasion, inquired into the annexure A that we have produced. That is the entire statement that we have produced, my lord. My lord, the payment from the petitioner is being made and it is reflecting in the statement, my lord.
Again, it shows that it is stopped, payment is stopped.
No, my lord, that is the clearances that the bank is sending. Subsequent to which,
Let the bank come, we will hear it from the bank. The counsel submits that he couldn't take out the hand summons and seeks time. The petitioner shall take out the hand summons and file a memo by, I'll take it up on 3rd of November.
my lord, any
No interim order. Or if you want, I can take it up on 30th, 31st, any day.
my lord, any week,
No interim order.
my lord, from our end, my lord, we are making the payments, and that,
That is not what it discloses. You are understanding it in a different way.
please, please, my lord.
Yeah, are you ready with the, when do you want? Please tell the court. I'm not going to pass any interim order. When do you want?
My lord, Thursday,
On Thursday. This is a matter on Thursday. Yes, next.
obliged.
No, 11. Yes.
I'm for the petitioner.
What is this council submission on office objections?
There is a interim order. We sought for the interim order, wherein we sought for direction to the bank to not to deduct the EMI on my account. That is the reason the office has raised the objection, not sought for any direction in the interim prayer. Your Lordship, there is a tripartite.
The High Court will grant such a direction, not to deduct from your account.
Your Lordship, in connected writ petition, Your Lordship, there is a fraud played by the respondent number 6
Papers were
builder.
notified for rectification of the following. Direction not to be sought at interim prayer.
In the connected writ petition, Your Lordship.
What is the main prayer in this writ petition?
Main prayer, Your Lordship, kindly see, in internal page number 10, wherein directing respondent number 4 and 5 bank financial institution to cease desist from recovering pre-EMI and EMI payment from the petitioner against the fund disbursed by them to the respondent number 6 developer until the
So
date
your
of
interim prayer and the main prayer are one and the same. That's what
Your
they
Lordship,
said. Your interim prayer and main prayer are one and the same.
Your Lordship, interim prayer is till disposal of this suit. In the connected writ petition, Your Lordship, in internal page number 244, annexure K1 and K2, there are several petitions
Directing
is
the
filed.
4 and 5 financial institution to cease and desist from recovering pre-EMI and EMI payments from the petitioner against the funds disbursed by them to the respondent number 6 developer until the date of possession.
Your Lordship, what happened?
What is the jurisdiction of this court with all this?
Your Lordship,
Why should we exercise a,
Your Lordship, for a moment in annexure K1, there is a several petition is filed before this honorable court. The respondent number 6 is the huge builder. He has played the fraud to the more than 2,000 innocent purchaser. He has entered into a tripartite agreement with the bank and borrower, and he has taken the entire huge amount from the bank, and he is not paying the EMI to the bank.
make the bank, make the developer all parties and file a civil suit
Your Lordship,
and seek a direction to the bank not to do any of all this.
see that what they have scheme has introduced, that is against the RBI rules and regulation. That is the similar kind of writ petition.
Where
is
did you
pending
question
before this
that?
honorable
Where
court.
did you question that? A
Your
particular scheme which is contrary to the RBI guidelines. Where is your prayer to that?
We have taken the contention, Your Lordship.
No contention. What is important is your prayer.
Your
Where
Lordship,
is the prayer?
Your Lordship, second prayer, kindly.
Let's see.
Issue upper read direct and respond number 4 and by to finance. The fourth prayer, Your Lordship. The sixth
Refunding
prayer,
in
issue
my-
upper direct Reserve Bank of India and National Housing Board to instruct
When a
all the
director
banks, finance
take any
institution,
coercive
non-banking.
action.
Please, Your Lordship.
Please tell the court at least one of the prayers of
The
yours.
sixth,
Can
the
it be
sixth
considered
prayer
by
in
the court?
internal page number 11. The sixth prayer in internal page number 11 in prayer column.
Issue an appropriate writ directing the Reserve Bank of India
to National Housing Board, respond
instruct all the
to
bank
instruct all the
financial
banks,
institution.
non-banking fund company to restructure all the loans accounts available by the petition on its project to protect the interest of the home buyers. Your Lordship,
What is
similar
this
kind
prayer?
of writ
No,
petition.
no. Is it a public interest litigation or what?
It is not, so far as concerned this petitioner.
This
Your
is not a
Lordship,
public interest litigation
it is
where
not
this
a-
court will direct all banks, all financial institutions, non-banking financial companies.
Your Lordship, several petition is pending before this one on the same respondent. They have cheated more than 2,000 petition. Kindly see the annexure K1 and K2. Where then 100, 200 members have filed the petition before this one court and they have sought for the interim order. And this one court also granted the interim
Where is
order.
that? Where are those interim orders?
That is annexure K1 internal page number 244. Your Lordship. That is one petition. And in another petition 5148 of
Look
20.
at the first one. 240?
244, Your Lordship. Annexure K1. Wherein he sought for the interim order in internal page number 245. In bottom, Your Lordship, as an interim relief is paid to issue appropriate order to direction to
Where is this
respondent.
WP 17473 of 2021 order?
That is
Just
the interim
order as in WP number. There should be a reason for the court to grant
that
interim
I will
order.
produce. That I will produce. Detail order I will produce. This is the interim order passed in this writ petition. Your Lordship. In writ petition number 18713. And thereafter writ petition 5148 of 2024 also on the basis of the same order this Sanam court has passed there. I will give you the details of the it takes nearly 50 writ petition is pending before this Sanam.
Give all the numbers. We will take all the writ petitions.
Please. Until then.
As a registry to verify all the connected writ petitions to this number. Yes. List along with all the connected matters on 12th of November.
Your Lordship, office objection may be over.
Office objection? Because such a prayer is not, your interim prayer, your main prayer is one and the same.
The writ prayer is till disposal, the interim prayer is till disposal of the petition. That is for permanent.
Office objections or sustained?
Your Lordship, till then interim order.
No,
what
no,
is
no.
granted
I will
in
not grant interim order.
Connected writ petition, same.
Let it be, let it be. The order which you have shown to this court is without any reason.
The
And
same,
you place an order which shows the reasons. Unless and until an interim order is granted recording the reasons. This court, that's not binding on this court. Even otherwise also.
please, Your Lordship.
Yes.
We'll furnish all the details.
Yes.
Guarantor's petition, and there is an order in the SCA filed by the petitioner imposing a condition that I shall deposit 9 lakhs within 39.
Where is the order?
The order is Annexure D, my lords. I have to deposit 18 lakhs, out of which I have deposited 9 lakhs, my lord. I have produced the account X. Annexure E, my lord. I have deposited 9 lakhs on 1810. And this is virtually a mercy petition seeking extension of time to deposit the other installment. Because here it so happened, my lord, this is a residential house where they are residing with the family and children. And unfortunately, the borrower who was running a crusher, my lord, that all the crushers in Mysore district were closed by the DC. And the borrower was supposed to get subsidy amount and that was not paid. Therefore, I approached this honorable court. Annexure A may kindly be seen, my lord, and a direction was issued to release consider my application for the subsidy, which has not been done yet, my lord. And that apart, the wife of the borrower is suffering from cancer. I have produced the medical certificates also. Under these circumstances, I am appealing to this honorable court to please extend the time by 1.5 months to pay the second installment.
How can this court do that? No, it is an interim order. There is
Please.
absolutely no illegality with the said order. The court has granted stay of all further proceedings,
Please,
DRT, by asking you to pay
In
the
fact, it's
amount into
virtually in the nature
installment.
of mercy petition.
But
I have
what-
sought for-
the problem is court understands the difficulties, but court should have the power to exercise it.
Court can definitely stay it subject to the condition that I shall pay it after 45 days or whatever period the court fixes.
No, this order was, you are
And
supposed to
that
pay
shall be subject.
by 39/20/25 year after a month. Unless and until the
No,
main
30/10, my
deputy-
lord.
Huh?
This is 30/10. Day after tomorrow, I have to pay the second installment.
First installment also you have paid after a month.
No, that I have mentioned the reason. That was a mistake by the council who did not inform the this borrower or petitioner.
Let the bank be before this court.
No, my lord. It's
petition
Day
is-
after tomorrow, they'll take possession.
Petition is permitted to take out hand summons on the council, on the bank, appearing for the
So
respondent.
your lordship may kindly make it a conditional order that if I don't pay the amount by that time, let the bank proceed to take possession, my lord. Your lordship, this is a mercy petition because the entire family is residing there. Subject to that condition, my lord. Otherwise, your lordship may kindly, they let the interim order be vacated.
Problem is, interim order is granted provided the writ petition is maintainable. Writ petition itself is not maintainable. Where is the question of granting?
Petition
interim
is
order?
maintainable, my lord. It's only
How
to.
it is maintainable, please tell the court.
This is only to modify the order of the conditional order. That's all, my lord. To modify the
Then for
conditional
that you
order,
have an option of going to DRAT, not before this court.
of course, there is an option.
No, court has exercised its discretion and passed an
The
order.
mandatory provision, not discretion, but it's mandatory.
Mandatory.
I stand-
Granted, what is wrong with
Please,
this
ma'am.
order?
No, it's only a mercy petition as I submitted because take into consideration
I
the
will grant provided you, which bank is this?
Bank of Baroda, my lord.
Who appears for Bank of Baroda? Who are the counsels? You appear? You appear?
I appear.
Mr. Vignesh Shetty will get instructions in this, is directed to take notice on behalf of the respondent bank. List this matter on Wednesday.
Let them not precipitate on 30th, my lord.
30th, I'm asking him to come back by 29th. Yes, 29th, the counsel for the petitioner shall tomorrow, shall serve the,
Copy served, my
Third,
lord.
my lord. I'll take it.
sir, yes,
Just,
next.
I beg to appear on behalf of my lord, respond in this matter. It's a matter, my lord. Lord, my securitization measure, my lord, SL before this one. Kindly come to my lord prayer at my lord page number 12 and 13. 12, my lord. The sale notice dated 23/7/2024. That is at my lord page number 18. And my lord,
To set aside the notice dated 13/8/2024.
13/8/2024 and my lord sale notice. The 13/8 notice is my lord pursuant to my lord order under section 14. I my lord given a notice to the my lord borrower. I'm going to take the position of the property since the account become NPA and we have issued 13 to 13/4.
Then
And
what happened?
Next, please my lord. Next is sale notice where my lord I supposed to conduct the action for want of bidders. This honorable court granted interim order subject to my lord some conditions. Confirmation of the sale is stayed. However, my lord, for want of bidders, I am not able to conclude the sale, my lord. Therefore, my lord, the relief sought in the present petition will become infractious. First submission. In respect of my lord, annexure, my lord, the notice dated 13/8/2024. That is a notice, my lord, which I indicated that I am going to take a position of a property. That, my lord, they can go before the DRT, my lord. That it is not maintainable. That is my respect for submission.
So when is the next auction? You have not issued
I
so
am not
far.
issued so far, my lord. This is an interim order operating in this matter.
Please
We have,
come.
Your Lordship, we have already made a payment of 2.5 lakh rupees, Your Lordship.
Order made with
And
What
we
is
have
outstanding?
9 lakh, that is 9,37,802, Your Lordship. We are ready to pay the entire amount, Your Lordship. Provided a sufficient time is given, we are ready to make the full final
What is the time?
At least 6 weeks' time, if it is given to me, I will make the payment, Your Lordship.
The interim order operating from last 1 year. I'll leave it to wisdom of this court. my
File an
lord.
undertaking, we'll list this matter on 6th of whatever you're saying now.
Yes, Your
Then
Lordship.
counsel for the petitioner submits that the outstanding is 9 lakhs and odd. Already 3 lakhs is paid.
2.5 lakhs.
2.5 lakhs
Pursuant
is
to order
paid.
made by this honorable court.
Huh?
That's interim
Interim
order.
order.
No, as per the interim order of the court, they paid 2.5 lakhs. And they are ready to pay the remaining outstanding within a period of 6 weeks. In that regard, an affidavit shall be filed before this court. Then counsel for the respondent submits that the sale notice that is questioned before this court is dated 23/7/2024, and on that day, they couldn't conduct the auction. There are no prospective bidders. List this matter on 6th of November.
Great.
File that.
Great.
Yes. I number 1025, filed for early hearing, is ordered.
Petitioner, we have filed a rejoinder yesterday. Any date may be fixed for final hearing, my lord.
Let's see.
Sir, we are also led by a senior counsel in this matter, my lord. And we have filed a rejoinder yesterday. It has to be put
Thought,
up
my
before
lord,
the.
I'll just in a nutshell, what the petition is, it's filed by your lordship. You can see one of the ex-director of UB Group, Kingfisher. Now, my lord, this writ petition reads more in the nature of an RTI application where he seeks a direction to the banks to disclose certain, how much have been recovered, how much properties have been attached. All of that, my lords, I'm already before the company judge. Or liquidation proceedings are going
Let's
on.
see the prayer. What is the prayer?
My lord, if my lords, page 62, my lord.
First read.
In the first read. 3357, yes. Triple.
3357 is before the court.
Correct, my lords. Page numbers, I think 62 is the prayer. Same
Issue a
prayers
writ
in
order or direction in the nature of mandamus to provide statement of accounts.
Respond 2 to 12 are the
by
banks, my lords, consortium of banks.
How is it maintainable before this court? Why should this court entertain all this?
No, kindly see prayer.
No, company petitions are there, company application. If you're interested, go implead yourself and get all these details.
No, the pleadings are complete, my lord. We are led by a
No
senior
pleadings,
counsel.
this is not a big case that the court has to complete the pleadings and hear everything. On the face of it, the prayer is not maintainable.
No, 14.2, 14.1, my lord. I'm the ex-director of the corporate debtor.
All the more reason that you have to go before the company, where the company petition is pending. As far as this, what is this? The United Breweries is.
My lords, I am appearing for the official liquidator. In fact, we filed an identical application seeking details from the State Bank of India. They've already furnished some details. That proceedings are already pending. Now, this is an
No, that you
ex-director
have asked before
the company court.
That's
My
what-
lords, and in fact, he is an ex-director against whom I filed a misfeasance petition for 17,000 crores. I do not believe he has any locus to maintain this petition itself.
No,
All I see-
whatever it is, but still, this is not, under the Surface Act, whatever, you cannot, file this writ petition before this court. Whatever all these details you want, if you can go before the company court and
All I
seek
seek
from
for
the
today
company
is one
court.
short
My lords, there's an
adjournment, my lord.
express bar under section 446 of the Companies Act.
Yes.
If my lords would
I seek for
kindly
the
see
short
that last
adjournment for
prayer
today, my
also.
lord. Because we had filed the rejoinder yesterday. We have instruction to engage senior counsel. One short adjournment, my lord.
What is happening in this?
Only notice was issued.
Notice was issued, but on the last day, statement of objections were filed. And yesterday I filed my rejoinder.
Let your senior counsel come.
Please note, one short
We'll
adjournment.
dismiss it in his presence.
What, just to
Let's
complete
just matter on.
Just to complete the narration, what is in fact happened, my lords, is Mr. Malya is facing insolvency proceedings in the UK. Now, my lords, all of this, he wants some information to help his insolvency proceedings there. In fact, recently he withdrew those insolvency proceedings because this matter was pending. So now if some information, whatever information comes here, he'll use it in his insolvency proceedings. So that is the larger game.
Whatever is ultimately the motive of the parties, maintainability is what this court is concerned. It's not maintainable. You take your, let your senior come. We'll have this matter on 3rd November.
I request for 27/11, my lord.
Huh?
Last week of November, my lord.
No,
We
no,
engaged
no.
the senior
My
counsel
lords,
from-
one request, my lords,
based in-
both my learned friends, third, they have some difficulty. Fourth.
Yes,
it will be
fourth.
possible.
Great.
Yes, next.
We have engaged senior counsel based in Delhi, my lord. 27/11, my lord.
Yes, next.
Great. For the petitioner in this.
Yes.
Pleading applicant.
Could your lordships in this kindly see the order passed by this honorable court on 17th of September, where the bank was directed to place on record the decision taken regarding an OTS.
I may permit it to Millard producer. In fact, I served a copy of another, sir.
seized by not by the applicant, by different person.
First respondent has brought the subject property, a secured asset, for sale with the petitioner having successfully participated. My lord, order dated 17/9. I'm just reading.
This is a matter which came up yesterday.
No, that hasn't come up since vacations.
Oh. So what is the writ petition about?
I'll just point on one. The writ petition, my lords, is filed by the auction purchaser. Again, my lords, in a nutshell, what this is, my lords, there were 25%, we were the successful auction purchaser.
When was the auction conducted?
Auction was conducted on 24/2/2025.
What was the
Total, my lords, approximately about 16 crores. We deposited 25% undisputedly on the same day. Then, my lords, what happens is this honorable court on 14th of March 2025 orders a status quo qua the property in a writ petition filed by who is this? By the guarantor, by the borrower, by the guarantor. So there's a status quo order on 14th of March. Then, my lords, on 18th of March, the bank writes to me saying, please deposit the balance amount. I tell them that, see, there is this writ petition pending. I cannot deposit the balance amount. So therefore, I will, please wait, let the writ petition get over. Then, my lords, finally, on 13th of August 2025, this honorable court disposes of the writ petition saying, let the stay be extended by a period of 3 weeks. Please approach the DRT because it's not maintainable before this honorable court. Then, my lords, the guarantor goes to the DRT. Another guarantor goes to the DRT. And, my lords, a status quo is once again ordered by the DRT. In fact, there's a express direction not to confirm the sale. So in those circumstances, my lords, I am left between the two rivals, the banks and the borrower. Then, my lords, what happens is I receive a letter which I've impugned before lordships, cancelling the sale, saying, please take back 25%. I write back saying, I will not take back 25%. Please pursue the matter. They write to me saying, no, I am pursuing an OTS with the borrower. And in fact, overnight, they transfer the RTGS amount into my bank account. In fact, there's a little bit of a tennis match saying, my money comes into my account, I push it back, they once again push it back. So that is where we are right now. Therefore, this honorable court felt, let the OTS decision be considered. If there is in fact, there was a misrepresentation on the last, I should also point out. If your lordships were to kindly see, there was a submission made that 14 crores was deposited. Today, my lords, I have received the memo saying only 7 crores was deposited. So there is more
by the guarantor.
By the guarantor. In fact, by somebody else. In fact, I don't even know who this is now.
My lord, 8 crores was deposited. There is another 5.50 crores which is ready with a demand draft. I represent the impleading applicant, that is the borrower, my lords. There is a demand draft of 5.50 crores which is ready, and already we have deposited 8.50 crores in terms of the OTS proposal, my lords.
No, like bank is used to, taking the money of the borrower as well as the auction purchaser.
In this case, my lord, they're not
No, you keep both.
No, my lord, here I refunded the money. My lord, kindly see the fairness of the bank in this matter, my lord. I am entitled to, my lord, forfeit their entire money in view of, my lord, non-compliance of Rule 9(4). In fact, my lord, I refunded the entire money. Lord, I'll just point out, my lord.
When the court passes an order to maintain status quo, what is the purpose of he paying the money?
My lord, I'll just point out. Status quo the property. I'll just point out, my lord, the order passed by this honorable court.
So who wants to enter into a litigation by giving the entire amount and it goes on?
Rule 9(4) and 9(5) mandates for the auction purchaser to pay the entire money within 15 days or subject to, my lord, extension of within 90 days. So please, he should come and request for, my lord, with a request for an extension. My lord, here the case where this honorable court grant an interim order, status quo the property, not in respect of the, my lord, transaction. At either, my lord, he would have come before me and, my lord, sought an extension, or he would have paid entire money. That is the, my lord, the honorable apex court in, my lord, various judgment. Now, my lord, in fact, 90 days after that, my lord, I can't even, my lord, there are various judgment from this honorable court as well as, my lord, honorable apex court. I can't consider in 1 day extra. At the most, either I have to, my lord, auction it fresh or I have to forfeit his money. My lord, kindly see the fairness of the bank here, my lord. I returned his money. Thereafter, my lord, what had happened in this matter, my lord, on 24th, my senior counsel rightly pointed out, I sold the property. In fact, my lord, for an amount of rupees, I just, my lord,
16 crores.
16 crore rupees, my lord, there are 2 trench of property which I sold. I sold it on, my lord, 24/2025 for, my lord, one of the, my lord, property purchased by the petitioner, which, my lord, confirmation or, my lord, whatever letter of, my lord, intimation of the sale, my lord, given to, my lord, petitioner, wherein, my lord, he is supposed to pay within 25% of the money next day as per Rule 9(3) and 9(4). And, my lord, remaining money either, my lord, 15 days he is having. In the meantime, the borrower came before this honorable court. My lord, he is contested on various issues, including, my lord, jurisdiction and, my lord, and redemption of mortgage.
That time the auction purchaser was not a party.
I was not
made a party.
He not made a party by the borrower. My lord, borrower.
He was aware that the auction was conducted by then.
Please, my lord. In fact, he is choose not to appear before this honorable court. That is his choice, my lord. He is not.
He was a party.
He was not party. That auction purchase is
My lord,
not.
it was not disclosed to us, my lords. His details were never disclosed to us. So we had filed it just against the bank.
Apart from that, no, at any time, my lord, that writ petition, my lord, landed in the writ appeal. That is different aspect. No, my lord, kindly see the, my lord, conduct. No, my lord, my lord, within 90 days, he is not paid. Left with no other option, either, my lord, I have to forfeit as per rule 9(5), or, my lord, I have to, my lord, conduct a fresh auction. I returned the money, and in the meantime, my lord, borrower came forward to me, and he wanted to settle. My lord, in fact, I sold it for 16 crore. He said, I'm going to settle under 33 crore.
You returned and you cancelled the sale.
Cancel the sale, that is a cancellation, a sale before this honorable court. My lord, in fact, I returned the money, and my lord, I accept the one-time settlement offer, which we brought before this honorable court, my lord, notice on the last date of hearing. This honorable court considered. In fact, that is a document which I placed before this honorable court today.
Yes.
The only issue
At
is
the
this,
most, my lord, the petition entailed some interest, which, my lord, others, last day, my lord,
In fact, on the last date, we have made a submission. Any
I need to
solitorium,
pay.
we are ready to pay. Any solitorium which this honorable court deems fit in the circumstances, we are ready to pay, my lords.
Only 2 points, my lords. One
Now
is,
here,
I understand.
the simple issue is, now there is an interim order. In spite of an interim order, as you're paid, you're a successful auction purchaser, 25% you're deposited, you are bound by the terms and condition of the auction. As per that, you have to pay the remaining
doubt,
amount.
no doubt.
Because of the fact that the litigation is pending, you have not do, but technically, legally speaking, that will not stop you from paying the amount.
Was that there? I quite see what your lordship is saying. I'm not for a moment or disagree. The only point there is, my lords, I wrote to the bank. The bank also, at that point, kept quiet about it. If they were so,
When did you write to the bank?
I wrote to the bank as early, my lords, as on 19th of March 2025.
19th March.
19th March.
Hmm.
The first time after that, where I received
What did you ask the bank?
I asked them, my lords, this is precisely what I say. Furthermore, as per the case details available to us, the Honorable High Court in WP number so-and-so has issued an order for status quo. Given this, it is perplexing that you have sent a letter despite the existence of the status quo order. Please note that. So therefore, the letter in question holds no legal effect unless the High Court vacates the order. This is what we read. Then, my lords, the bank also stays quiet while the writ petition is pending. The first time I receive a communication once again after that is 28th of August.
28th.
28/8. For the first time since 1903.
We're asking you to pay the money.
Again asking me to pay the money. In the meantime, there is a specific, at that stage, there's a specific direction by the DRT not to confirm the sale. Now, if there was any dispute, which I would respectfully submit, there's no dispute, but if there was any dispute, the DRT made it very clear saying, don't confirm the sale. So there, they can't rely on status quo or not status quo. They said, don't confirm the sale. In fact, the bank, interestingly, goes and makes a submission to the DRT saying, we have confirmed the sale. Kindly see the DRT order, Malas. That's at page 25, minutes. Annexure F. I'll just read heard both learned counsels. Counsel for the applicant submits that the respondent bank has not confirmed the
respondent
sale.
bank submits that confirmation of sale is already done.
So therefore, there's a lot of flip-flopping
What is
happening.
that? What is that statement before the?
Well, confirmation in this case, my lord, done. My lord, now also we are, my lord, kindly see their own letter. In fact, my lord, I'll just point out to us. My lord, kindly come to.
When was the confirmation done by you?
I'll just point out, my lord, 1 minute. My lord, before that, kindly come to page number 20.
No, without paying the amount, how would you confirm the sale?
My lord, confirmation, my lord, what will happen, my lord? The moment he is paying 25% of the money, I'm liable to issue a confirmation. Sale certificate after payment of entire money. Here, confirmation, I'm bound to do. The moment he will pay 25% of the money.
When the notice is issued on 19/3/2025, asking you to pay the money, what did you do, petitioner?
He's disputed my sale itself. Except, my lord, disputing my sale, my lord, that's what I wanted to point it out. Except, my lord, disputing my sale. One or the other allegations he's putting on me. My lord, he never come before the bank either. I need
What is his response to 19/3/2025?
My lord, which 19/3?
Annexure
It is not a part
page
of
24. Page 24.
24.
There's a quietus, Malas. For a while, there is a quiet.
Acknowledge receipt of your email, however, we know that well you're like. So I think now nothing much to dwell on this.
Correct.
Only thing is, what about the money was lying for how many months?
It's been lying.
4
since,
months, my lords. 4 months, my
No,
lords.
not 4 months. March. Sorry, February. February 2025.
Two?
Now, Malas, but my only request is now, even that OTS, which we have challenged now, Malas, they make a statement saying we've paid 14 crores. Now, Malas, my learned friend candidly submits, no, 14 crores are not submitted, was not paid. Now he says.
Now it is like this, as far as the purchaser is concerned, cancellation is valid or
quite-
invalid.
yes, yes.
Once the cancellation is valid, the other things that's between the bank and the.
Borrower.
No, the
and
only,
the borrower.
I'll just leave it at this. There's more to it than meets the eye. The conduct of this auction, the borrower, my lords, speaks for itself. But I understand what your lordship is saying. There's only that much I can also push. Beyond that, and of course, my lords, there are Supreme Court
That's very-
judgments.
No, I'm surprised to know, writ petition by the borrower, direction by the court to pay the amount. Then they will take the amount because they have no other option. Then they will cancel the sale. And the purchaser will come, auction purchaser will come. He'll also have an interim order. He will also have an interim order and he will deposit the amount.
No, I don't have an interim order.
Not in your case. Generally, I've seen that study he was
Generally,
referring
of course.
in the other
Lordship is
matter.
hearing BRT every day.
So no, here, before this court, he has another order.
That's what happened.
So no, he has the money of the borrower, the money of the auction purchaser. So I said keep both because the court has directed him. Yes. So for whatever, the months that amount is lying with you, he says, what is the interest on that?
My lord, last occasion they undertook before this honorable court at the rate of 7%. I will leave it to wisdom of this court, my lord.
We
My
will
lord may
leave it
fix they will pay.
to 7%. We are ready, my lords.
Well, your lordship could have it next week. Let them come forward with a.
They're
Of course,
ready.
there is no.
No,
interim order, so
7%,
the
I'm
tendency
ready,
will
my
not
lords.
make a
I'm ready, my
difference.
lords.
I'll say
Today's-
that it is
I have
undertaken
instructions,
that they-
7%, we are ready, my lords.
Sorry, Malak, I couldn't.
No, I'll record that with 7% interest, they are ready to, sir, because the money anyhow is returned to you or you sent it back to them.
No, with them only.
No, that is, now it is in our
Them
court.
only.
Yes, it's sent
So
back.
whatever it
Since
is,
September,
that
it has
all
been with them,
In
my
between the shuttling, whatever is
Yes,
the.
now it's in our court.
Whatever is the interest for that amount, as it was with them, let them pay that.
Could I just seek a short, maybe in the afternoon, if I could get back regarding, or tomorrow, Manoj, I'll just, tomorrow morning.
Tomorrow will pass.
Grateful minutes.
Yes.
Grateful.
Lords, senior is appearing in this matter. Yesterday, he had that road infraction, my lords. On 5th, the other matters are listed. 5th,
This is matter on 5th.
please, ma'am.
Yes, next.
I appear for the petitioner.
Who appears for this Housing and Urban Development Corporation?
Issue and summons to earlier,
Who is the council?
one Havaldar has come on the.
Please write a paper.
Please.
Land council submits that so-and-so. The land council, so-and-so is directed to take notice on behalf of the respondent. Land council, the petition shall serve the, the writ petition on the council. We can have it on Thursday. Any urgency or on the next? I'll list the
after 10
matter
days,
on
madam.
18th of November.
Please.
Next. Passover. Yes. Kotak Mahindra, who appears? He was. You appear? Serve him papers.
I'll serve, my lord. As hot
I will
for-
take up tomorrow.
Please.
So-and-so is directed to take notice on behalf of the respondent bank. Then counsel for the
Please, sir.
petition shall serve the copy of the petition on the council. Get instructions by tomorrow. Yes, 21?
I'll hand it over right.
Yes.
Please.
Appearing for the respondent bank, I filed wakalat yesterday.
Yes.
Challenging the sale notice, my lordship, which is in page number 12, annexure B. The outstanding balance amount is 33,14,604. Sale was scheduled on 31/10/2025. I ready to deposit some portion of the amount, my lordship.
No portion of the amount. Substantial portion, we will interfere. Otherwise, no. Just the other case you have seen, that's what is happening. Neither here nor there. Yes. So 33 lakhs is the outstanding amount.
33 lakhs.
So how much you're ready to deposit?
The account became NPA on 18/3/2024. In fact, they approached the bank in between now for settlement. They give a letter
That's
for
what I said.
settlement.
Now
but-
he deposits substantial amount now, undertakes to deposit the remaining amount by filing an undertaking, then we will stall the proceedings.
Because he approached the bank for settlement, he gives a letter, then he files this writ petition.
Hmm.
This creates a.
Yes,
It's 5 to 6 lakhs, my lord. Then
that peanuts, we are not going to pass any interim order.
10 lakhs, up to 10 lakhs I can deposit.
So half of the amount, 15 lakhs you pay, 15 lakhs you file the undertaking before the court, then we will grant. Whatever is the time your client seeks, ask him to file an affidavit before this court. Accordingly, we'll stall that further proceedings.
15 lakhs within how many?
31st.
Sale is on 31st.
31st. 15 lakhs, it is very difficult to arrange the funds up, use 15 lakhs.
10 lakhs, 10, 10, 10, 10, 10, and then the remaining, whatever is outstanding, all this, what is the time frame? In that regard, you have to file an affidavit.
Pass over, my lord.
Yes, pass on.
The party affidavit, party is not there for filing the affidavit.
Let the affidavit, because 31st, there is still time. Let the party come and do it.
Can you have it tomorrow, my lord?
Yes, tomorrow, list the matter tomorrow. No, tomorrow is what? Tomorrow is 29th. 31st is the auction according to
Yes,
you.
yes,
We'll
ma'am.
have it on 30th. On that day, you come up with the affidavit itself. 30th, we will list on 30th. What's your name?
Natasha and Murthy.
Right, so and so. Submitted, she has filed wakalat today. Yes.
Affidavit to the
Yesterday.
extent that 10 lakhs within date of action.
And the remaining amount, what is the remaining amount? Remaining amount, when are you going to pay? 1 month, 2 months? Whatever is. Or give a
Once
copy
they
to
pay
them.
10 lakhs, what is the remaining amount? I'll inform.
Yes.
I'll do that.
Please be in, find out from her. Yes, 22.
My lordship, possession notice has been challenged, my lordship.
Which bank is this? Bank of India?
Bank of India. I
Who
am ready to
appears?
deposit some amount, my lordship.
Without the bank's presence, I will not grant anyway. Who appears for Bank of India? Please take the panel counsels for all the banks. Vignesh Shetty appears. Vignesh Shetty is directed to take notice on behalf of the respondent bank. He has matters afternoon. Please serve the papers. Let
Day
counsel
after
for the
tomorrow.
petitions or serve the papers on the council.
Tomorrow, my lordship.
Sale notice is when?
No, possession notice.
14.
Possession notice issued on 9/10.
We'll have it day after tomorrow. List this matter on 30th.
Obliged.
30th and serve the papers by that time.
Yes, yes.
Union Bank of India, who appears? You
Taking
appear?
appearing. Lord, sale is there on 30th, my lord.
On
Let them serve a
30th.
copy of the petition.
Where is he? They have moved the memo also. Passover, it's 142 for Passover.
Kindly pass over.
Passover. Yes, all of the matters in the afternoon.
My lord, one small submission. Serial number 15,
Ah.
previous, there is another writ petition, or it may be other. There is another writ petition filed by another auction purchaser. Both may be taken up together
This is
tomorrow.
13.
15, madam.
15 list along with that tomorrow.
Please.
Tell him, tell the other council also that it's adjourned.
Small submission. I moved in the morning regarding that 31st is the auction date is there. But I moved in the morning, the agenda is of tomorrow. I given it in the morning itself. I will note that you will go through it and sign it according to that. Because 31st is there without 15 days time.
But tomorrow is, what is the date tomorrow?
29.
Then I will look at the memo now.
Much. Kindly can be decided tomorrow. That's all. Sir, no move. Sir.
Sir, list. Sir, list. Sir, list. Sir, list 3, 4, 5 ಯಾವುದು ಅಡ್ಜಾಯ್ನ್ ಆಗಿಲ್ಲ ಸರ್. ಸರ್ ಸರ್ ಲಿಸ್ಟ್ 3, 4, 5 ಯಾವುದು ಅಡ್ಜಾಯ್ನ್ ಆಗಿಲ್ಲ ಲಿಸ್ಟ್ 3 4 ಸರ್ 4, 5 ಟೇಕಪ್ ಮಾಡ್ತಾರೆ ಸರ್ ಆಫ್ಟರ್ ಲಂಚ್.
Connected matter. Thought.
Sir, I, sir, sir, this person inconvenience your person, junior person. ಇಲ್ಲ, ಇಲ್ಲ. ಅದೇ ಒಂದು 2:30ಗೆ ಬಾ ಅಂತ ಹೇಳಿದ್ರಲ್ವಾ ಅದೇ ಇವ್ರು ಬಂದು ತಿಳಿಸ್ತಾರೆ.
ಹೌದಾ?
ಗೊತ್ತಾಗ್ತದೆ ನಮ್ಗೆ
And no, PO is not there. Okay, register chamber, VG. Okay. So, what about your lunch? Have you bought the? Okay, okay. Then, yeah, then tell Seema that right now I'll be sending after your lunch. No, I'm sending a draft of that new case, that is GSR sale. Okay, tomorrow is the sale, so we have to file it today and move the matter for tomorrow. End of the list. That is the reason. To do one thing right now, I'll be sending that GSR sale draft. Okay, she has to go and get the print and come here and take my signature. Parallelly, the client is also somewhere there, either near the DRT or High Court. So you should contact that client. I'll send the client's number to. I think she has his number. Yesterday I told him to contact me. So you have to go and collect it. No, take his signature before taking. And Bakalat is there in the. I think is there in the car. Car key is with me, no, with her only. Okay, so she has to get that wakalat, and after party signature, you come here. First, get the party to total 20, where we can take a signature. We have to do scan, e-filing. There's so much of work. Better don't wait there. After you're done with the lunch, no, don't wait there. You come back to the article. Sorry, High Court. High Court, no, before coming to 20, go to Ganga Xerox, take printout. See the, before taking printout, no, check the alignment. Check the alignment and take a printout in green sheet. Get one set for office copy. Yeah, office copy. Then yeah, I'll arrange all the annexures and just keep it. Come here and we can do pagination.
ಎಲ್ಲಾನು ಕರೆಸ್ಕೊಂಡ್ರೆ ಸ್ಲಿಪ್ ಇಲ್ಲಿ ಒಂದ್ ಕಡೆ ಇಟ್ಬಿಟ್ಟು ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಅವ್ರಿಗೆ ಕಳ್ಸೋಣ ಫಿಲ್ ಮಾಡಿ. ಏನ್ ಸಿಗೋಣ? ನಾವ್ ಹೋಗ್ರಿ ಸುಮ್ನೆ ನಮ್ ಇವ್ರ ಜೊತೆ ಹೋಗ್ಬಿಟ್ರಿ ಬಿಂದು ಜೊತೆಗೆ. ಹಾ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಅವರು ಈಗ ಎಲ್ಲ ತೆಗಿತಾ ಇದಾರೆ ಅದೆಲ್ಲ ಹಂಗೆ ಅಂದ್ರು. ಸುಮ್ನೆ ಒಬ್ರನ್ನ ಪರ್ಮನೆಂಟ್ ಆಗಿ ಸುಗುಣಗ್ ಹಾಕ್ಸ್ಕೊಟ್ಟು ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಅವತ್ತೇ ಹೇಳ್ದೆ ಇವ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ಟು PS ಗೆ. ಯಾರು? ಇಲ್ಲ ಇಲ್ಲ ಇವಾಗ ಹಂಗೆಲ್ಲ ಇಲ್ವಂತೆ. ಪರ್ಮನೆಂಟ್ ಆಗಿ ಇಲ್ವಂತಲ್ಲ. ಪರ್ಮನೆಂಟ್ ಆಗಿ ದಿನ ಒಬ್ಬೊಬ್ರನ್ನ ಕೊಡ್ತಾರೆ. సార్ సార్ నేను పోయి మాట్లాడండి.
For the passwords.
Passover matters, list number 1, serial number 3. List number 1, serial number 3. Jonathan. CH-20.
Why is it passed over in the morning? No, why is it passed over? Pass over it again.
Serial number 11. Serial number 11.
For the respondent in this case. Petitioner, my lords. This is a matter where the consent was given on 16/3/2023.
I'll ask the court to consider the MC, afresh,
My lords, the,
all framing of the issues and all.
my lords, the evidence part, everything has been over, my lords.
Evidence recorded on what basis?
Matters,
All through, I've just gone through the proceeding sheet.
Please,
It
madam.
all speaks about the statement of assets and liabilities and on all. Now, first of all, you have to decide where you have to go. Then only you will make steps. How you go by a car, how you go by somebody or some other.
Please, madam.
And you don't know where are you going and you just say that the evidence is adduced. No, there are two MC filed by her, filed by him for cruelty, filed by her on the ground of adultery.
One MC, they have the counterclaim in my MC.
Claim on the ground of adultery. There are two different things.
Please, madam.
Adultery and cruelty.
Please.
And that has to be proved.
Yes, madam.
Nothing just like
No,
that.
based on that, evidence has been laid by both the parties. Based on the same, I have got marked around 40 documents. They have got marked around 47 documents. The evidence has been conducted on day-to-day basis.
Why did you consent to the fact that
That was
nothing
much-
has to be decided
No,
with regard to the
It was-
relationship of the parties?
My lords, one submission was honorable court, my lords. On 16/3/2023, my lords, It was only a conciliation made by the court, my lords. The concession what?
Not an order according to you.
It is an order, my lords. I'm not saying that. In a conciliation proceedings, what the court asked that, what is the reliefs you sought for? I said that I am a petitioner, I sought for dissolution of marriage. Well, even they had a counterclaim. What is the relief you are seeking for? Even I wanted dissolution of marriage. If that is the case, it is only left out only with regard to the quantum of the case. We totally agree with that. I have no difficulty in that order. The only thing is that, my lord, if in order to reset the case on quantum, my lord, I have to prove my cruelty. It's nothing but indirectly I have been admitting that I'll pay some quantum to the. If I prove my case on cruelty, my lords, on the respondent, I will not. That is a settled principle of law, my lords. If I prove my case on cruelty, the respondent wife will not be entitled for any maintenance. That's the reason the entire evidence was laid. If I fail to,
No, if that's the understanding,
Please, my lord.
court is not able to understand.
I'll place
It is what
citations
we
on
can
that, my lords.
understand is,
Please, my lord.
as far as granting divorce is concerned.
Please, my lord.
So on her, like without any assigning any reason, both of you are ready to get away, to put the relation at this thing by granting a divorce. Then with
If
regard
that's-
to alimony or
Please,
the
if
maintenance,
that is the case.
only evidence has to be let in. That is what order dated 16/3/2023 says.
No, order dated 16/3/20 is only on the quantum of maintenance. So in order to show that I am not liable to pay any quantum of maintenance to the respondent, I led my evidence. It is not the in between. Subsequently, evidence has been taken place from 1/12/2023. The conciliation, the order was passed on 16/3/2023. I started my evidence on 1/12/2023. Based on that, I have led my evidence. I got marked my documents. Subsequently, I have been lengthily cross-examined.
There is no adjudication on the point of cruelty or adultery. There is no adjudication on the point of cruelty or adultery.
There is, my lords. They allege
That is
that.
what is 16/3 order.
No,
Please read it.
please, my lords. Lordship, may kindly see 16/3 order, my lords.
Yes, please read.
Please. That is on ink page number 8. Today morning, my learned friend has provided.
Yes,
Please.
Yes. Please read.
Both the parties and their counsels are present, conciliated, and it seems that there is no objection is granting the relief with regard to relationship, but the dispute lies in the respect of quantum of maintenance to the respondent and her child. Therefore, parties are hereby directed to lead their evidence in respect of maintenance and is directed to lead their evidence forthwith. My submission is that, my lords,
So your submission doesn't fit into this order dated 16/3/23.
my lord, the court has said that, okay, if the respondent is entitled for maintenance, that is only, that should be decided only the merits of the case, my lords.
No.
Please, my lords.
Now, your court is not going into the issue of either cruelty or adultery.
Please, my lord.
Both of you want to separate, so
Please.
divorce will be granted.
Please.
Then when it comes to the maintenance or to the child and the mother, or the alimony to the mother or concern, that would be basing on your statement of assets and liabilities and other aspects.
Very well, my
It
lords.
will not touch upon the merits of the main matter.
Please, my lords. Now, for a moment, your lordship may kindly see the order passed by the family court for a moment. The reasoning given by the family court for a moment.
Yes.
Please. Your lordship may kindly see in the first petition.
All these are unwarranted.
Please, your lordship may kindly see the reasoning given by the family court, my lords, for a moment. I'm sorry to trouble, my lords. It is at page number 85, running page number 85, my lords.
Yes.
It's annexure K. The relevant part, I'll go to the relevant part, my lords. The relevant part is on 87, on paragraph number 6, second part of the,
Yes.
please.
Yes.
87. In spite of the said order, both the parties have led their evidence on the merits of the case, that is the grounds assigned for dissolution of marriage along with the permanent alimony. It was never a objection raised by the respondent nor by the petitioner. Both of them have made up their mind that matters to be decided on merits further. At the time, both the parties and the respective counsels have not brought to the notice of the court regarding the order dated 16/3/2023. For a moment, I'll pause, my lords. There was a pending IAS passed where this 16/3/2023 is absorbed. I'll bring it to notice of the Honorable Court in earlier pending IAS.
All these findings of the court cannot be. What is this finding at paragraph number 7?
Please. In this contest, learned counsel for the petitioner contends that though the ground of adultery is not invoked by the petitioner, it was explicitly pleaded in the petition and evidence were led to prove that the respondent has committed adultery against the petitioner. Learned counsel for the respondent vehemently argued that this court is empowered under Order 10 of the Code of CVPC to pass suitable orders on ascertainment of admissions and denials of allegations in pleading by both the parties. Accordingly, court can proceed with an observation made in the order sheet dated 16/3/2023 to dissolve the marriage by granting divorce, a decree of divorce, and restricting the findings only in aspect of permanent alimony sought by the respondent. Having heard the parties, both parties in length, this court has carefully
Memo is
gone.
filed by whom?
My lords,
Memo is filed by the husband.
memo filed by the husband. I'll come to that, my lords. For what reason that memo came to be filed? I'll come to that, my lords. Having heard both parties in length, this court has carefully gone through the order of this court dated 16/3/2023. My learned predecessor in office has observed that it seems that there is no objection in granting the relief with regard to relationship. Nowhere it is observed that parties have consented before the court to pass decree of divorce without adjudication and finding on the grounds invoked by them. Even otherwise, if it is taken that the parties have consented for grant of divorce as argued on behalf of the respondent, then also the parties are at the liberty to withdraw the consent at any point of time before passing the judgment. Now, through filing of this memo, petitioner has implicitly withdrawn his consent for grant.
Implicitly, explicitly, whatever court wants to say, court will say. There is no procedure for that.
My lords, is not that, my lords. In the matrimonial cases, my lords, since being a sensitive cases, my lords, the parties will come to the court and will give some consent, my lords. We don't know what happens after both of them going back to home, my lords. That is the practical reality, my lords. Some consent will be given before the court. And further, my lord, now your lordship kindly see the sequence of the date of events, how the court has conducted.
Now, whatever is the order dated 16/3, which is not recalled by the court, and nobody has filed any application, let everything go in accordance with that order.
If that is the case, my lord, let
the court will decide the maintenance, something else.
Please, my lord, if that is the case, my lords, as rightly observed, by honorable court, if the issues is not framed pertaining to the issue concerned, let the issues be framed, but let the evidence cannot be discarded, my lord, because there are a lot of admissions, huge lot of efforts have been made by both the parties.
The court will not go into all those issues because you didn't want the court to decide it.
No, we both wanted. No, it was not that we misled or they misled. Both of them.
You didn't want the court to decide anything with regard to the merits of the matter on the issue of divorce. So the court will not go into any of the issues. Whatever evidence that is available on record, the court will decide with regard to the alimony maintenance that is entitled by the wife.
Please, my lords.
Only that will not go into cruelty, adultery, none of the grounds.
Please, that's the reason we let the evidence. If I prove my case on cruelty, I'll be not enter for maintenance.
These are two different stands which cannot coexist.
No, I'm not taking two different. My humble submission.
I will record that. Now I understood what you're saying.
Please, my lord, if that is the case, my lord, with regard to the quantum of amounts, let the case may be decided on merit. That is my case. I have never said that I don't want that. Let the court may decide on quantum of the maintenance.
You are confused or you're trying to confuse the
court. No. I'm sorry, my lord. That is
there are two issues.
Please, my lords.
Once you say, I am only concerned with the aspect of maintenance, basing on the evidence, court decide the maintenance. I understand that.
Please, my lord.
Now, in between, you are making one more submission that if I am able to prove that the wife has committed cruelty on me, she is not entitled for maintenance.
That is a settled, my lord, that is a settled position.
We know what is the settled position.
Please, my lords.
You have consented for that.
My lord, that's not a consent. That was only a conciliation done, my lords. And based on that, in order to prove that I am not entitled to pay any maintenance to the respondent, I let my evidence. If actually, my lords, if actually on material available on record, if actually either of the parties have amounted cruelty or adultery,
so none of them mean that both of the parties want to have, the divorce and
that they don't want to take
on that.
Please,
if that subsequent point of time you are taking a U-turn, then you contested, you question that order that is passed on so and so date, or
that was not
you want the matter to be heard on merits.
No, that's
ask
not
the court for that.
That was not a new term, my lords. My expert submission honorable court is that. Now, for a moment, I'll take 2 minutes, my lord, to see the date of events, my lords. If your lordship see the entire order sheets, the conduct of the parties. For a moment, my lords. Morning, which has been filed, my lords. Now, your lordship may kindly see.
I heard it, I understood it.
No. This one moment. Lordship may kindly come to page number.
That's what, whatever purpose you are doing, why the court is letting you do it, we don't know.
No. For a moment, my lords. Sorry, my lords.
What is the purpose of pleading evidence? Pleading evidence is to decide the dispute between the parties.
Yes, my lord.
When the dispute between the parties about the monetary terms, why the other evidence has to be looked in?
My lords, that's the reason, my lords. For a moment, your lordship may kindly see the order dated 23/9/2024, my lords. For a moment.
Yes.
Please. Case called at 3:15 PM, respondent counsel, learned counsel for respondent present. Page number 40, my lords, of the order sheet.
Yes.
Both the parties present, RW1 fully cross-examined, where the cross-examination of the respondent wife was for. RW1 fully cross-examined by the learned counsel for the petitioner till 5:16 PM. Learned counsel for the respondent filed memo of the judgment referred to so and so. Now, finally, my lords, the honorable court posed the matter for that point of time, my lords. On 24/9/2024, there is one more IA is filed by both parties. Then that IA came to be rejected. Finally, my lords, on 26/9/2024, an order is passed by the honorable court. Both the parties absent, learned counsel for the respondent present. Both the parties are directed to file written arguments on 27/9/2025. On 27/9/2024, even before I commence my arguments, they come and file the written arguments. Now, your lordship may kindly see the written arguments filed with that. It is the U-turn taken by them, not by me. If your lordship sees which is a part of the document, is the writ petition.
Whoever has taken the U-turn.
Please, my lords.
Let it not be considered. Let it go as per the order dated 23/4.
If that is the case, my humble request to the honorable court is let the institution be framed, my lords. Because if it is only at the quantum of maintenance, then I have to lead by evidence on the merits of its case itself. That how she has amounted cruelty on me.
Then everything has to, now let there be issues on all the aspects. Whether you
Please, my lords.
committed adultery,
We are
she
not
has
difficult.
committed-
We are not difficult. Let the issue be on all the aspects.
Yes.
Please, my lords. Let there be issues on all the aspects. Please, my lords.
The present writ petition is filed. Where is that order?
Impugned order would be at
page
annexure
number?
K, my lords.
Page number?
84, commencing from 84.
84.
This is the order that is passed on the memo.
Hmm. Agreed with the order passed on a memo in MC number 4272 of 2021 dated 25th January 2025, whereby the memo filed by the husband dated 18/12/2024 is allowed. The wife is before this court. Parties are referred to as wife and husband for the sake of convenience. The husband has filed MC number 4272 of 2021 seeking divorce. That wife has filed a counterclaim seeking divorce on the ground of adultery. On 16/3/2023, an order is passed by the court, which reads thus, with inverted commas, both the parties and their counsels are present, conciliated, and it seems that there is no any objection in granting the relief with regard to relationship, but the dispute lies in respect of quantum of maintenance to the respondent and her child. Therefore, parties are hereby directed to lead their evidence in respect of maintenance, and the petition is directed to lead the evidence forthwith. While the parties have led their evidence. While this being so, the present memo is filed by the respondent husband. Where is the memo?
It's on annexure H, page 81.
Page 80.
1.
File the memo stating that and referring to the order dated 73, he has referred the order dated 16/3/2023. That since the wife has filed a counterclaim in the present petition and has sought for permanent alimony amounting to crores, and in view of the same, the husband has led his evidence and has cross-examined the wife in detail pertaining to cruelty and adultery committed against him. In view of the same, the wife is not entitled for any relief as paid in a counterclaim. Hence, you have filed the memo. Therefore, the court may please to pass judgment decree on merits of the case and allow the petition filed by the husband and by rejecting the counterclaim. The court has heard the arguments on the said memo and passed the impugned order. In the order, it is observed by the court that the predecessor has passed an order dated 16/3/2023. In that, it is not stated that, it is not observed that parties have consented before the court to pass decree of divorce without adjudicating and findings on the grounds invoked by them. Even otherwise, if it is taken that the parties have consented for grant of decree of divorce, then also the parties are at liberty to withdraw the consent at any point of time before passing the judgment. Now, by filing this memo, the petitioner has impliedly withdrawn his consent for grant of divorce without adjudication on the contention that the findings in respect of grounds of divorce taken by the husband is required consideration of claim of the wife for permanent alimony. As the husband has withdrawn the consent, he has requested the court to pass judgment basing on the available evidence on record. Next parallel, counsel appearing for the wife submits that the order dated 16/3/2024 still 23 was never questioned, never altered, and it remains to be there. In those circumstances, when it is agreed upon that only the evidence will be let in, basing on the evidence will be let in only in respect of alimony, the court now has taken the memo, has withdrawing the consent by the husband and directed and held that basing on the evidence, the court will pass a judgment on merits by considering the evidence written by both the parties. It is submitted that there is a procedure for conducting the case and the issues to be framed where both the wife and husband have taken different contentions, and without framing the issues, without the court just like that, basing on a evidence that is adduced for the purpose of alimony, now cannot say that basing on that the court will pass the judgment. It is submitted that the order impugned needs to be set aside. Learned counsel appearing for the respondent husband submits that the conduct of the parties is very clear, as they have extensively cross-examined the husband, led the evidence extensively, touching upon the merits of the matter. When that is the intention of the parties, in the light of the fact that the wife is seeking alimony running into crores of rupees, until and unless the husband proves that the wife is not entitled for alimony, as she has she has committed cruelty on the husband, cruelty and adultery on the husband. It is submitted that the court had rightly, considering the evidence, as evidence is available on record, the court had rightly held that the matter will be heard on merits, and basing on the evidence, the judgment will be passed, and there are no grounds to interfere with the order passed by the family court. Next para. Having heard the counsels on either side, peruse the material on record. The consent, the order dated 16/3/2023 is very clear that both the parties there is a consensus as far as the divorce is concerned. And the only aspect that needs to be adjudicated is about the alimony / maintenance. The wife, child, or entitled. Now it is a contention of the respondent that both the parties have extensively led the evidence, which is touching upon the merits of the matter. At any point of time, if it is the intention of the parties that the matter has to be heard on the merits of it, and both the parties wants to prove that there is a cruelty or adultery as alleged by both of them, the order it should have been brought to the notice of the court that they want to proceed on the merits of the matter. Without now, according to the counsel for the respondent, this court has to, the intention has to be seen from the manner in which the evidence is written by both the parties, and the court is right in coming to the conclusion that it will decide the matter basing on the same, this submission and the conclusion that is arrived at by the court. This court is not able to appreciate, and the same needs to be, the order dated, the order impugned needs to be set aside. Accordingly, this court is passing the following order. Both the parties, as a petitioner husband wants to lead the evidence, want an adjudication on the merits of the matter, considering the different stands taken by both the parties, the court has to frame the issues, whatever is the evidence on record, and apart from that evidence, in support of the issues that are framed, if either of the parties want to adduce any further evidence, both of them are permitted to adduce the same. And after hearing both the parties, the court shall pass appropriate, the court shall dispose of the matter as expeditiously as possible, but not later than 6 months.
Let there be recording the issues to be framed, my lords.
Yes, sir.
Please. Based on the,
based on connected matter.
Based on the pleadings and on the evidence, my lord.
I said so.
The pleadings is not come.
Yes, yes. 11.1.
Please, Manoj.
Is by
Here, again, this petition, my lords, is filed by the wife. So what happens is the court, now my lords are very well aware what transpired on 16/3/2023. Citing that particular order, the court rejects 2 of my applications. One application was filed seeking for husband's call records as well as his paramour's call records. The second application is filed seeking hotel records.
both the matters. This also in the same. WP 15551 of 2025 is filed by the wife. Questioning where is the order impugned?
Let's page number 91, my lords. Sorry, annexure G 81. This order is passed on IA number 5 as well as IA number 6.
Questioning the orders passed in IA number 5. It is IA number 5 only.
In this,
IA number 5. Whereby
may make one submission, my lords. May make one submission. In this matter, my lords, in this connected matter, my lords, the impugned order challenged is on 4th December 2024. When the written arguments has been filed by both the parties, arguments have been completed. There is a 2 observation with the Honorable Court. Before posting the matter for arguments, it observed that there are no interim applications pending, matter post for arguments. When both the parties concluded their arguments, then court came to know that there are 3 pending IAs filed by the respondent. For that reason, my lord, on 4th December 2024, the IA was filed.
application.
Please, Your Lordship, may kindly see
May I make one submission?
Annexure G.
No.
This application was rightly rejected.
Let it go on, because with all that time frame fixed by the court, they have dismissed this application.
Please, they
Because of the time
specifically
frame
cite
fixed by the court.
True, my lords, but that's not the case. Your Lordship may kindly appreciate the conduct of the respondent, my lords, for a moment. When the matter was posted for judgment, about to post for judgment, written arguments have been filed, list of authorities have been filed. When the matter was posted for judgment, when I filed this memo also, my lords, this came to be also brought to notice that there are 3 more IAs pending.
My lords, this is
This once again, every time the respondent is taking a U-turn, my
Now
lords.
she's seeking divorce on the ground of adultery.
Please, my lords.
These are all relevant.
I totally appreciate that, my lord. But the reason is that, my lords, this application was never argued much earlier. It was only when the matter was posting for judgment, they brought to them the Honorable Court.
Now, if my
They
lords
never
were to
took any-
appreciate
no,
his
no.
conduct,
No,
what
they
happens
never
is
took
this
any-
order is
no,
passed.
they never took any appropriate effective steps to decide this application on merits. There was no proper due diligence from their side, my lords.
Seeking direction to the regional manager, Reliance Jio, to produce call details, recordings, including details of incoming calls, SMS and other also tower location details of the mobile number 9742714588 and 6360298385 that came to be dismissed.
Your Lordship may kindly see para 11 of the reasoning of the order, my lords. It's not just the time frame was fixed. Your Lordship may kindly see the observation given by the family court at para 11, my lords. This is my humble request. May permit me to read, my lords.
The court observes, now this goes against you, this finding.
One,
Please read it, paragraph 10.
okay.
Considering the relief sought by both the parties, the predecessor, by order dated 16/3/2023, conciliated the parties and observed that the dispute lies between.
Please, parties in respect of the quantum.
Considering the relief sought by both the parties, the predecessor in office, order dated 16/3/2023, conciliated the parties and observed that the dispute lies between the parties is in respect of quantum of maintenance to the respondent and the chair. Therefore, parties were directed to lead their evidence in respect of maintenance. Both the petitioner and the respondent have affixed a signature to the order consenting to lead evidence only in respect of maintenance permanent alimony to the wife and a child. In the light of the above, further proving the alleged act of adultery committed by the husband is not necessitated for final adjudication of this petition. Further, the court observes that even though this application is filed before commencement of trial, the same was kept in abeyance by the predecessor in office in order to expedite the proceedings. Thereafter, parties have let in evidence, and after conclusion of final arguments, the present application is pressed into service. Nevertheless, in view of the observations dated 16/3/2023, this application is not maintainable and accordingly dismissed. Both the councils have argued and made submissions in line with the defense that is taken before the family court. In the light of the fact that this court has already set aside the order in WP number 6286 of 2025, and now the court is going to deal with the matter on the merits of it, both on the grounds of cruelty and adultery. This application requires to be allowed accordingly. I number 5 is allowed. Accordingly, the petition is also.
I make one
applications,
submission.
I number
Let
5
the
as well as I
application may be
number
decided
6.
once again by giving an
But the
opportunity.
order is set aside. The court, by giving an opportunity
Please,
to the
Vaish.
respondents, shall decide the application.
The two IAs.
Within,
The two IAs, I number 5 as well as I number 6.
here it is only I number 5. What is question?
91, my lords.
There are
The
two
other
IAs.
order is at page number 91.
Two IAs, my lord.
Two IAs.
2
One-
IAs and 1 writ petition.
My lords.
The court fee
The
paid-
order was passed on the
This is
same
what,
day.
this
It's a
is what
common.
the problem I'm expressing to the advocates.
The court fee
Certainly,
is paid for
certainly,
one. There are
I
two-
number 5 and
6.
I number 5 and 6. The court shall decide by giving a reasonable opportunity within a period of 2 weeks. Yes,
A date may be fixed, my lords.
without further, the party shall appear before the court on 19th of November.
Please, my lord. Oblige.
Yes, next.
Serial number, list number 2, serial number 5. List number 2, serial number 5.
Lord, as regards, my lord,
HB.
restructuring, my lord, my instructions are these. There is no restructuring. It was,
No, his pleadings are different. Writ petition is himself.
but he is not
admitted.
permitting.
No. In
Court
writ
has queried.
petition,
He is not even letting me to complete.
in
As
writ
regards,
petition, he has admitted that sanction was done.
Now, from now onwards, whoever interrupts with the other's argument, I will pass orders in favor of the other side. I think that is the only alternative. Yes, give the file.
My lord, so far as,
Instructions on that.
yes, the instructions I have received, man.
Give that.
One set nan kodi, ಎರಡು ಕೊಟ್ಟಿದ್ದೀನಿ, ಒಂದು ನನ್ಕೊ. ಒಂದು ನನ್ಕೊ.
One copy to him.
ಕೊಟ್ನಲ್ಲ ನೀನು, ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡ್ರಿ.
With
Lord, kindly
reference
come
to
to
your
this.
above letter, we would like to
Yes.
inform you that the settlement of the loan of coastal projects at rupees 4 crores
Is
is
incorrect.
incorrect. Further, it may be noted that the timeline for compliance of terms and conditions of the settlement has elapsed on September 30th, 2017, as both you and Coastal Projects Limited have failed to comply with the same. The bank is constrained to proceed with appropriate remedies available. No, even from this, what we can understand is they
Kindly
have.
take to the next page, my lord. That is their letter. What letter they have given.
Oh.
Kindly take to the next page.
Hmm.
2710. This is very relevant. Kindly come to para 1 well, as you are aware.
Hmm.
As you are aware of the fact that the coastal projects had initially availed a loan of 40 crores and thereafter upon the request of the borrower of the loan was restructured to 34 lakhs and 17 lakhs, 34 crores 17 lakhs. And for the
When was this restructuring of the loan?
my lord, essentially, my lord, my instructions are it is not restructuring, it was a facility for closure. That is why they filed a joint memo before magistrate, page 104 in my writ petition. After availing all this, they file a joint petition at page number 104 of my writ petition. They want to settle it for 17 crores. This is a statement made before, after everything is done. In page number 104, it is categorically undertaken by them that we want to close it. We also said, yes, let there be a quietus. Let them put a halt to it. Page 104 of my writ petition for a minute. And the settlement filed before the magistrate is dated 19/9/2018, my lord. Post all this. Settlement at page number 104 of the writ petition is dated 19/9/2018. of the writ petition.
Where are the objections?
Not objections.
Objections. Morning they have filed.
ಬೆಳಗ್ಗೆ ಕೊಟ್ಟು ಅದೇ ಅದೇ
Page 71, your lordship. Page 71, annexure
Para
R8.
number 18 or 17 he was referring to.
Yes, page 71, annexure R8. Of,
No, please come to page 7.
please.
This letter of yours is dated 27/10/2017.
Page number 7 in the tabular column, your lordships are referring of the statement filed in the morning.
I'm referring to him.
Okay, I'm sorry.
You're saying that your loan is restructured with fresh terms and conditions on 19/5/2017. Please read your own letter dated 27/10/2017. You're given a copy of it to him.
One copy I have given, told you.
Lord, may I start?
No, let him read.
kindly see page number 73, my lord, of sanction letter
70?
3 of my objections. That 5 crores is pertaining to this sanction. There is clear 5 crores to be paid by the borrower or by this second security provided
Then
with.
at least, at least you please show the court 19/5/2017 this restructuring of the loan.
Yes, ma'am.
Where is that proceedings? Page number?
This R8, ma'am, annexure R8. That is the sanction letter. I am not a signatory to that.
70?
71, annexure R8, ma'am. In that 73, 5 crores comes to this sanction, not to this thing, my letter. Fresh sanctions was given. There, serial number 2, my lord, terms of settlement. Second one, 5 crores to be paid by the borrower. That amount I written in this letter. And 10 crores has been taken by one Bhaskar Reddy, according to this sanction.
To a 19/5/2017 restructuring of the loan.
My lord, my
Where
lord.
from we'll get it?
He is himself stated, kindly see, writ petition page number 11. He has admitted below 1, 2, 3, 4, fourth line, my lord. Writ petition.
Page number 11.
11, below from fourth line, my lord, on 19/5/2017. Got it, my lord? 19/5/2017. 2017, the petitioner issued a sanction letter. He himself is admitting to the borrower settling out the revised terms and conditions bound the term loan facility for the outstanding principal amount. The term and conditions set out in the said letter were accepted by the borrower and respondent number 1 by countersigning the said letter. Under terms of this letter, the outstanding amount of the term facility outstanding rupees 28 crores. Respondent number 1 agreed that she would pay 5 crores to the petitioner before 39/2017. Rupees 10 crores was to be repaid from the sale of another collateral provided by another person as security.
So
He-
after this restructuring in on 19, from your own government.
Yes, admission.
19/5/2017, what happened?
Thereafter, my lord, they made a state, kindly come to page 71 annexure R8 of their statement of objection.
So.
There, my
after-
lord, time limit was set out within 7 days. These did not read the last para. Kindly come to page 71.
Yes,
Second last paragraph, your lordship, the letter and the annexes.
I'm reading at paragraph number, page number 11 of your writ petition.
Yes, my lord, this is my pleading. This is, my lord, kindly see what is stated by,
Let us read from your pleading.
very well. I'll start it.
Starting 13.17 crores was to be converted into bank guarantee.
Yes, my lord, I shall complete it.
In favor of third parties, which would eventually be.
At the behest of the borrower, which would eventually be returned to the petitioner. In the said letter, the respondent number 1 had agreed.
In respect of this loan,
Yes,
when was the account declared as NPA?
My lord,
Which
it
year?
was declared as per my averments, my lord, it came to be declared as NPA on. One second. Just. My lord, in the synopsis portion, page number 1, my lord, your lordships will find. 26/2/2014 was the date when it was declared.
26 to
2014.
2014.
Yes, my lord.
Now, what is the effect of this 19/5/2017?
Yes, my lord. The settlement letter, kindly come to the statement of objection, page 71, my lord.
Once you have restructured the loan,
My lord, essentially, I would submit it is not a restructure, it was an arrangement. Kindly come to page 71, that will clarify of their annexure R8.
no, well, that's what I wanted to know. Some arrangement was entered into.
It is, my lord,
And
we
both
can
of-
roughly say,
Both of you have agreed upon certain terms.
yes,
Now, the moment they don't agree to the terms and conditions as stipulated on 19/5/2017, according to you, you don't have to initiate the proceeding.
no, my
from
lord,
afresh.
that is clearly stated in para 2 of that undertaking. Annexure R8, page 71.
Hmm.
Annexure R8, page 71. I shall read it, my lord.
71 of your writ petition.
No, my lord, their statement of objection filed in the morning, afternoon, in the forenoon session. Page 71, annexure R8. My lord, kindly come to para 3. Para 3 will also be very relevant. Specific terms and conditions in addition, kindly mark, my lord. In addition to the terms and conditions of the facility agreement and the security agreement applicable for the individual facility are detailed in the annexure to this letter. All other terms, kindly mark this, all other terms and conditions of the facilities as stipulated by sanction letter 23rd April 2012 and sanction addendum letter dated 1st July 2013, as also the facility and security documents executed by and between the borrower from time to time and inter alia the guarantees so executed earlier shall remain valid, effective, binding and subsisting during the tenure of these facilities. This letter and the annexures hereunder are intended for your guidance and information. Any legal relationship will be evidenced by the documentation which will be prepared following our acceptance of the offer. Please note that at such time and the contents of this letter shall form an integral part and shall be read in conjunction with the facility and security documentation. In confirmation of your agreement to be bound by the conditions stipulated herein, please return the duplicate copy of this so and so.
Not relevant.
And within 7 days from the date of this order, whichever is pursuant to this, my lord, she gives a letter. Just now I passed it on. She doesn't want to, the order of, the undertaking of 5 crores, she doesn't adhere to. Subsequently, a statement is made before the magistrate at page number 104 of my writ petition.
I've seen that.
At 104, they would, both of them would sign.
That is on one side.
One side.
What has happened to the proceedings before the,
Magistrate. My lord,
before Hyderabad?
my lord, those proceedings I'm instructed to submit. What my learned friend was pointing out, there was some check bounce proceedings. I'm instructed that
settled.
I'm instructed to submit that, my lord, those
Not about the check bounce, it is about the DRT.
DRT proceedings, my lord, I'm said that
Still evidence stage.
NCLT proceedings are on. That is what my instructing counsel would submit. DRT, there is absolutely no, my lord, pendency as regards subject to what my learned friend would say. Proceedings
Let
are.
them file an affidavit to that effect, that OA is not pending. My lord, they have participated in the proceedings, they are party to that. And very recently, my lord, evidence is also commenced. They are aware about all the
And the
proceedings.
withdrawal of
My lord, right from the beginning, right from its inception, my lord, each and every facts which the bank has narrated is a total false. My lord, I can demonstrate before your lordships that, my lord, how the bank, first of all, in a section 14 petition, my lord, they never include the principal borrower. A statement was made across the bar by pointing out at page number 104, if your lordships could kindly recollect in the morning, stated that, my lord, even the borrower as well as the guarantor has signed that particular document. My lord, where is the question of borrower signing that particular document when he is not party in section 14 petition? My lord, if your lordships may kindly appreciate, the reason why they have not disclosed about the details of the principal borrower is, my lord, principal borrower is none other than coastal projects, which is involved in 12,000 crore fraud. And the bank is part of that. There is a CBI inquiry as well. For that reason, my lord, they have suppressed all this material. And they want to, my lord, now take out my property after settling the matter with the principal borrower. My lord, if all these proceedings are pending, my lord, under what circumstances, my lord, they have settled the matter under 138 of the NI Act with the principal borrower?
What is the amount?
My lord, amount
6 crores.
6 crores.
Document is produced, my lord. Kindly see.
He paid the 6 crores.
Principal borrower.
Principal
My lord,
borrower.
in this matter, what has happened
They are not
is, if your lordships could kindly, the re-sanction letter, may I request your lordships to kindly look into page 67 of my learned friend statement of objections. That is the 19th May 2017 letter. But according to their document, 2014 is the NPA. 2015 they approached the learned magistrate. 2015 they approached the learned magistrate, obtain an order. I prefer a writ petition before this honorable court. This honorable court relegated both of us to participate before the learned magistrate. My learned friend made a submission that I need not be heard in the matter, but learned magistrate took up the matter, reopened the matter by virtue of the directions of this honorable court and not otherwise. And thereafter, my lord, what has happened is,
Let him finish.
taking undue advantage of the learned magistrate's order, they go and take the physical possession of the property. Under that coercion, my lord, they make us to file a joint memo. My lord, my learned friend on one stretch argues that the magistrate is not required to adjudicate or he is just a ministerial act. If that is the case, under what circumstances, my lord, a learned magistrate can record a joint submission of the parties and enter into pass an order, and that order is also a conditional one. And subsequent events that has taken place. Now, may I request your lordships to kindly take page 67. 71, my lord, according to statement of objection, kindly look into, my lord, the document.
Yes.
This is a letter addressed to coastal projects by the petitioner. My lord, this re-sanction is provided to them. May I request your lordships to
No
kindly turn.
properties are mortgaged by the principal borrower.
My lord,
No properties are mortgaged by the principal borrower.
my lord, that is a high time fraud. What they have done is, my lord, they have showed a dummy project. They have taken all these properties like that of petitioners as collateral in collusion with the bank in order to reduce the liability of coastal project. They are keeping on selling the properties that are mortgaged by various co-obligants or the guarantors. Their properties are not touched. If your lordships could kindly look into the restructuring agreement that is done, my lord, they are supposed to open an escrow account wherein the amount that is credited to the by way of project has to go to the escrow account. That is not done till today, my lord. From coastal projects, they have not even recovered one single pike. And in order to safeguard his interest, they only approach the NCLT, file an application under section 7 of IBC, get a moratorium for them, for their benefit. This is, my lord, bank and the coastal projects are in hand in glove. And if that is the case, my lord, if liability is so much, my lord, why they have settled that 138 proceedings? OA, my lord, from 2014, they have kept it pending. 11 years. And now your lordships may kindly turn to this document. This document will, my lord, clearly indicate what is the fraud that is played.
Yes.
My lord, may I request your lordships to 19/5/2017 document. The next page. My learned friend said it is only a restructure. No. I hereby acknowledge the receipt of your sanction letter reference number so and so. This is a fresh sanction. Now may I request your lordships to kindly turn to next page. Your lordships may kindly in 2 tabular column term loan Residual outstanding 34.17 crores. Revised sanction 28.17. Status is existing. Next, already dispersed NPA and suit filed. Your lordships may kindly, your lordships got it in two tabular column on the top. Next column may kindly be seen, my lord. Bank guarantee. My lord, during the pendency of this NPA, they provide a bank guarantee out of my properties guarantee. My lord, I have not signed any bank guarantee at all. Your lordships may kindly see the status of that. 13.17 crores is the revised sanction. Status is new. Status is new. This is after the declaration of NP and after obtaining the order from the learned magistrate. So where is the question of learned magistrate again reopening that proceedings? Because this is all the fresh proceedings. They should have immediately, my lord, they have declared the assets, classified the assets as NPA thereafter, because it is a fresh sanction. And thereafter they should have proceeded before the learned magistrate. That is not the case here. And that apart, the application your lordship's morning read, they have made an application in 2017 seeking for repossession. At what stage they have filed is, my lord, at every proceedings before this honorable court, wherever, my lord, I have challenged their auction notice or section 13(4), they come up with this learned magistrate's recording of compromise, stating that I am liable to pay 18 crores because I have agreed. But why I have agreed for that 18 crores is my property was taken possession. The chairman of the coastal project at that point of time before the learned magistrate comes and handovers the check to the bank. For that reason, that compromise was entered into. And thereafter, my lord, that check was presented before the Andhra Pradesh court. Their check bounce case was filed. Now, my lord, without my knowledge, without making me as a party, that matter is settled. For what amount, they are not disclosing at all. If your lordships could kindly see the documents. And that apart.
You appear for whom?
My lord, I appear for respondent number 2 in this matter.
Who is respondent?
Yeah.
Respondent number 2 is, my lord, actually in this proceedings, husband and wife.
Guarantor.
You, both of you are guarantors.
We both are guarantors. My lord, it is an educational institution. We were running the educational institution. What has happened is, even if this settlement, my lord, because I have stopped in between, my lord, your lordships may kindly turn to the next page where I have read with regard to bank guarantee. Now, my lords may kindly require next paragraph onwards. Revolving, non-revolving does not include working capital facilities aggregating to 58.42 crores sanctioned, revised as part of consortium agreement under the CDR mechanism. Overall exposure on the borrower to be capped at 86.59, that is 28.17 plus 58.42 crores. The residual principal outstanding term loan of 28.17 crores shall be settled as per the terms and conditions mentioned herein. So total amount due according to them during May 2017 is 28 crores 17 lakhs. Terms of settlement, rupees 10 crores by way of sale of collateral security of NH Bhaskar Reddy, which is under mortgage with the bank. The borrower shall facilitate that sale proceeds in bringing prospective buyers for the said property and smooth closure of the sale process.
Who represent this borrower?
Nobody. Well, Lord, they have never done anybody as a party before any of the proceedings. It is only they are targeting me. Well, Lord, is it not required or is it not mandatory that, my lord, whenever section 14 application is filed, the principal borrower is the necessary party? They doesn't proceed against him at all in any of the proceedings. Now here also, my lord, this Bhaskar Reddy's property.
He has not mortgaged any property.
Yes.
To borrow.
Yes. No, because he was going on, my lord, when I was in.
No, when you, like, when any action is initiated against those properties.
My lord, so far as the principal borrower is concerned, my lord, OA is filed. That is one. That is what. That is what.
That OA is filed.
No, he is interrupting every time, my lord. Let me complete my, because I did not want to interrupt when he was going on. The simple, my lord, submissions are that so far as, my lord, the contention that I had made a submission in the morning that they should not be heard. This court had only directed the guarantor to be heard when they were relegated to section 14. He was making a submission that I did not want to intrude.
It's not going to.
No, that's what he is making incorrect submissions. He should know what submissions he is making.
Please don't comment personally.
That's why.
You stick to your submissions.
Therefore, when remand was made, it was only being heard by the guarantor, not by the borrower.
I thought only these kind of submissions, this kind of aggression is there in only family matters. So no, what is there in the bank councils also?
No, because we are being harassed and we are to, my lord, everything is being
And you kept quiet from when? From 24?
Kindly see the order sheet, my lord. Kindly see the order sheet.
Seen that.
Question
I've
of law
seen
is
that.
also formulated at their behest.
Yes. now
Question
the
of
thing
law
is,
was formulated under 13(4)(c).
If you start fighting without, answering the court's query,
Very well.
it's not
My lord.
going to go anywhere.
Please tell
I'm
me.
asking, what did you do with the principal borrowers?
My lord, the instructions are that OA was filed and certain check
You
bounce.
kept quiet. You are just,
We did not keep quiet, my lord. The proceedings under the OA Act before the DRT were on, and as per section 14, the submission that was advanced, that it is only the guarantor who is witch hunted and no action is taken, my lord, appears to be erroneous in terms of the very provisions.
right from 2014, you are waiting for the borrower.
No, my lord,
and,
we have filed applications. Kindly see my applications, my lord. Since 17 it is going on. It is projected as if we are not taking any action against the principal borrower.
Why?
Under section 140 of the Contract Act,
Sir, the Securitization Act cannot be invoked against the borrower.
my lord, it is mutually coextensive under section 14. If
It is there,
That
but
is-
that a provision is not required.
provision is coextensive, and my lord, as regards their, my lord, liability under section 14.
So for the bank who is more
Not more, my
approachable-
lord. What I'm saying, ultimately, we are under section 14 now. We are not under section 13(2). We are not under.
So a close perusal of this 73 shows that
Very well, ma'am.
there is a restructuring of the loan.
Very well. This
Once there is a restructuring of the loan, then the proceedings have to be afresh started, and you should follow.
my lord, my submission to your lordships is, if page 71 last paragraph is looked into,
I'm looking at 73.
73, my lord, is subject to the earlier undertaking given by them under 71. They give a letter. They don't comply it within the time-bound manner. And you are submitting that somebody came from the principal borrower. They were made to sign before the magistrate. Nobody has forced them to sign before the magistrate. It is before the court of law that they have signed it under 18 crores. And even now,
Under section 14, all these things won't.
that's what, my lord.
Neither hearing them, nor taking them.
Exactly, precisely, my lord. Precisely.
Both of them are as if like they're
So
non-existent.
therefore, my lord, he cannot blow hot and cold at the same time. He cannot say that I was forced to sign 18 crores. It was his wisdom. Nobody forced him to sign it. And it was only the guarantor who was required to be heard in terms of the earlier order passed by this court. But both borrower were also heard. And extraneously, learned magistrate holds there is no.
The only limited issue that arises now.
My lord, under section 14, whether magistrate is justified in saying that there is no paper publication. There is a paper publication.
Apart from that, after the restructuring of the loan,
My lord.
basing on the earlier NPA,
Yes, my
can
lord.
the bank proceed is the second question.
My lord, they can proceed in terms of, my lord, kindly come to page 73.
No, you have to go as per the provisions of the act, some agreement between the parties.
Not
or
agreement, my
not,
lord. What I'm saying, the
or
conduct also
concession
would.
given by the party.
Very well, my lord. Page 73, it is their document, it is not my document. Page 73, top portion, your lordships may kindly see. Already disbursed and NPA, my lord. It is there, repeatedly they requested. And my lord, why all this? Your lordships may hear me for a minute here. This is a school that is being run. They come up, guarantor comes up, yes, I want to, I will pay, I will regularize the loan. I'll keep the EMIs in a proper payment mode. With that undertaking, we got the manager appointed. The manager is none other than the guarantor. That fact is not revealed to your lordships. Guarantor before this court is none other than, my lord, the respondent herein who was appointed as a manager of the school.
One more clarity is required is whether it is possession or repossession.
My lord, kindly take to my prayer.
No, because in between you.
It is a possession, my lord, because we handed over to the manager. Guarantor said.
You wanted the possession from the manager. You have initially taken possession from the guarantor.
Very well, my lord. We
And
took,
appointed a manager.
then matter got remanded back.
So now you wanted, that's why you use that word repossession.
My lord, in the
Because
prayer
already
portion.
possession once is already done.
Well, what I'm saying is only one clarification. If my application is to be looked into for a minute, of course, in the cause title, the opening phrase would say repossession. In my prayer portion, if my lords would see, the word used is possession itself. We have never said repossession. And we issued notice to this manager also, this guarantor who is present before this court, stating that you have not adhered to the terms and conditions and you become a trespasser. We have given this notice. This is part of my writ papers. So once he becomes a trespasser, my lord, my action under section 14 would revive.
Yes.
Kindly come to page 162, my lord, for a minute. Page 162. Guarantor is none other than the.
Both of you file your written document. I'll dispose of this.
My lord, the question of law was also formulated under 13(4)(c) on the last date of hearing. That will also, my lord. That judgment is also placed on record before the honorable court.
For taking position, Panchnama is also drawn, my lord.
Written arguments and written submissions will file. And additionally, my lord, what I'm submitting is fraud and misappropriation and all these things. Can they be pleaded in a writ petition?
You are right, it is your.
No, my lord, again he is
It
coming
not
in between. When I'm making
it is
submission,
your
he should know this.
expedition. It is your
When
expedition, it is
when
not
I'm making a submission to the court,
Then
he
I'll
should
not hear
realize
this
that his
matter.
other side should
I'll
complete.
not hear this matter. If you both of you want to shout on each other,
sorry,
please do it, go outside the court and do it.
So,
I'm sorry.
so far as the fraud, my lord, allegation of fraud is concerned.
Yes, next matter. Whenever they file. Yes,
Lord, next week your lordship may fix it, I'll file. On 6th or 7th, whenever your lordship.
yes, next.
Tell me. 7.
Move the matter to.
Tell me 7.
Yes.
Hearing for the petition lordship. In this case, the respondent number 2 ARC, reconstruction company lordship, they have purchased our assets for 55 lakh rupees in March 2023. Without following any procedure, the guideline of RBI, they put it for the realization lordship for the worth of 1 crore 25 lakh rupees lordship for the auction. Lordship, kindly just, I will request this honorable court look into the
The
guideline.
other day I remember what you are saying is the amount that is, he has to pay is 45 lakhs. 45 lakhs and you have sold it for 55.
Bank has sold it to respondent number 2 at 55 lakh.
55 lakhs.
And they
That's
put
what
it,
is the submission.
yes.
I'll address. So my lords, what has happened is there are significant facts which are suppressed in the writ petition. From the total outstanding amount.
What
which
is
was
outstanding?
Today, as on date, my lords, it is 1.42 crores. And the auction notice says it insofar as it is 1.42 crores. I'll place the exact figure on record. The entire writ petition, insofar as it hinges on this 55 lakhs, is without any basis. Now I have taken over as an asset reconstruction company, I have taken over, my lords. The SARFAESI proceedings themselves were started in 2022. 13(2) notice has been issued. Section 14 has been allowed. I take
No, you have issued 13(2) notice.
the lender, my lords. I took over this in March of 2025. March of 2025, as on date, when the auction.
As on date in 2022, when 13(2) notice is issued, what was outstanding?
I haven't filed anything, sir. My lords, a sum of 1 crore 36 lakhs. I can place this on record, my lords. I have a memo. The 13(2) notice I have with me, I can place on record.
Yes. It was served on the,
It was served. That procedure is not challenged in any proceeding here, my lords.
no. Now it is the submission.
Yes.
So it was
13(2)
served
has
on-
been followed. 14 order was allowed in 2023. I'll just file. In fact, I'll file
14
the
is
list
when?
of dates, my lords. There's a short list of dates, my lords.
Yes.
My lords will see. In 2018 is the loan agreement, my lords, where the disbursed amount was 1 crore 36 lakhs. 30th/7/2022, the loan account is classified as an NPA. 27/12/2022, the statutory demand notice under 13(2) is issued. 4/5/2023, the possession notice is issued, my lords.
Yes.
7/8/2023, the criminal miss is allowed and the section 14 is allowed to take physical possession of the property.
Yes.
20th March 2025, I step in, my lords, as the asset reconstruction company. The entire debt I take over, including right, title and interest.
For what, for how much amount it is given to you?
That specific amount is around 55 lakhs, my lords. That is on the record, my lords, I say as an officer of the court.
Why it is when the outstanding is 1 crore and odd?
My lords, what happens with asset reconstruction companies is when they're taking over a sizable portion of the debt, either they're taking over a single debt or they're taking a conglomerate of debt. Now, when a conglomerate of debt is being taken over from the lender, the specifics of the transaction can vary. The lender is not concerned with what is the outstanding amount. The lender is concerned with how much money is the lender making from this project. Insofar as the asset reconstruction company is coming in, because they step into the shoes of the lender, all the right, title and interest vests in the asset reconstruction company. Now, as on date, when the matter was taken over, my lords, and the auction notice was issued, the outstanding is 1 crore 42 lakhs. But the question is slightly different, my lords. Instead of going into the figures, my preliminary submission is this. As on date, the SARFAESI proceedings are ongoing for the last 2.5 years. There are 2 submissions which I have to make. There is no impugned.
Not able to understand is when the bank can give you this for 55 lakhs of 55 lakhs, Why not they settle the same with them with 55 lakhs?
My lords, that is a submission that is between,
lakh rupees to the bank.
that is between them, my lords. The way it,
What is the rationale in this?
the rationale, my lords, financially as to how a lender works insofar as restructuring how much liabilities they have on their books. I cannot speak to respondent number one. They are not before the court presently, my lords. Insofar an asset reconstruction.
It's very interesting.
Lordship.
No, for when the outstanding is 1,42,000, they give it for 55 lakhs.
My lords, the reason is,
But the same 55 lakhs.
no, my lords, the reason is 95 lakhs is paid by them.
Yes.
The 95 lakhs is paid by them. It is mentioned in the writ petition. I am not denying that. 95 lakhs is paid by them.
55 lakhs.
At the time, my lords, I don't know the exact amount which is outstanding. The debt is taken over in March of 2025 at this amount. Computed with the interest, my lords, when the auction notice is published, around 1.42 is pending. Now, before this court, my lords, my submission is twofold. Irrespective of the exact quantum, my lords, when the SURFACE matter is ongoing for the last 2.5 years, at any point of time, they have the remedy of going under section 617 to the DRT. They have not exercised that. Here, my lords, there is no impugned order in the writ petition. The writ petition is framed as a mandamus. If my lords will just see the prayer for a second, my
I have
lords.
seen, if we have to go technically, not even one writ petition we can entertain before this court. That time conscious of it.
No, my lords, to the effect that at least insofar as the prayer is concerned before my lordships, there were two aspects which had to be considered. The main prayer is to direct me to accept a consideration amount. That consideration amount is nowhere mentioned in the writ petition. What is the consideration amount?
Now, the amount is 55 lakhs.
My lords, they have said it is 55 lakhs. 55 lakhs is.
You have.
Yes, my lords.
It is assigned to you.
Yes, my lords.
At 55 lakhs.
Yes, my lords.
So, if he pays that amount to you,
my lords, that's not the instructions that I have, my lords. As on date, I have stepped into the shoes of the lender. The auction has already taken place. Today, my lords, they had moved this matter for today. Morning when it came up right before the auction, 12:30 to 1:30, they took a passover in the matter and I made the submission that the auction is underway. Auction is concluded at 2:50 p.m. The successful bidder has been declared. Now, what the procedure that has to be followed insofar as the interim prayer is concerned, that is infructuous, my lords. Insofar as the main prayer is concerned, which is to direct me to admit or accept a consideration amount, that is not something that can be done by the way of the writ petition for one simple reason, my lords. The right of redemption that they have against me to pay, even if it's 55 lakhs, even if it's 1.5 crores, the minute the auction notice is published, that right of redemption ceases in its entirety. That position of law after the amendment in 2016 to the SURFACE Act, my lords, has been reiterated on multiple occasions. There's one judgment, my lords, I'll show. It's a 150-page judgment. Just few months back, it has been passed to say that the question of whether you will pay me 1,000 rupees or you'll pay me 50 lakhs or you'll pay me 10 crores becomes immaterial and irrelevant to a court the minute the auction notice is published. For 2.5 years, you had the option of challenging it under section 17. You do not. You had the option when the 13(2) notice is issued to pay the full amount and walk away with the property. You do not. You wait till the auction notice is published, all in due accordance with law, my lords, and 3 days before the auction to get an interim stay, the matter is moved. As on date,
how much you sold the property?
The successful bid, my lords, my instructions are 2 crore 55 lakhs, my lords. The reserve price was set at 1 crore 49 lakhs. The successful bid is 2 crores 55 lakhs. Whatever excess amount is there, which is not due to me in terms of the outstanding amount as on date, will be returned to them. There is no windfall profit being made over here, my lords. The submission that they've made in the writ petition, they've not given a single ground as to why no action has been taken for the last 2 years. They've not even mentioned that they had a right of redemption for the last 2 years. They paid the 95 lakhs. That is not disputed, my lords. But the court and the provision is clear. When you have the right of redemption, it has to be an amount paid in full. If it is not paid in full, the minute the auction notice is issued, you cannot ask for a right of redemption. That amount, even today, if they're willing to pay me 5 crores, my lords, the right of redemption, now it is my discretion as to whether it is allowed or not. If they are concerned with any action which has been taken, they can file before the DRT. Even this court, my lord, consistently, including in this month and the last month, has now taken position of one main Supreme Court judgment, my lords, which says that interim orders in DRT matters where you're asking for the right of redemption like this, if your writ petition doesn't contain a single line as to why you've not exercised your remedy under section 17, that entire writ petition is bereft of any material particulars. even if you say that the effective remedy under section 17 cannot be exercised, the main prayer that is sought before this court, my lords, is now barred by law.
Make submission. Lordship. My humble submission is, my learned friend.
Why did you not question any of the notices under 13 to
This,
13?
after all these notices, position was taken, Lordship, kindly appreciate. Position was taken. After that, after taking a position, we paid 95 lakh rupees. It is not that doing. We have conceded all the notices. Position was taken to settle the amount under 1 lakh for 1 crore for 35 lakh rupees. Out of that, we have paid 95 lakh rupees to the bank. That is on January last 2 days and February, total 95 lakh 50,000 rupees we paid in 2020. Subsequently, after 1 year, this our property was sold to the restructure company. But you kindly appreciate, there is a guideline for ARC's company, the Assessed Reconstruction Company, by the RBI. What they're supposed to do when they receive this kind of loan? They have not followed any of the procedure and they directly issued a auction notice. Is the Securitization Company and the Reconstruction Companies, the Reserve Bank Guidelines and Directions 2003.
Which one?
This is what I have to do. This is the relevant is, Lordship. Kindly see the Rule 7. Rule 7. Assess reconstruction. Acquisition of financial assets, Lordship. Then here the rescheduling of debts. Once they received it, every Rule 7 I'll read out. Every securitization company or reconstruction company shall frame the approval of the board of directors and financial assist acquisition policy within 90 days of the grant of certificate registration and shall clearly lay down the policies of guideline covering inter alia. Then Lordship, kindly see here. Rule 3 is subclause 3, 7.3, rescheduling of debts. Every securitization company or reconstruction company shall frame a policy. 7 subclause 3, Lordship. Rescheduling of debts. Every securitization company or reconstruction company shall frame a policy duly approved by the board of directors, laying down on the board's parameters for rescheduling of debts due from the borrowers. All proposals should be in line with the supported by the acceptable business plan, projected earnings and cash flow to the borrowers. The proposal should be materially affected the asset liability management of the securitization company or the reconstruction company or the commitment given to the investors. The board of directors may delegate power to the committee.
How is it relevant?
Lordship, it is, they have to reschedule our debts. They have not done that.
Where do you get that?
It is the rescheduling of the debts is there, Lordship. Once they acquire the property, then they have to reschedule our debts. Lordship, then enforcement of security interest is there for 4. While taking a recourse of the sale of secure assets in terms of section 3(4) of the Act, the securitization company or reconstruction company may itself acquire the secure assets either of its own or for resale, only if the sale is conducted through a public auction. Then the settlement of the dues payable by the borrowers. Every securitization company or reconstruction company shall frame a policy duly approved by the board of directors, laying down the board parameters of the settlement of the debts due from the borrowers. The policy
after that is taken over by you, the asset reconstruction company, what are you supposed to do? What is the procedure thereafter?
My lords, it depends on what the status is at the time of takeover.
You will take over it from the date from the procedure where it has started, where it is.
Yes, my lord. It is as simple as when an assignment takes place under the assignment deed, the terms say that the right, interest and title transfers. Now, as an asset reconstruction company, which is a statutory body, there is no doubt that there are internal rules which guide its governance framework. But vis-a-vis the SURFACE Act, the matter where the point at which it stopped or the point at which it paused, my lords, is where I step in and take over.
Then what is this 3(1) is referring to?
My lords,
I'll just read the 5 also. The plan for realization. They just without bypassing all the procedure, they jump into the realization of the problem.
My lords, which clause has been referred to me?
3. He is looking at
731. 3(1), my lords.
Please read that.
My lords, every securitization company or restructuring company shall frame a policy duly approved by the board of directors, laying down the broad parameters for rescheduling of debts. My lords, now there's no doubt that as an ARC, this policy will be there. Whether my actions are in line with this policy or not, first, has not been questioned in the writ petition. Second, it is outside the purview of this court in the discretionary jurisdiction. If they want to challenge the manner in which I have taken over the debt or the manner in which I'm supposed to restructure it, again, my lords, it's a factual inquiry which cannot be done in writ jurisdiction. Today, my lords, a single line is being shown from a 2009 master circular to question my own internal policies when nothing is placed on record. It doesn't take away from the fact, my lords, that for 2.5 years, every remedy that could be exercised has not been exercised. And as on date, even if I didn't argue this matter, my lords, the final prayer is barred by law. They can't ask for a mandamus to me to accept a certain unspecified amount in the writ petition with 10% additional. There's no relief that's being sought before the court. My lords may look at the prayer once, my lords. The prayer is on clause, I'll just finish, sir. The prayer is on clause page 11, my lords.
I've seen.
This to direct respondent number 2 to accept consideration amount. There is no clarity on what the.
I've seen all this on the day when the matter came before the court. Only ground that if the respondent comes and whatever proposal he's saying, if it is acceptable to you, then I wanted to pass some order.
My instructions are this, my lords. Today, as on date, the outstanding amount has been published in the auction notice on page 29. The auction, which they didn't impugn in the writ petition, they asked by way of interim relief, they asked for a stay on the auction. That auction has been concluded, a bid has been confirmed. I am going to recover my entire money, my lords. Whatever excess money is there, in accordance with law, will go back to them, my lords.
Please come.
May I make the sub-rule 5 Lordship also mentioned.
No, where is it questioned in the writ petition?
Lordship, these are the procedure they need to follow. They have not followed it. They have jumped into the realization. These are the legal aspect which court has to look into it. On what basis they had auctioning our property. Once they have taken over the assets, there is a procedure has to be followed. Without intimating us, they had put an auction notice. And auction notice, they have received property on 50. On what basis they are saying the debt is 1 crore 40 lakh on that day, when they themselves has received the property for 45 lakh rupees just 1 year before. How is it possible the debt will increase from 55 lakh to 140 crore? So all this procedure has to be there, Lordship. There is a procedure as per the guidelines by the RBI. Once they restructure it, so they have to approve the borrower for the repayment.
From the amount you will be taking only 55 lakhs and the incidental expenses.
No, my lords, the outstanding that is published in the auction notice.
How? The outstanding is 55 lakhs.
The outstanding is not 55 lakhs, my lords. In a reconstruction deal which is taking place with the lender, that is a private commercial transaction. If I am today buying debt or debt is being assigned to me, the value at which it is being done, my lords, is an inter se commercial contract between two parties. Now, if someone owes me 100 rupees, my lords, I can say that my debt, I am not willing to pursue it any longer. I am assigning my debt to you at a value of 20 rupees.
Oh, if that's the way, that's what the banks want to do, why don't you give the same offer to the...
That is at the discretion of the bank, my lords. Today, when an account is declared as an NPA, when securitization action has been taken, there's no doubt, my lords, that the bank can do it.
Nowhere, the banks will never come out with that kind of proposal to any of the borrower.
That is unfortunately, my lords.
But then what is this happening with this, between the asset reconstruction company and the banks?
Lordship, we paid 95 lakh rupees. After that, the debt come down to 45 lakh rupees. From that 45 lakh rupees, bank is safely sold it to 55 lakh rupees. Now these people, from 55 lakh rupees, they are selling 1.4 crore rupees. They are earning money from our distress.
My lords,
That is my concern.
I must.
If they are taking 55 lakh rupees, transfer the remaining amount, I'd have no issue at all from the auction.
I must at this point out, my lords, that
Lordship, how they reach to this figure, 1.4 crore rupees, when we already paid 95 lakh rupees, that is accepted by bank, and after accepting the money, the remaining was a 45 lakh rupees. Bank has paid, sold this property to respondent number 2 to 55 lakh rupees. Now they are saying there is a due or 1.54 crore rupees. I am not worried about this, the procedure. 55 lakh rupees money, they asset they have received 55 lakh rupees. They sold it to 1.4 crore rupees. And now they are saying fairly with our procedure, whatever the excess amount we will pay to the borrowers.
If I just I place a document on record, my lords.
RBI has
this has not been produced. My principal issue with the writ petition is that even the loan account statements which have been produced are produced only till a specific period of time. My lords will see document number 1. I have produced my statement of accounts, my lords. They are saying, how are we arriving at this value? How are we arriving at the value? The percentage basis for delayed payments for interest is all stipulated. Today, my lords, will see the loan account till 28/10/2025. On the bottom, it says 1 crore 43 lakhs, my lords.
In that he has paid the 90 lakhs.
My lords, the overall outstanding amount can be seen on top, my lords.
When did he pay that amount of 90 lakhs?
January 2024, my lords, 95 lakhs around was paid. From that, my lords, interest is computed, they've said in the writ petition. Interest computation which takes place till today has come up to this amount, my lords. Now,
Account
my
was
lords,
closed,
I'll just
Lordship.
bow
After
down.
they paid 55
I'll bow
lakh
down.
rupees, account was closed from the
I'll
bank.
bow down. There is one question which has fairly fallen from the bench, which is that if an outstanding amount is in excess of the amount which I have paid to acquire a debt, doesn't it create a situation where banks have no incentives to have an OTS with the borrower themselves? I bow down, my lords. This is an anomaly. I cannot today speak to whether or not there is an incentive that the bank has, and perhaps it is a situation to be
But in fact,
addressed.
it's injustice to the borrower who is the owner of the property. Bank, what it can do with the assessed reconstruction.
I bow down.
company,
I bow down, my
would
lords.
have done it with the same.
I bow
Will-
down, my
will-
lords.
Will any bank give will any bank enter into this kind of transaction with the borrower? And RBI guidelines won't permit them to do with the borrower, but they will permit them to do with it as a asset reconstruction.
No, I
company.
bow down, my lords. This is a valid concern. It is something for the bank to answer who has not appeared before the court. As
Bank
in,
is not a party.
This is a party, Lordship.
the lender is respondent number one.
They are in Delhi. For that reason.
Which is the bank?
Bank is this is NBC, Lordship.
Pyramid Finance, my lords.
Pyramid is NBA.
Now, there is no doubt, my lords, I do bow down. It's a fair question that has fallen from my lords. At the point, my lords,
So this is how all the transaction goes on from with the bank and majority of cases like this. the
I wouldn't say majority of cases, my lords, but it has to be seen that in an inter se commercial contract, what happens with assignment of debt is that is purely a matter between the two parties. Today, my lords, I can decide as a bank that I am taking a haircut on the value owed to me. Now, the decision is not a purely monetary consideration, which is why when banks do this, they don't necessarily assign a single debt.
What are the guidelines of the RBI for assigning these kind of debts to the asset reconstruction companies?
There must be a set of guidelines, my lords. I'm not aware of it, and I cannot answer to it.
I don't think those kind of guidelines will give them this kind of, the difference.
My lords,
You buy the asset at 50 lakhs and you sell it at 2.5.
I must say the asset is not bought at 50 lakhs, my lords.
Your debt is bought at.
Yes, this is the assignment of the debt. There is no doubt that there may be situations like this. But vis-a-vis the rights of an assignee, my lords, once the assigner has done it for whatever commercial value, whether it was for 10 rupees or 50 lakhs or for 10 crores, today the commercial reasons.
Bank has done something, it's not beneficial to the bank. How is it beneficial? Property, when the property that itself is fetching 2.5 crores in the market, why should they assign you for 50,000 to 50 lakh rupees?
Now, for many reasons, the entire process which takes place, e-auctioning, getting bids, doing the process for multiple properties, what sometimes banks do, and this is my limited knowledge, my lords, I'll bow down. My limited knowledge is what banks do sometimes is they mass assign debts to ease out the process. For them as a commercial transaction, there is a recovery of a certain amount made. They do not have to go through two processes. One is the physical and the tiresome process of the auction itself.
Now you have sold it for 2.95 crores.
2.55 is the confirmed bid, my lord.
55 crores.
Whatever is the outstanding amount will be taken away, my lord.
It's not that. Like for 55 lakhs of rupees, a property is sold and no, not even one opportunity is given to him.
My lords, that's between the bank and the borrower. Between me and the borrower, my lords, today, once the e-auction notice has been issued, I am purely on a technicality, my lords. I will bow down, even though this commercial transaction may not make sense. Today, the right of redemption does not exist.
We'll try to understand what exactly banks are functioning and how we will, please do not confirm the auction.
My lords,
it has gone on, let auction be not confirmed. And this is a fit case where interference of the court is required because I'm not able to understand what is this, maybe the bank will come and throw some light on that and the court will understand.
My lords,
for an outstanding of like 1 crore 45 lakhs. You start what is the bid started at 1 crore 45 lakhs.
Yes, my lords.
You debt is assigned to you for 55 lakhs.
Yes, my lords.
For a property which is worth rupees 2 crore 55 lakhs.
That is sold in sale, my lord. The property value is irrelevant to the transaction.
Because nobody will buy the property just like that. That's a market value.
Marketing value.
Of it. So how does asset reconstruction companies and these banks or functioning, whether it's a fit case where the interference, I felt that, after having this roster, I never felt that I should interfere in any of the matter. This is a fit case to interfere.
I bow down, my lords. The concern which falls from my lordship is the difference in quantum.
I do understand. Now this is a purely like on what basis they're doing it. There is no rule and rhyme. That's what I type here. Let the bank come and tell the court, please come. The present writ petition is filed questioning the following release, seeking the following relief. The writ petition is filed seeking the following prayer. The interim relief that is sought is to stay the operation of the public auction notice issued by the.
My lords, if I may just submit, I have instructions from the client. The 55 lakh quantum is not something that they are giving instructions on. If it can be had tomorrow, let me assess it, my lords, because the assignment, as I understand it, was a mass assignment. It was not a single assignment. It was a mass assignment which took place. I'll get proper instructions, and if needed, I'll place a memo of calculation on record.
Yes.
Page number
And
18,
please instruct your client not to confirm it till tomorrow.
It may be, Lordship, it may be at least in court order sheet may be there, confirmation. A confirmation or not to confirm the auction, Lordship, may be.
Learned counsel for the respondent submits that he'll get specific instructions from his client with regard to what is the assignment of the debt and what is the price of the auction and other relevant details. It is also submitted that today the auction is conducted and till the instructions are placed before this court, they'll not confirm the auction. Yes. Let's
I bow down, my lords.
Yes, next. And you please get the other details also. Let's understand how it works.
I will, my lord. There's
Reconstruction company.
and my lords, I filed the wakalat in the count. I was served last evening.
So and so submits that he has filed the wakalat.
For respondent 2 and 3, my lords.
Respondent number
2 and 3, my lords.
2 and 3. The registry is directed to reflect his name. Yes, next.
In respect of respondent number 1 also, I will be allowed to take handsome money because they have one branch here in Lasat Nagar.
Respondent number, petition is permitted to take out handsome money on respondent number 1.
Next date is fixed, my lords.
Tomorrow? If you want, I can take day after tomorrow also.
Day after tomorrow, I bow down.
Day after tomorrow. In the meantime, you serve the
Yes,
handsome money. Yes.
Cell number 19. Sarvana ji.
Respondent, my lord.
You appear for the respondent.
Respondent. The sale has not taken place, so petition may not survive because sale notice was challenging. So,
when was the sale conducted?
no, not conducted. It was not, there was no bid dash. 2/8/25, the sale notice dated.
Please come. The writ petition is filed. No interim order is granted in this.
No.
The writ petition is filed seeking the following prayer. The petitions have questioned the sale notice dated 2/8/2025. When counsel, that when the matter is called, there is no representation on behalf of the petitioner. When counsel appearing for the respondent bank submits that on the day the auction could not take place and the writ petition has become infructuous. Next paragraph. When the sale notice dated 2/8/2025 is questioned, when this auction is not conducted on the date, there is nothing survives a consultation before this court. Accordingly, dismissed. Yes, next.
Cell number 23.
Sale notice is being challenged. For a moment, your lordship may kindly come to page 14.
14.
Sorry, page 20. Sale notice at the earlier point of time is concerned.
Why should we interfere with the sale notice?
My lord, for a moment, my lord. My lord, it is dated 24/1/2025. The amount, my lord, at page 22, they have stated as 36,55,684. Now, this was being challenged before, my lord, the coordinate bench of this court. And ultimately, please, my lord, my writ petition was dismissed on a different context is concerned. Subsequently, my lord, another sale notice was issued that was dated 4/9/2025. My lord, for an amount of rupees 26,82,804. Now, the date and time of auction was fixed on 26/9/2025, my lord. Now, this was being challenged before the DRT, my lord, by filing an application is concerned. My lord, for a moment, your lordship may kindly come to page 38. My lord, there was an interim order granted by the DRT. My lord, remitting me to pay amount sum of rupees 2.5 lakhs is concerned, and the confirmation of the sale was being held as by way of an interim order is concerned. Subsequently, my lord, on 29/9/2025, my lord, I filed a memo before the DRT, my lord, in view of the compliance of the earlier order of the interim order is concerned. My lord, since there were no bidders are concerned, my application had become infructuous, please, my lord, and that my application before the DRT was dismissed as infructuous is concerned. Now, again, a fresh notice has been issued. Your lordship may, for a moment, kindly come to page.
So again, go to the DRT.
My lord, I'll come to that. For a moment, kindly peruse page 31 and 41 simultaneously. My lord, page 31 to where, my lord, I have approached the DRT. My lord, the secured debt for the recovery of which the immovable secured asset is to be sold is for 26,82,000 is concerned. Now, again, in a fresh notice, my lord, without deducting the earlier amount of rupees 2.5 lakhs is concerned. Again, my lord, it is a, my lord, at the most, I can say it is a cut copy paste. Why? Because your lordship.
It's okay. No, we'll take it. That
Allah, my lord,
that 2 lakhs.
not only that. My lord, page 31, earlier notice. The date and time of auction was fixed on 26/9/2025. My lord, in the subsequent notice also.
When is
same
the
date.
end to this litigation?
Allah, same note. My lord, I am ready. My lord, make some payment.
That's not how it works.
My lord, your lordship
Will
kindly-
not, will not.
Allah,
What is the purpose of, you take money, you don't pay. When the bank comes like.
Allah, they don't, my lord, they don't give me the
One
particulars.
is wrong, two is
Allah,
wrong,
they don't
three is.
give me the particulars. Why? Because, my lord, this sale
From how
notice is
long you are
dated
fighting
10
this litigation?
My lord, from 24. From 2024, my lord, loan is of the year 2000.
So, 2000?
Loan is of the year 2017.
Now you intend to fight it till when? 35, 40, 50?
Please, my lord.
You want to fight this litigation till 35, 40, 50 when?
My lord, I'm not,
By
my lord.
paying 2 lakhs, 1 lakh, as if like
My
you're
lord,
doing a favor
my
to
lord,
them.
No, my lord, I'm not on that. My lord, the date and time of auction. My lord, the sale
That's
notice is
over now.
dated 10/10/2025.
9 is over. 9 is over.
9 is over. In the subsequent notice also, my lord, they have given the date as 26/9/2025. The sale notice dated 10/10/2025. They give the date and time of auction as 26/9/2025.
Yes, my lord, there is a mistake in page 41, but then at page 40, clearly mentioned as 30/10/2025.
But the amount
And also
which I have
paper
deposited, my
publication
lord,
also mentions 30/10/2025.
But the amount which I have, my lord, which I have
Yes,
already
amount-
deposited, 2.5 lakhs.
As
They have not
on, we
deducted.
mentioned the date, my lord, as on 3/9/2025. As on 3/9/25, they have not deposited 2.5 lakhs. It is subsequently, so we've clearly mentioned the date.
But
When
on
an
25
amount is mentioned as due, we mention as on which date. Subsequent payments may not be, but then we are not saying that as on date. We are saying as on 3/9/2025. Outstanding, my lord, is the 26 lakhs minus 2.5 around 24 lakhs, my lord.
I'll deposit some amount.
No, some amount.
Well,
by some amount, if the auction is, we let the auction go on, they get full amount.
Well, reasonable amount. Why? Because I'll regularize the account is concerned. That would be
From
if some amount. My
from
lord,
how long the same slogan?
my lord, certainly, my lord, certainly there were some difficulties in the family of the petitioner is concerned. Now, please, my lord, everything seems to be smoothened. Now, my lord, if your lordship would direct.
How much amount you will pay?
My lord, I'll pay around 5 lakhs in a matter of.
No. With 2 lakhs, 5 lakhs, the auctions will not be stopped.
My lord, 10 lakhs, if your lordship, my lord, sometime 10 lakhs, my lord.
No, sometime 10 lakhs by the date of auction.
My lord, that would be, my lord. Why? Because, my lord, Sometimes.
You know what is the interference of the
I
court
am, my lord, I
in
am,
these
my lord.
petitions.
I'm-
So unless and until some substantial amount is paid,
Certainly.
will not interfere.
Not my, only my request.
And you're already habituated to this.
But if 10 lakhs, my lord, some time is given, certainly I'll deposit 10 lakhs, my lord, and I've already complied the order of the, my lord.
What do you
interim order.
say? 5 lakhs by the date of auction and 5 lakhs thereafter.
Yes.
Another 10 days from there.
Yes.
Date of auction is on 30, my lord.
No, that's 5 lakhs amount if you don't pay on that day will not, it can't be. The another 5 lakhs will give some time.
My lord, may I request in this? My lord, 2.5 lakhs on the date of.
Why
auction.
the 2
Allah,
lakh,
Another
5 lakhs is
7.5
the,
lakh, another 7.5 lakhs in, my lord, in another 10, 15 days. 5 lakhs by 30th.
before the auction, before the time of
On
the
or,
auction.
on or before.
No, it is, at what time is the auction? On
My lord, at
30th?
10 AM, my lord.
Huh?
10 AM.
30th?
Sorry, 30th, yes.
10 AM.
Normally it is 12, my lord, I'll just check.
Give the file.
10 AM, my lord.
Yes.
My lord, one submission which I would, only one submission. My lord, let them accept the amount is concerned. Why? Because when, my lord, when the DRT court granted an interim order, they refused to accept
No, my
the
lord, in
amount.
fact, I checked.
When you have deposited the amount beyond the
My lord,
time, they will not
no,
accept.
my lord, I was constrained to, my lord, by way of an RTGS. I approached the bank.
The present writ petition is filed questioning the e-auction notice dated 10/10/2025 issued by the respondent bank. And the auction is scheduled to be held on 30/10/2025. This is the third round of litigation. In the first round of litigation, when the petitioner's writ petition is dismissed, petitioner has approached the DRT and questioned a sale notice. The DRT has passed an interim order on the condition that he should deposit 2.5 lakhs.
2.5 lakhs.
2.5 lakhs. It is the case of the petitioner that he has deposited the money. Thereafter, that application has become infructuous. Now, the respondents have come up with the auction notification. When council has stated, has made several submissions pointing at the technicalities about the date, about the amount of 2.5 lakh that is paid by him is not.
Description in the schedule.
Huh?
Sorry, description in the schedule.
Description in the schedule, and the 2.5 lakhs amount is not deducted from the outstanding. On all these, the grounds that are stated by the petitioner are not the grounds on which this court will interfere with the auction notice, sale notice. However, it is submitted that he is ready to pay the outstanding amount of 20,
Around, my lord, 26 lakhs minus 2.5, about 23 lakhs, my lord.
about 23 lakhs and odd. It is submitted that on 30th, he will be paying on the date of before the auction time, he will pay an amount of rupees 5 lakhs, and the remaining amount of 5 lakhs he will pay on 10th of November. On 10th of November, it is submitted that after that, as per the after that, he will come up before this court with regard to the remaining amount, and within a reasonable period of 2 months, he will be clearing the amounts also. Considering the submission of the council, this court is inclined to pass an interim order. Number one, the respondent shall not go ahead with the notice, with the auction, with the sale day that is scheduled on 30/10/2025 on the condition that the petitioner shall pay 5 lakhs before the auction time, that is on 30/10/2025, 10 a.m.
10 AM.
10 a.m. Next, number two, he shall pay the amount of 5 lakhs by 10th of November. List this matter on 11th of November. On that day, an affidavit shall be, an undertaking affidavit shall be filed before this court on the remaining amount when he is going to pay the amount. Yes. And any of the violation of any of the conditions, this court will dismiss the writ petition on the, yes.
Great.
May I request,
As Ms. So and so takes notice on behalf of. the
I'll file for
Lord, may I
Yes.
request once hand delivery of, Lord, why?
Huh?
Because hand
No, I'll
delivery.
inform, my lord. I intend
If
to
that,
inform the
please,
bank.
Yes.
Cell number 24, Sidramaya VB.
Appearing for petition, my lord. My lord, on 21/7/2025, magistrate has passed an order for delivery of position.
Unless the respondent is heard, I'll not pass any order.
My lord, let the shall not initiate for auction of the property. At least for auction, my lord.
The petitioner shall take out hand summons on the respondent and shall file a memo to that effect. When do you want?
No, emergent notice also.
And addition, emergent notice shall also be
First
issued.
week of November.
Yes, let's just matter on 6th of November.
Cell
Yes.
number 25, preliminary hearing B group. Vishnu Vinayak CR.
Appear for the
For
petitioner.
respondent in this case, Your Honor.
The demand notice, possession notice, as well as the section 14 order passed by the learned magistrate challenge. For the simple reason that the demand notice as well as the possession notice contemplates illegal amounts contrary to the bank statements issued by the respondent bank. The amounts are exaggerated and these.
On those factual aspects, how can we go into?
Look, this
No, that particular
exaggeration.
aspect, whether factually, whether the amount that is claimed, that is demanded by them is correct or exaggerated, those factual aspects in the writ petition, how can we decide?
That's because this goes against the foundations of the.
Then that for that, for all these factual aspects, in your, they've come, it has come till 13, 4 and 14, go before the DRT, we can't decide it.
From 13.2, from 13.2.
Then you have, where is your reply to your 13.3A reply to 13.2 notice?
The 13.2 notice never reached me at all. I do not want to get into the technicality of the service of the demand notice or of the possession notice.
Because you have to go into the technicality, because unless you give your reply to the 13.2 notice, how will we know? How will the bank know? What is your difficulty?
My instructions are 13.2 and 13.4 never reach the borrower. It is only after the possession
What are your
order was
instructions?
passed.
20% deposit amount till today, not completed.
That is complied, my lords.
Not completed
I
because
established before this court
they have
that
18 lakhs is
amount is
pending is
paid.
there, only paying on the 14 lakhs 50,000.
Looks, the exaggeration is not a mere anomaly or a mistake.
I'm not
Court order
going into
dated
all
on-
that. I can't do the calculation.
No, there's no calculation required, my lord.
First of all, 13.2
And seven-
notice is issued to him or not?
Sorry,
13.2 notice is served on him or not?
service, sir.
It's not.
Where is the material? You filed your objections?
I have not filed objection. I take instruction.
When is the
and-
interim order granted?
Interim order was granted on 1/2/2025. If I may pass on a memo.
So
10 lakhs was paid after the interim order, 4.5 lakhs is paid by virtue of this.
it is submitted that the interim order dated 1/2/2025 is complied with. Then calls for the respondent seeks time for filing objections. This is matter on 26th of November. Interim order earlier granted is extended till then.
Cell number 26. Sanjay Ayub Prabhu.
Appear for the respondent bank.
Yes.
I've sought for the demand notice was given. Annexure F is a demand notice. Annexure G is a reply. Annexure E is a demand notice. After the demand notice was received, my lord, I replied to the demand notice with some specification with regard to I am ready to clear the loan dues with some schedule, not the entire dues. Saying
Where is your reply?
That is annexure G, my lord.
Page number?
In page
Number?
page number 57. 57. Payment schedule for closure of total outstanding amount of rupees 15 crores. In that, my lord, I have mentioned 4 crores from the sale of pledged with the UBI. That in fact it would have been mortgage. Then 5 crores with the KIDB land, surrender back to KIDB. Like, whatever the property I have, I will surrender back to the KIDB, and later to that 5 crores will be paid. So specifications for, after availing the loan, if because of the Russia and Ukraine war, I had a greatest hit on the business. I was doing well when I had availed the loan. Later to that, when demand notice was given, I replied to them with a specification that I would like to clear the loan dues with these specifications. Release of 1 by 1 property on first, that is the second page, 58. Releasing one property with a 4 crores payment. The moment I make a payment of 4 crores, any property which the banker wish to, they have to give me, in case if they give. The second.
You have set the terms to the bank, how they should release the property.
To cooperate with me on release of the property.
How can it be?
For the
Why will
security.
they do?
For the security, I have given some properties. If entire dues has to be
This is your 13(3)(a) reply.
13(3)(a) reply. For that, they have to.
Setting the goals to them.
They had to reply it within 15 days as per the rules. 15 days they did not reply. Parallelly, I filed a writ petition requesting the court, directing the banker not to issue publication of purchase notice, that I will be clearing the loan dues if they are obliging with this condition. If they are not obliging with the condition, let them give me specified time so that I can, I have shown my bona fides.
The one who has to come
If
out
I may,
with
my
the-
lords.
Please,
This is the
Lakshmi, kindly turn to one loan was cleared subsequent to they issuing the demand notice. This particular demand notice
If I may, my lords.
was issued to
My lords, their
me.
only prayer is for us to consider the representation dated 6/8. And that has been done. In view of that matter, nothing remains consideration.
You have
and
already considered.
We have already considered and we have rejected the proposal.
Let's see where is the,
We have filed a memo, my lords.
no, where is the relief that is sought?
Prayer, my lords will find it at page 9. Issue a writ of mandamus directing the respondent to consider the reply given by the petitioner to the respondent on 6/8/25 for the demand notice produced at Annexure G. That has been considered and we have given a reply, ma'am.
Consideration also, my lord, I would like to file my rejoinder. Reason is, I would like to file my rejoinder to that, the consideration. Reason is, my lord,
Lords, I pray that the
within
writ petition
15 days, they
begins,
are
nothing
supposed to-
remains
as per
to
the rules,
consider.
First of all, what is this mandamus? Why will the court issue a mandamus to them?
They did not consider on time. Within 15 days as per the rules.
Then that will go. 13(2) will go if they don't consider.
Please, parallelly, my lord.
And now you have given up a big, schedule how they should do what, when and how. And it's not acceptable to them. What will the court do?
Lakshmi, kindly turn to the ink page 59.
The due amount is more than 15
But-
crores, my lords.
In
They have
which-
not paid a single rupee till date.
15.
More than 15 crores.
Order in this.
No, my lords, it was rather an undertaking given by us that we will not take out 13(4)
To consider
notice
the
until
reply
the
given.
representation has been considered.
Writ petition
Now
has
that the
worked out, nothing
representation
else
has been
we-
considered,
nothing else
nothing
Lakshmi,
survives.
kindly turn to ink page 59.
No. The prayer that you sought is issue a writ of mandamus directing the respondent to consider the reply given by the petitioner on 6/8/2025 for the demand notice. Then your relief, what you're seeking is worked out. They have considered.
We have
They have
considered and
passed an
given a
order.
reply.
They are not interested. Nobody can compel the bank to do. And that too, it is not a small amount.
Lord,
It is 15 crores amount.
previously I had approved this honorable court in some other case, my lord, that's with some other bank, where 89 crores was involved, my lord. This honorable court, my lord, granted an interim order, my lord,
Yes, that is
restraining
not
the
the
bank,
subject matter of the
restraining the
present
bank,
writ
my lord,
petition.
from issuing possession notice. Immediately, the buyer whom I had identified, my lord, he cleared he paid the amount, because if my name would have been in the market, if my name, my lord, is spoiled, my lord, then I will not get the buyer with whom I can negotiate.
But
This
this
is-
court is not so generous.
Lord, I cleared the 89 crores, my lord, I
That's
produced the
not- no,
document.
Please
also.
understand, if something court can do, court will definitely do. You cannot expect the court to do something that such jurisdiction is not vested with the court. Please come.
If not, I would like to file an undertaking affidavit that within what period I will be closing the loan.
My lords, in fact, they had sought an adjournment on
Because
this
one more thing, my lord,
submission itself. That has
No,
not been
What
filed
I'll do
until
is,
date.
I will take up this matter on 3rd of November. This is the final, for her request. On that day, I'll pass orders.
Please.
List
Very
this
well,
matter
Lords.
finally on 3rd November. Land
That
council
even,
for
my
the-
lords, the interim model may not survive. Why? Because it was an undertaking by us.
Council, 1 minute. Land council, let it, whatever it may be, let it be there till 3rd. Then council for the petitioner submits that by 3rd, she will come up with an undertaking affidavit, till within what time they are going to clear the outstanding amounts. Land council, it is also submitted that our land council respondent submits that the outstanding amount is 15 crores.
More than 15 crores.
More than 15 crores, and so far no amount is paid. And they have given an undertaking not to take further steps, as a prayer that is sought in the writ petition itself is already, no more stands for consideration. The writ petition may be dismissed, considering the submission of the land council for the petitioner. Finally, list this matter on 3rd. If the undertaking is not filed on that day, no further adjournments will be granted, and the writ petition, final orders will be passed on the writ petition.
Bill number 27, Elangani, C for petitioner, VC Avinash.
Pay for petitioner. If I had asked the calculation, memo for calculation, it has been
Take that.
the EMI which regularly it has been paid after the demand notice also, it comes around 36 lakhs 43,737. It is EMI is continuous, my lord. We are not stopped the EMI. But there was some outstanding which they have demanded. We are settling it. We asked for it some time, but they are continuously taking the EMI.
Outstanding now.
Outstanding, total outstanding is 66 lakhs, my lord.
Total is 79 lakhs. There are 2 loan accounts. One loan account is around 66 lakh 89,000.
What is the stage of the securitization proceedings now?
My lord, the auction is
auction has been published. It
When is it?
4th of November.
4th of November.
My instructions are till now there are no bidders. We have not received any bid so far.
My lordship, here my contention is I have not defaulted in now recent payments and all. I have been continuously paying the amount. They had asked
So
for.
when was your account, when was this account declared NPA?
NPA minor. I could not.
See, it is on 4th November. Still we have time.
My
This is matter. This is
My
matter.
lordship, it is not declared. I have been continuously paying the EMI, lord.
I think he doesn't have the
No, yesterday
instructions.
the matter had come up. I need
third-
to take
third-
instructions.
My lordship,
November.
interim order may be granted, my lord. They will come for auction and I had to run door to door, my lord. This is continuously I am paying the EMI and there is substantial amount.
The auction,
My
we will
lordship.
hear it on 3rd. Yes,
He is not even he is willful.
please get
defaulter.
instructions.
I will get
Yes.
instructions.
List number 3, serial number 1, Raghavendra KN for petitioner,
For the respondent in
Bharat
this case,
Kumar.
my lord, I filed a memo for dismissal. But my lord, IA number 2 of 25 has been allowed and stay has been granted, my lord. Without considering the IA number 1, there is an inordinate delay of 915 days. And the petition,
The matter is listed for dismissal under the caption for dismissal today. Now the matter reached at the fag end of the day. List this matter tomorrow under the same caption. Yes, 2.
serial number 2,
I represent the petitioners.
hearing for the respondent in this
And,
matter.
In 2.1 today morning, I filed Wakalat, another connected matter with this.
Where were you both the other day when the matter came up?
My lord, I had appeared, my lord.
He has not appeared.
Yeah.
He has not
Lord,
served a
they have
copy
not
to me.
complied with the order of this honorable court passed on 4/6/2025, my lord.
Lordship, I have paid a 40,000 rupees till date because
Who
the,
is P. Mahesha?
I appear for.
Dismissal of appeal for non-compliance of
My
officer.
lord, only one word has to be changed in the prayer, my lord.
So why are
I'll
you
change
not
it right
changing
away.
it?
My lord, the file had already gone, my lord.
Petition is permitted to carry out the correction. This is matter on 18th of November.
Lordship, kindly direct them to give a copy of entire this petition.
I'll give it right away.
serial number 3, Bhaskar CR,
Notice to the respondent.
serial number 4,
Notice to the respondent.
Petitioners, madam.
serial number 5,
For petitioner, madam, serial number 4.
386 days delay, notice.
Cell number 5.
Well, it's for the petitioner.
Notice.
Well, I may be permitted to take hand notice in the trial.
The, no, EC is directed to issue the emergent notice. Yes, 6.
Cell
Great.
number 6.
Petition in this case. Lord Lord.
Ramesha VK.
Lord
Do that. 24 RPFC, without even notice in this, you say that the compromise talks are going on.
Yes, my lord, it is true. Because it is 10,000 awarded for the wife and 5,000 for the son.
Notice
And
to the respondent.
Cell number 7.
Lordship, I informed the other,
Javier.
appearing for the respondent, I've informed the other party,
Yes.
request for a short accommodation.
This is matter on 20th of November.
Grateful, your lordship.
9. At
Cell
the request
number
of the council
8.
respondent.
Cell number 8. Dhananjay PC. A. Madhusudan Rao.
For the respondent minutes.
Amount is not paid.
As of date, on the balance of 5,000 is payable is what my client has instructed me. He has paid before the trial court minutes, but they have not filed a memo to that effect. I have not been served with the
This is
copy.
matter on, anyhow, he's continuing to pay.
He's paid.
This is a matter on 8th of December.
Cell
Yes, no representation for the petitioner. Yes, 9.
number 9. Cell number 9.
And for the
Petitioner
petitioner.
KN.
The impugned order is at page number 36, my lord.
Hmm?
Page 36, my lord. The respondent is hereby ordered and directed to pay maintenance of rupees 10,000 per month to the petitioner number 1 from the date of the petitioner during her lifetime. My lord. And moreover, further for the
This
respond,
total 8,000.
total 18,000, my lord.
What is your income?
Income is 1 lakh, my lord.
Income is?
1 lakh.
And then what's the difficulty?
So additional 15,000 is been added in domestic violence act case. That's also mentioned. So
So it comes to 30.
now I am getting 1 lakh, my lord. From the date
Comes
of
to 33,000.
30.
It comes to 33,000 for
Yes, my
3
lord.
people.
From the
And-
date of the petition, my lord. It is in the year 2006. My salary is 29,000.
And then,
But then from the, if it is counted to the date of the petition, my salary is 29,000.
when your salary became 1 lakh?
Recently, my lord, last
How
year.
recent it is? How recent it is?
Because of pay scale has been revised. He is a government servant.
No. If not 1 lakh, what was your salary before? It can't be suddenly from 26 to 1 lakh, there can't be any hike.
No, it is in the petition is in the year 2016, my lord.
Yes.
2016 yearly, it has been accepted in the petition also. It has been come in the petition, my lord. So whatever. So as on the date of interim order was passed, also passed, my lord. So they have filed a,
Counsel for the petition submits that.
they have filed a false affidavit. That
Okay,
affidavit
they
also.
granted 18,000 to the wife and 2 children. And he's already paying another 15,000 in the domestic violence case. So this order is passed from the date of petition, that is in the year 2016, and it's difficult for the petitioner to pay the arrears.
12,000 has been paying, madam. 12,000. Interim order has been passed for 12,000.
Pay, arrears at so and so. Considering the same, there shall be stay of all further proceedings on the arrears. However, the petitioner shall continue to pay the amount as granted by the court by 5th of every succeeding month. Yes,
Notice.
notice to the respondent. Next.
Cell number 10. Syed Khalil Pasha.
Yes.
Family court passed the order, my lord. Page number 40.
Page number?
40, my lord.
Hmm.
Respondent is directed to pay maintenance in wife 5,000, my lord. And 213 each 2,000, my lord. Total
Maintenance of 5,000 per month to the petition number
total
1
9,000 order.
and 2,000 per month to each. That is 9,000.
9,000, my lord.
What is your
So,
income?
My income is, my lord, only 10,000, my lord. For electrical labor, my lord, I'm working. Electrical labor per
So
day.
you don't even get 15,000 per month. You don't even get 15,000 electrical labor.
Electrical labor, my lord. So, as our wife as a working, my lord. Is a
What is the evidence in that regard?
page number, my lord.
Can you
Page
please
number
come?
26, my lord.
Then counsel for the petition submits to the court has granted maintenance of an amount of rupees 5,000 to the wife and 2,000 each to the children. The petitioner shall continue to pay an amount of rupees 6,000 per month. And arrears also at 6,000 within 8 weeks. If any of the conditions are not complied with, the stay granted with this court stands vacated. Notice the respondent. Yes,
List number 4. For orders matter, serial number 1.
see that.
My lordship, this matter already remanded, my lordship. Eight, 11, 20, 20.
1 minute, 1 minute. Please come. A letter has been addressed by the Senior Civil Judge and ACJM Karkala seeking extension of time for disposing of MVC number 232 of 2015. It is stated that this court has disposed of the matter on 8/11/2023. Due to oversight, the matter was brought to the notice of the court on 14/8/2021. Hence, the learned judge has requested for 6 months' time. On 25/10/2025, this court has called for a report from the Registrar Judicial on what date the order is dispatched to the MSCT. The registrar has placed a report stating that the order was received by the court on 29/12/2023. When the order of this court is received by the MSCT on 29/12/2023, what was the court doing till 8/9/2020 till 4/9/2025? And the reason that is stated that due to oversight cannot be accepted. The senior civil judge and ACJM shall place a report before this court and the matter shall be disposed of expeditiously within a period of 3 months. And a report shall be placed and the report shall be received by list this matter on 20th of November. Registrar Judicial is directed to communicate this order to the learned judge. Yes, next.
Serial number 2.
Yes, my lord.
Pradeep B. For petitioner, unclaimed R7.
Steps to be taken in the notice to
Notice may be
R7
reception.
returned as unclaimed amounts to deemed service of notice. Then what about the respondent?
All
Respondents.
respondents.
Divisional Control KSRTC R6 Mr.
Dabal.
FS Zabari is directed to take notice. Yes,
Delay
admit post for final hearing, call for the DCR.
Delay of 1022 days.
Where is that?
IA is there.
IA is IA number 1 of 24 is filed to condone the delay of
1022 days.
1022 days for the reason stated delay is condoned. Admit post for final hearing.
Serial number 3.
Can be disposed.
Learn counsel for the applicant shall
It
state
can be
steps.
disposed of.
Huh?
The liability facing on the respondent number 1, my lord. Finally dispense with the notice of R2.
No,
by-
memo is filed seeking dispensation of notice to R2 dispensed with.
It can be disposed.
No. Yes,
Address to DC.
But 2022 accident,
I saw deceased, they are not pressing the notice to them. Yes.
my lord, the additional evidence is there in this case. The appellant has been terminated from the job.
Hmm.
In this case, my lord, additional evidence has to be laid. That's why.
Admit
You have
post for
produced.
final hearing, call for the TCR. Yes, next.
Delay of
How much?
38 days. I
IA
have
number
enough
1 of
24. I have enough 24.
24 delay of so and so, condoned. Admit post for final hearing, call for the TCR.
Serial
Yes,
number
next.
4.
I pay for the.
Number 4.
Notice in respect
Second
of
respond.
R1 returned as refused. amounts to deemed service of notice. I number 1/24 to condone the delay of 109 days. Condone.
It can be disposed.
Yes, ready? Yes. 109, yes.
2019 accident.
Case of death.
My lords,
No, it's a case of injury.
my senior will,
This is matter on, all these matters I'll give one date wherever they are seeking adjournment of yours. This is matters on 4th of November. Yes, 5.
Till number 5.
Respond, my lord.
Visiting.
I filed the memo for transfer of the amount, my lord. The earlier order is, my lord, is there, my lord. The amount is released to the respondents, my lord, but they are deposited the amount here, my lord. Instead of MSCT, my lord, I filed the memo for transfer the amount to the tribunal, my lord. That is in place.
I had deposited before this court, same has been accepted by this court, my lord. There is an order for release of amount. I have no objection to release of amount.
Before tribunal, my lord.
Where is that IA?
Memo, I filed the memo for.
File seeking to transfer the amount that is deposited before this court to the tribunal as already this court has permitted the respondents to withdraw the amount. The registry shall transfer the amount to the immediately to the tribunal. Yes, list after service of
Another
notice.
claimant also preferred an appeal, my lord. My lordship may post along.
List along with so and so. Yes, 6.
Till number
Await
6.
service of notice.
Of notice. 7.
So, my lord, R2, my lord, second time will take steps, my lord.
For taking steps a week's time, default order.
Till number 8.
8 also, my lordship.
It also
Non-compliance of
week's time,
subjection.
default order.
Till number 9.
Memo is filed seeking
For the second
dispensation of
respondent.
notice to R1 dispensed with.
Notice has been filed
Huh?
to R1. Memo for dispensation of notice.
That's
has been
what.
filed For R1, my lord.
It can be heard.
No, my lord, TCR is required, my lord.
Admit course of final hearing, PCR. Next 10.
10. Prithvi Vadir.
Petitioner. Your Honor, I will undertake to file wakalat for R2 and R3.
R2 and R3.
Yes, ma'am.
R3 is already served.
already-
Then
R2.
council so and so submits his instructions to file wakalat for
R2, ma'am.
R2.
Yeah.
R2. Next I number 1 of, what is 1 of 25?
Stay, I have sought for stay because now they have preferred filed contempt petition.
Oh, it is RP.
It is RP, Your Lordship. The caveat was filed by defendant number 1 alone. We were also the petitioners hearing were party to the MFA.
We hear it some other day.
Your Lordship, may I request on 4th or 5th, Your
Yes,
Lordship. if
this is
your
a matter
Lordship's
on,
convenience.
this is a matter on 6th of November.
Till
Yes,
number
next 11.
Telangana 11. Conclude, sir.
I number 1 of 24 is filed to condone the delay of 38 days. Condone. Acceptance of this, what is this?
Acceptance of wakalat filed by
Wakalat
the
for
respondent.
R1.
Yes, admit post of final hearing, call for the TCR.
Till
Yes.
number 11, 12. Till number 12.
This
Arvind is
matter,
Royal Sundaram.
the urgency in this matter, my lord, is that in the execution proceedings, delivery warrant is issued, my lord. That's the
Who are
urgency.
you owner of the vehicle?
I am, my lord, owner of the vehicle. What had happened, my lord, was that the driver of
To
the
that.
owner and driver were placed ex parte before the
Delay
MSCP
of
court.
2,469 days.
2000 days.
Notice
Before
is not
the-
served on you.
Notice is not served, my lord. Notice is served on me. I was placed ex parte. I did not contest the matter. I was placed ex parte.
Why
On
why the liability is fixed on the
on the
owner?
sole ground that the driver did not have a valid driving license. Now I've produced, my lord, a copy of the valid driving license.
Why
that
did you
I-
not contest?
I could not produce. my
So
lord.
the entire, for all these, from the date of petition till now, the interest will be borne by you. On that condition, I'll grant stay. You have, if you have contested the matter, you have placed this, whatever the driving license before the tribunal, all this couldn't have happened. Now,
Interest-
who will answer to this?
Interest, my lord, would be a sum of 65,000 and odd.
From the date of
1,20,000
petition
from
till
the-
now?
From the date of award. From the date of award, I have calculated. 1,65,200 is the decretal award.
It's a
The-
case of
the
death or
award.
injury?
Sorry, my lord.
It's a case of death or injury?
Injury.
What is the amount?
Awarded is 1,65,200. Interest would come up to 69,447.
The owner of the vehicle is in appeal before this court. Then council submits that the only ground on which the liability is fixed on the owner of the vehicle is that the driver is not having a valid driving license. He has placed a driving license. It is submitted that he has placed a driving license before this court. The place a driving license before this court. Next one, the petitioner, the appellant, having served with the notice had failed to appear before the court. And the court has passed an order now with a delay of 2,000.
900.
Where is the 2,900, 469 days delay.
416.
469 days delay. He has come before this court. The hence there shall be stay of all further proceedings on the condition that the petitioner is the appellant is liable to pay the interest for the period of 2,469 days. Then which is
Execution case number, my lord, is execution case.
I said stay of all further proceedings pursuant to
Please,
the above.
please.
Which is this Royal Sundaram who appears?
Royal Sundaram.
You appear?
Royal Sundaram. Yes.
Mr. B. Pradeep is directed to take notice on behalf of the insurance company for respondent. Notice to the, which respondent it is?
R2.
R2.
Tell
Yes.
number 13.
Great.
For the climate appeal, delay may be condoned. Both the respondents are served.
Sriram General Insurance.
Shivanagowda.
Shivanagowda is directed to take notice. I number 1025 to condone the delay of 65 days in filing. This is matter on 4th. TCR is required.
No, not necessary.
Admit post for file hearing. This is a matter on 4th. Yes, 14.
Tell number 14.
I appeal for the,
Appearing for the appellants in this case, my lord.
that there is a
Delay of 1006
inordination of
days.
delay.
You're the claimant.
I am for the appellants in this case.
That's what claimant
Claimant.
I'm saying. I number 1025 is
Please.
filed to condone the, you want to file
He
a,
is ready today, delay may be condemned.
I'll argue this matter.
Please.
not today, both of you ready, court is not ready. This is a matter on 4th, that day we'll hear and condone the delay.
My lordship, one
Yes.
submission, my lordship, my senior name will be deleted, my lordship.
Where?
On the earlier occasion, they
That
have
case.
filed their
Delete the
wakalat.
name of Mr. A. N. Krishnaswamy. Registry is directed to delete the name. X15.
Tell number 15. E. Ravishankar Shastri.
I'm for the appellant, my lord, filing dispensation of R1. Memo for filing,
Memo for
dispensation of R1.
R1. Who is R2?
R2 is Cholamandalam.
Cholamandalam.
Cholamandalam. Mr. D. Vijayakumar is directed to take notice on behalf of the respondent. Respondent number? 2. I number 1025 is filed to condone the delay of 315 days, condoned on condition. Admit post for final hearing, call for the DCR. 16.
Number 16. For admission matters.
Respondent.
PCR is required
Records
in
are
this.
required, my lord.
Huh?
Records are required, my lord. Because head injury is there, my lord.
Yes, is this matter after the TCR is received? Yes.
Tell number 17.
What about
Yes,
this?
I appeal. This matter may be have it on 4. There is some
All
discussion.
matters I'll
Let
have
us-
on 4th.
Same.
Yes.
Tell number 18.
All these matters which are adjourned today in this list, 4th list on that. Yes.
Tell number 18. Ravishankar Shastri G. P. Pradeep.
Injury, my lord, records may be necessary, my lord.
Admit post for final hearing, call for the DCR. 19.
Tell number 19. KB Nayak.
Case of death, my lord.
In both the
Ready.
cases I have filed wakalat. In both the cases I have filed wakalat.
Mrs.
7/7.
Shankar is directed to take notice on behalf of the,
R2 is already.
I have already filed wakalat
in
in both the cases.
19.1 I'm saying.
19.
19.1.
Yes. In both the cases I have filed wakalat.
You already filed.
Yes, already filed.
Submitted that Mr. Shankar Reddy has already filed wakalat for the insurance company. Next 19.1, a memo is filed seeking dispensation notice to R1, dispensed with. I number 1025 is filed to condone the delay of 11 days in filing. Condone, it can be heard or TCR is required.
Not required, my lord.
Not
Death not.
required. This also on fourth.
Please.
Yes, 20th.
Cell number 20.
My lord, I am for the appellant, my lord. It's a case of injury, my lord. It's a head-on collision, my lord. And the same has been admitted from the doctor through the
How much
discharge.
is the amount
8
granted?
lakh 22,500, my lord. I'll deposit 50%, my lord.
The land council appearing for the appellant submits that it's a head-on collusion and the court has failed to fix the contributory negligence. Considering the submission, they should stay of all for the proceeding on the condition that they shall deposit up 50% of the amount, and on such deposit within 4 weeks, and on such deposit then the claimant is at liberty to withdraw notice to the respondent.
We will deposit before the tribunal, my lord. Before the
20.
tribunal.
Yes.
Cell number 21.
Claimant's appeal,
Pages.
my lords, and for the appellant, my lords. Notice may be directed to R2, my lord.
R2 is who?
Chola,
R2 is Chola.
Chola MS.
Chola.
Cholamandla.
Chola.
Mr. H.C. Betsur is directed to take notice on behalf of the insurance company. Admit post for final hearing, call for the TCR that is dispensed with.
Please, my lord, R1.
A memo is dispensing dispensation of notice to R1 dispensed with. Yes.
Final hearing, cell number 22. Manjula.
No, all these matters will take. Yes.
Insurance company is in appeal challenging the liability in front of them.
This also on 4th. 23rd, Pradeep.
23.
Ready?
Pradeep B.
This also on 4th.
Cell number 24.
Branch manager Cholamandla. Shivanagoda appears for Cholamandla. Pradeep, Mr. Pradeep is directed to take notice on behalf of R2 in 24. Next 25.
Cell number 25.
Only notional income.
That's what we'll take it up on 4th because it's already 5 o'clock. 4th, next 26.
Cell number 26.
If court okay, who appears?
I will take.
To take. Mr. D. Vijay Kumar is directed to take notice on behalf of respondent number 3 insurance company. 27.
27, sir. Death case, my lord, claimant.
Managing Director, KSRTC.
MCTD.
Chinmay R. Kulkarni, she appears for the RTC.
R4.
No, no, my lord. R4, my lord.
So, Mr. Dabali is directed to take notice on behalf of the insurance company. Next,
Fourth, my
so
lord.
all these matters on 4th.
Please.
Cell number 28. Pradeep B.
4th, 29.
20. Cell number
Magma, who appears? You appear?
Magma.
Shivanagoda is directed to take notice on behalf of the insurance company. Wherever directed, appellant shall serve the copy of the appeal memo. This is on 4th.
Cell number 30.
Serial number 30, I appear for that.
Who is this?
4 digit.
Go
No,
digit.
not go digit. HDFC Ergo.
HDFC Ergo.
Yes.
Mr.
Angli
H.S.
type.
Lingaraju
Lingaraj.
is directed to take notice. Serve the papers on him. This also on 4th.
Cell number
31.
31.
I appear for
My lordship is a 17 years
Case of
old
death, I am ready.
minor death, my lordship. So
Death of 17-year, my lord. The tribunal is followed by the Kishan Gopal case.
We'll have it on 4th. 4th.
Cell number
Next.
32.
Mr. Dabali, Mr. Dabali is directed to take
Tata
notice.
AAG, ma'am.
Where is it?
Tata AAG.
Tata AAG who appears for R2, Mr. Dabali. Tata.
R2 only. Tata AAG.
Oh, this divisional manager Tata AAG.
Yes.
Mr. So-and-so. Mulkand is directed to take notice on behalf of the insurance company. Yes, next 33.
33.
This also on 4th, that this 4th.
Cell number
34,
34.
4th.
Appellant.
35. 35.
For the respondent, you have.
35 on 4th.
34, my lord.
36.
I am for appellant.
Yes, 4, 37,
37.
Paper petition.
4, 38 also on 4,
Cell number 39.
Second respondent.
4,
Cell number 40.
44,
Cell number 41.
same day,
42.
Second respondent, my lord.
42,
Second respondent.
yes, 4th,
Cell number 43.
4th,
Cell number 44.
I am for the appellant, my lordship.
4,
Sale number
45,
45,
Appellate, my
United-
lord. United
45.
Indian.
United India Insurance R2.
Mr. Krishna Kishore S. is directed to take notice on behalf of the insurance company. Yes, 4th.
Sale number 46,
46, my lord, yesterday, my lord, dictated, my lord, CR Ravishankar advocate.
The same order he is saying.
Yes.
Tomorrow for order, for judgment, for dictating the order, something you, on that caption.
Lordship
Yes.
has dictated, my lord.
Dictated, just finally, like, we'll do it tomorrow.
47,
My lordship, 47, my lordship, claimants also prefer an appeal, my lordship. Is the insurance company appeal? Claimants
List
also
along
prefer.
with, write it on.
7733 of
List
2025.
along with so and so on 11th of November. In 48,
number 48,
My oblige, my lordship.
have you deposited the amount?
Deposited.
When counsel for the appellant submits the amount is deposited. Yes. 49, what is this?
number 49,
This, yesterday your lordship served, my lords. Simple injury case, my lords.
Tomorrow, list is tomorrow. Yes.
sale number, list number 5. For orders matter, sale number 1.
Memo for acceptance of paper publication in respect of R4.
Yes, ma'am.
Accepted. R4, R5, accepted. Notice to R4 and R5 held sufficient. Next, what is this IA number 1/22 for impleading? Implead to whom?
Notice.
Huh? No. Hmm. Yes, we'll see this later.
Sale number
Yes,
2.
ma'am.
This case IFA for appellant.
I
Delay of
number
16
1/24 to condone the delay of 877 days in filing. Who
16
appears
days,
for
my
this?
lord. 16 days, my lord.
R1.
Serial number 2, my lord.
Oh, sorry, 2. Memo is filed seeking dispensation of notice to R1, dispensed with. Next, I 1/24, 16 days condoned. Next 3,
Sale number.
admit post final.
Sale number 3.
For the appellant, madam.
Notice. as well. They have to.
I have paid the cost and I agree. I've taken the steps, madam.
Notice, they have to furnish the process, ma'am. Private persons.
All private parties.
Yes.
Needful shall be done within a week default order. 4.
Number 4.
Some costs are there. Have
I
you
paid, I
paid?
paid it.
Paid?
Paid it.
It is submitted that as per the order dated, order of the court, he has paid costs of rupees 500 to the High Court Advocates Library Fund. Next 4.
Sale number 4.
My lord, he said that he will give claim petition copy next week, my lord. Chetan did it.
Week's time,
Sale number 5.
a week's time to do the needful, yes.
5. Sanjay Gowda NR.
I have 1/24, 146 days delay, condoned on condition, admit final hearing TCR. Next 6,
Tepes Dabali.
Appear for the appellant, my lord. Second response, my lord.
as per the postal shara,
Unclaimed.
notice to R4, returned as unclaimed amounts to deemed service of notice. I number 1/25 to condone the delay of 128 days, condoned.
That is,
Involvement of three vehicles, murder.
Hmm?
Involvement of 3 vehicles.
Oh, you want to implead them?
I implead.
This matter tomorrow,
Yeah.
6 tomorrow, day after tomorrow.
there.
Yes, 7.
Sale number 7.
For the appellant, your lordship, there's a connected matter in this case. Copy I've already served long back. The connected matter is 4217 of 25, your lordship.
Just along with that.
Sale number 8. Sri Harsha AK.
Appearing for the appellant, my lord, filing a memo of dispensation for R3.
R3. A memo is filed seeking dispensation of notice to R3, dispensed with. Then what about, only R3 is pending?
R3, sir.
I number 1/25 to condone the delay of 225 days, condoned on condition. Yes, admit post of final hearing. Call
9.
for TCR.
Srikant Patil K.
For appellant, my lord.
Memo is filed seeking dispensation to R1 and R2, dispensed with. 1/25, 768 days, condoned on condition. Yes, next 10.
Sale number 10. Furnishing of
Admit maybe. Much.
notice to order.
10, a week's time default order.
Sale number 11.
list after service of notice to respondent.
Cell number 12, Pradeep B.
R2,
R2.
Text of
a week's time default order.
Cell number 13,
What is this?
Milord,
Advocate for appellant has not filed
Future-
the rectified copy of
That's
the
my
judge.
lord's future generally insurance company limited. I has left out in the judgment. That is the objection, my lord.
Yes, next 13.
13, D. Vijay Kumar.
It is, no, about the issuance of the process R2 and R2.
Within a week.
Paid or will pay?
I will pay it.
A week's time default order. It is submitted that the amount is deposited. Next 14.
Cell number 14,
Appearing for the appellant this month.
Mesh.
R1 may be dispensed.
Memo is filed. Take that. Dispensation of notice to
R1.
R1. Yes, admit post for final hearing. Call for the TCR.
Oblige.
Cell number 15,
My lord, in this case, my lord, in the first case, my lord, I have accepted the notice for R1, my lord. And second case, my lord, wrongly connected the MFM, my lord.
15.1 is not connected with it.
Not connected with, my lord. But
Uh,
15 point,
Mr. K. Vishwanatha. your-
M. Vishwanathan, ma'am.
What is your name?
P. Mahadeva Swami.
So and so. Submits that he has instructions to appear on behalf of respondent number
1, my lord.
1.
And
Between D-Link.
Dealing. And I have filed one more appeal,
There
my
is no
lord.
connection between 15 and 15.1. Registry is directed to D-Link 15.1 from.
R2 take notice, my lord. United India.
Who? United India?
I will take it. I will take it.
The dealing matter.
I take.
In the D-Link.
Earlier notice
My-
was issued,
my
my
lord,
lord.
and
Anyway, we'll see once it comes back.
my lord,
again.
climate has filed one more
Huh?
appeal. 66.
This 15, list along with so and so.
66.
Yes, 16.
cell number 16, D.
16
Pradeep.
connected appeal may be posted. 7703.
In respect of R3 and R4, postal sheriff party expired.
I will verify.
The appellant shall take steps within 4 weeks. Default order,
6 weeks.
6 weeks default order. 17.
Post along with,
Post along with so and so.
Sorry, my lord.
17,
Against respondent number 3 and 4. my lord.
Against respondent number, so
10, 4.
default order, the appeal shall be stand dismissed against 3 and 4.
7703 has to be posted.
17 for R2.
I'm appealing for
It can be
the
disposed.
appellant file a dispensation memo for respondent
be
number 1.
disposed.
Memo is filed seeking dispensation of notice to R1 dispensed with I number 1025 to condone the delay of 382 days.
Without interest.
Condoned on condition. List this matter on 4th. Admit post for final hearing. Call for the TCR. 18.
18 Kotak Mahindra Millet, BC 7 Nagoda may be directed.
This is your Nagore is directed to take notice on behalf of the
A
respondent.
delay of 97 days.
I number 1 of 25, 97 days condoned. Yes, next.
This is also on 411.
No. Yes. 19.
Cell number 19,
For appellant my lord. DPF payment.
I have not received the copy.
38 rupees deficit.
Copy serve ಮಾಡಿ.
No, what about the process?
Pay ಮಾಡಿದ್ವಿ. Pay ಮಾಡಿದ್ವಿ.
It is submitted that the needful is done. Let's just matter to service of notice.
Cell number 20,
Memo is filed in this 19. Admit post of final hearing. Call for the TCR. 20.
In 20 you actually by appeal for United India Insurance Company, second respondent.
Papers are not served.
Not required, no, they are served, your lordship. It may kindly be posted on 4th because only on quantum, only one point needs to be considered by this one.
Memo is filed seeking dispensation of notice to R1 dispense with. Let's just matter on 4th.
cell number
21.
21,
Memo is filed same seeking dispensation of admit post of final hearing TCR. All these matters on 4th, 20 and 21.
cell number
Next 22.
22, my lord, we are, insurance company has already deposited the amount 50% on 9/10/2025.
PF
PF I'll pay within a week.
within a week, a default order. It is submitted that already amount is deposited.
Much,
23,
much.
I am for appellant, my lord. Behalf of Ravi Subbiani, I am representing, my lord. Today steps has been taken, my lord.
It is
50% award
submitted
also
that
we have
the needful is
deposited.
done, and they have deposited the 50% of the award amount. 24.
cell number 24, Ajay
2
Prabhu.
weeks time, my lord. It is a statutory deposit which I have to make, my lord. Statutory deposit, ECA matter, my lord. I have to make it in, I will make it in 2 weeks. My lord.
Why, on without filing, without the statutory deposit, it will be numbered.
No, my lord, I have filed, initially I filed application for dispense, my lord, to deposit before the honorable court, my lord. That application was rejected and directed to deposit in trial court. Lord,
Amount shall be submitted that within 2 weeks they'll deposit the amount.
please,
The appellant will deposit the amount list after 2 weeks. Case 25.
Number 25.
I number 1 of 24 to condone the delay of 573 days condoned on condition. Admit final hearing. Fourth,
Exoneration against the company.
25.
25.
After, not on fourth, some other day. 26.
Till number 26.
I number 1 of 24 to
I
condone the
appeared
delay
for
of
appellant,
566 days condoned on condition.
566 days. condoned.
Yes, next for 27.
Till number 27.
67 days.
Maybe condone.
Condoned.
TCR is required, my lord.
Fourth,
TCR is required, my lords.
admit call for the TCR.
Till number 28.
Respondent, my lord.
I number 1 of 24, 38 days.
My lords, I would
condoned.
like to make a submission with respect that, my lords, on the previous date, my interim order came to be vacated on the ground that I had not deposited. But however, I had not filed the proof of deposit, but I had deposited within 4 weeks, my lord, and I have filed it now, my lords.
When is this order passed?
It is passed last month, my lords, on 22/9, my lords. I had deposited in March itself, in April.
Land counsel for the petitioner submits that he has deposited the amount as the same was not represented before the court.
Please, my lords.
The court had
Vacated
a
the,
coordinate bench of this court has vacated the order on
on 22/9, my lords. 22/9, 9/25.
22,
9/25.
22/9/25, considering the submission, the order of stay granted by this court dated by the coordinate bench dated
18/3/25.
is restored.
Please, my lord, much obliged.
Till number 29. All to
In this,
Oriental
I number 1 of 24 to condone the delay of 38 days. In the 28, condone admit post of final hearing court for the TCR. 29,
29. R3 is Oriental Insurance.
R3 Oriental. Who appears for Oriental?
I appear.
Mr.
Ashok and Patil.
Ashok and Patil is directed to take notice on behalf of the insurance company. I number 1 of 24. Who are the other respondents?
Notice is not yet, other
Ah.
private persons. Notice
The
has-
notice to, this is respondent number
3.
3, notice to the other respondents. Then 29.1, memo is filed seeking dispensation of notice to R2 to R5. Dispensed with. Next, 30,
Till number 30.
Appearing for responding to, my lord.
memo
Maybe-
is filed seeking dispensation of notice to R1 dispensed with.
Responding to, delay may be condoned.
IA number 1 of 24 to condone the delay of 150 days condoned on condition. Admit file hearing TCR. Next, 31.
31.
Appear for appellate, my lord. Case of a death, it may be disposed of, my lord. Next,
We'll have it on 4.
please, my lord,
I
please.
number 1 of 25 to condone the delay of 432 days in filing condoned on condition. This matter on 4th. Admit post of final hearing TCR.
Till number 32.
They appear for the appellant. There is a delay of
Not
308.
308 days condoned on condition. Have you served the papers on Mr. Dabali?
Not double, Holla appears. Holla
Oh,
is-
Waka, you know, Holla is appearing.
Yes,
Have you served on that?
yes.
Admit final hearing TCR.
Till number 30, for admission 33. R Shashidhara.
This may not company also
The
prepared an
legal
appeal.
manager IFCO Tokyo. You appear, Pradeep?
33, I have to file wakala.
Pradeep is directed to take notice on behalf of the respondents.
Till
My
number
lord, 4357 of 2024, it has to be connected along with.
4-3? No, it's already connected. 33, 33.1.
4276 connected.
It's already connected. 4357. No. 33 is 4357.
Please,
33.1 is 4276. Both are there.
please.
So, Pradeep is directed to take notice on behalf of R3 who has filed the wakalat in the other connected matter.
My lord, one small submission with respect to list 3 serial number 2, my lord. My lord, matter may kindly be taken up on 17th instead of 18th.
Look at it. Whatever.
Some inconvenience.
Whatever he is saying, no?
17th, 17/11.
Yes.
Obliged.
Which one? These guidelines also keep it.
ಯಾವ್ದು? List 3.
ಇದು ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕಂತ ಇದು
ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಅವರೇ,
ಹೇಳಿ ಸರ್.
ಆ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ರು ಮೇಡಮ್ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಅದು ಏನೋ ಇದನ್ನ 4th ಕೊಟ್ಟಿದಾರ, July 4th, ಇದು
ಯಾವ
November
ಲಿಸ್ಟ್
4th,
ಯಾವ
4th
ಲಿಸ್ಟ್
ಲಿಸ್ಟ್ ನಂಬರ್ 4.
ಲಿಸ್ಟ್ ನಂಬರ್ 433 ನಾ?
ಹಾ
Serial number 46 ಕಳಿಸ್ತೀರಾ? District matter for judgment ಅಂತ. 46 and 49.
33 ನಾ ಸರ್?
ಹಾ 33 ಮೇಡಮ್, KT ಮಧು.
ಅದೇ ಗಿಟಾರ್.
ಹೌದು ಹೌದು.
ಅದು 4/11 ಡೇಟ್ ಹೋಗಿದೆ.
ಹಾ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ ಮಾತ್ರ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ರಿಜಿಸ್ಟರ್ WP 3323
ನಾಳೆ ಡೇಟ್ ಅಲ್ಲಿ ನಾಡಿದ್ದು ಇದೆಯಾ ಅಲ್ಲಿ?
In spite of your last given the date, we couldn't take the answer because the file is the evening. ಯಾಕಂದ್ರೆ ನೀವೆಲ್ಲ ಈಗ ಸಾಯಂಕಾಲ ಕಳಿಸಿದ ಫೈಲ್ ಎಲ್ಲ ಅಲ್ಲಿ ಇರುತ್ತೆ ಆ ಆನ್ಸರ್ ರೆಡಿ ಮಾಡಿ ಅದಕ್ಕೆ ನೋಡ್ಬಿಡಿ ಎಲ್ಲ ಕ್ಷಣಕ್ಕೂ ಹೇಳಿದ್ರಿ ಆನ್ಸರ್ ಅಂತ ಇದ್ದು ಫೈಲ್ ಬೇಕು ಹೋಗ್ಬೇಕು ಈಗ ಇನ್ನೊಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಅವತ್ತು ಅದು ಮತ್ತೆ ನೋಟಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆನ್ಸರ್ ನಮ್ಮ ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ಇಷ್ಟೇ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಏನ್ ನಂಬರ್ ಹೇಳೋ 65 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳೋ 8 8 ಅಲ್ಲ 8 ಆಗಬೇಕು ಮುಗಿದು ಬರುತ್ತೆ ಇದೆ ಮತ್ತೆ ನೀನೇನಪ್ಪ ಪಿಎಸ್ ಕೇಳೋ ಈಗ ನಮ್ಮ ಜ್ಯೂರಿಡಿಕ್ಷನ್ ಏನು ತಿಳ್ಕೊಂಡು ಈಗ ನಾವು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳೋದಿಲ್ಲ ಈಗ ಅಕೌಂಟ್ ಪ್ರತಿ ದಿನ ಕಷ್ಟ ಇದೆ ನಾನು ಗೊತ್ತಾಯ್ತಾ ಈ ತರ ಎಲ್ಲ ಒಬ್ಬೆಲ್ಲ ಸಿಕ್ಕರೆ ನಾವು ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಈಗ ಅವರು ಒಂದ್ಸತಿ ಡೈರೆಕ್ಷನ್ ಅಲ್ಲಿಂದ ಬಂದಿದೆ ಅಂತಂದ್ರೆ they will not listen to the direction of us ಪ್ರತಿ ದಿನ ಬರ್ತಾ ಇದೆ ಗೊತ್ತಲ್ಲ ಕಲಿಸ್ಕೊತಾ ಇದೆ ಏನಾದ್ರು ಮಾಡ್ಲಿ ನಮ್ಗೇನಾಗ್ಬೇಕು ನೀನೇನೋ ಅಷ್ಟೇ ನಿಂತ್ರಿಸ್ಕಪ್ಪ